Scott, co-director of the Boyden Gray Center for the Study of the Administrative State, and along with my co-director Adam White, we are thrilled to welcome everybody here this morning for our symposium co-hosted by the George Mason Law Review, who's been amazing, very energetic and great students, one of whom you'll hear from here in a moment. But for our symposium today on Chevron on Trial, the Supreme Court and the future of agency, authority, and expertise, which is a very big issue. It's been a big issue for decades, but even more so this term, because the Supreme Court just in the last few days has taken up a second case this coming term where it will actually re-examine, per the request of some of the litigators before it, the question of Chevron deference and how agency action should be reviewed by the judiciary. And we've got a lot of panels with some really top-notch scholars lined up today to discuss a lot of these issues. Someone yesterday, in describing this panel to me, or the set of panels, referred to it as the Super Bowl of scholars on the relevant issues. So I love that analogy. I think it's great. We've got folks who are scholars affiliated with Yale, Columbia, Michigan, UVA, Vanderbilt, Chicago, Texas A&M, GW, Georgetown, and our own Professor Caroline Seacott from Scalia Law School, who is also the advisor of the Law Review. And so we're really glad to have a lot of participation today with the Law Review. Also, interestingly, the lead litigant for the party challenging the Chevron Deference Doctrine and Loper Bright Enterprises is former Solicitor General Paul Clement, whom the Gray Center is proud to call its own distinguished practitioner in residence, or just, I should say this, the formal name, Justice Story Distinguished Practitioner in Residence at the Law School's Gray Center. And then our Student Separation of Powers Clinic filed an amicus brief on behalf of a number of members of Congress in the case. So a lot of connections here today on the practical side and also on the scholarly side. And also want to say a quick shout out to our Gray Center folks, Jace Lincoln, Raven Perry, Tyler Carter, David Wu, who have done yeoman's work in getting us ready for today. So without further ado, I'm going to turn us over for just a minute to the Law Review Editor-in-Chief for Volume 31, John Michelli, who's going to welcome you all on behalf of the Law Review. And then we'll get started with our first panel.
Thank you, Professor. Yes, good morning. Thank you all so much for being here. I just got to say, as an EIC, I feel like I have won the symposium lottery, not only because we got to partner with a great academic center like the Gray Center, but because we got to do it during the year when the court decided to take up Chevron deference. So it really feels like the stars have aligned for us. And yes, I just have a couple of thank yous to give out. First and foremost to Megan Dill, sitting right over there. Megan is our symposium editor this year for the Law Review, and she's really been the entire half of the equation for us so far in getting this set up. I know a lot of thoughtfulness went in on her part into seeking out a diverse array of scholars today, so if you, which of course the Gray Center was receptive to. So if you have an opportunity to introduce yourself and say hi, please do. And then of course, a special thank you to Professor Mascott and the Gray Center. We would not be here literally in the Mayflower Hotel without their support. And we would not have access to the really great lineup of scholars that she mentioned without the work that she and Adam White have put into building up the Gray Center as a place where serious scholarship gets done. I know it accrues to the benefit of the Law Review today. I know it accrues to the benefit of the law school, and I'm hoping ultimately it accrues to the benefit of the Supreme Court as they grapple with the question presented. So thank you once again, Professor.
And with that, I'll turn us over to Judge Paul Mady from the U.S. Court of Appeals for the Third Circuit to introduce our first set of panelists. Thank you so much, Judge.
Thank you so much, Professor. Thanks to George Mason and the Center for hosting this exciting discussion. For many, I imagine, exciting doesn't naturally precede administrative law. We, of course, know better. It is always like that with the important stuff in the law and in life, isn't it? Most miss what is compelling, the ideas and the images that spring from imagination into reality. That's why we have nerds like us to see the next cool thing before they do. Take comic books. When I was reading them back in 1984, I knew how exciting the stories were, but I can assure you it didn't do anything for my popularity. Comic book kids like me, well, we obsessed over the minutia, labored over hypothetical battles between endlessly opposed powers, debated tirelessly about where the story would go next. So decades later, I was delighted to discover I could relive my childhood through Chevron. When it arrived in the 1980s, Chevron was also not very cool, but it caught the eyes of the fanboys and girls who dove into its pages, reading and rereading for hints, for clues, for questions. It took a bit, but eventually everyone caught on and joined the fun. And we got a galaxy-spanning story with spin-offs worthy of a Hollywood franchise. Thrill to Meade Step Zero, jeer the darkness of Brand X and Talk America. Grip your chair as Keyser adds 5 new factors to our deference, and then wonder if it's really sinister Skidmore back from beyond. Just like comic books. In the 2010s, Chevron became the Marvel summer blockbuster of law school cases. And just like the great movies, say Iron Man through Black Panther, we consumed it endlessly, always hungry for more. And then, a few years later, everybody kind of just moved on from Marvel, right? The Eternals, Wakanda Forever, some Ant-Man sequel, yawn. And wouldn't you know it, the same thing sort of happened to Chevron. In what seemed like the blink of an eye, the most spectacular law school franchise ever just started to vanish. Sure, the studio tried to keep things going, resurrecting old classics that, at least on the storyboard, sounded pretty good. Marvel trotted out Doctor Strange and Shang-Chi, thoughtful, earnest, philosophical. They sought to ground the comic book world in something more serious. The true believers, they loved it, but it really never caught on very broadly. Sounds a lot like Gundy, the 2019 reimagination of that long-lost hero, the non-delegation doctrine. Gundy delivered a satisfying punch that seemed poised to relaunch a long-dormant franchise last seen during a quick one-year run in 1935, but despite the rave reviews, the sequel never imagined. And so the decade closed, and with it, much hope for our hero, whose powers, long separated, seemed forever diminished. But then, after the credits rolled and we were ready to leave the theater dejected, the movie restarted. And striding onto the screen appeared a creature of infinite potential, a character so major that it forces us to question everything we thought we knew about delegation and deference. And just before the lights went out, our mouths dropped as the major questions doctrine took the hands of non-delegation to create perhaps the most dynamic duo ever. Where will the writers of this saga take us next? What will be revealed in Looper and Relentless? And now it really does sound like I'm making up comic book titles. We need not wait for next summer, because we are fortunate to have the insights of 3 exceptional leaders to tackle these topics. Beginning with Kent Barnett, the Associate Dean of Academic Affairs and J. Alston Hosh Professor of Law at the University of Georgia. Professor Barnett is a former trial and appellate litigator and now prolific scholar, co-author of a leading administrative law casebook, former chair of the administrative law section of the AALS, and an appointed public member of the Administrative Conference of the United States. We're also joined by Professor Christopher Walker, professor of law at the University of Michigan. His publications have appeared in law review articles across the country, and his book, Constraining Bureaucracy Beyond Judicial Review, is forthcoming from Cambridge University. He worked in all 3 branches of the federal government, taught for a decade at Ohio State, serves as a senior fellow of the Administrative Conference of the United States, and a past chair of the ABA section of administrative law. You can find him blogging at the Essential Notice and Comment. Finally, and next to me, is Thomas Merrill, the Charles Evan Hughes Professor of Law at Columbia. He is one of the most cited legal scholars in the United States and regularly pens amicus briefs on administrative interpretation. He served as Deputy Solicitor General, counsel at Sidley and Austin, and as a co-reporter for the ALI's Restatement Fourth of Property. If all of that isn't enough, he has, as the kids like to say, literally written the book on Chevron. Each of our panelists will share their insights this morning, and then we'll move to an open discussion after what I'm sure will be a lively exchange. We'll make sure to reserve ample time for your questions. And so with that, I'll turn it over to Professor Barnett.
Thank you so much, Judge Mady. That may be the best introduction that I've ever had for a panel. I really enjoyed those remarks and the framing of Chevron. Chris and I had a contribution that we entitled Chevron and Stare Decisis for this, and it takes many of the arguments that we used in our amicus brief that we filed in support of neither party in Loper-Bright. And as most of you know, Loper-Bright is considering whether or not we should overturn Chevron deference, that is, whether or not courts should defer to an agency's reasonable interpretation of a statute that is ambiguous that the agency administers. And I would think it's fair to say that Chris and I were both fairly agnostic about Chevron, kind of at the start of our careers. And then we began doing research separately and together with it. And based on that research and some of the development in the court's doctrine, we came around to the idea that Chevron, as a matter of stare decisis, should stay in place. So the court should not overturn it. And I'll begin by talking through some of those stare decisis arguments, and then Chris is going to turn to some of what we think are the more hidden or the less noticed types of rule of law values that Chevron promotes that we uncovered in our research. So I'll begin this framing in an important place that I think gets overlooked with Loper-Bright. That is, this is a question about whether we are overturning a doctrine, and what's going to be critical there is how do we think about stare decisis? And what is really important here is that the court has essentially told us exactly how to think about stare decisis for something exactly like Chevron. They did this in a case called Kaiser v. Wilkie, which concerned really Chevron's kissing cousin, our deference, which is a form of deference where one defers to the reasonable agency interpretations of ambiguous regulations as opposed to statutes. And upholding our deference, the court said we apply already super strong statutory stare decisis. Indeed, it has enhanced force. It's super duper statutory stare decisis that we apply to something like this, which is deference to an executive's legal interpretation, because of three factors that all applied in our and also apply here with Chevron. First, that the court would not be overruling a single case, but instead a long line of precedents. Well, depending on how you think about this, we're either overruling a line of some form of reasonableness review going back at least until the 1940s. We could take it back to the founding, where depending on where one wants to start, or at least until 1984. And since then, we have had several other cases that have developed from it that have given more dimension to Chevron and assumed its validity, whether we're thinking about Meade, whether we're thinking about Christensen, whether we're thinking about the City of Arlington, Brand X. All of these cases that have created, as to the second factor, a significant place that pervades, in the court's words, the whole corpus of administrative law. Well, just like our deference, which applies generally to all agencies' actions with some limited exceptions, Chevron does the same thing. Finally, the court asked whether or not the doctrine would allow relitigation of any decision based on its framework. And here it would with certain decisions. It would be those decisions where the court found that an agency's interpretation was reasonable under step 2 of Chevron when when Congress had not clearly provided its intent in the statute. That is the same thing that existed in our deference too, with that same group of cases that would have to be subject to relitigation. So we already have this place where we've got this super strong form of stare decisis. Well, of course, stare decisis can still be overcome in certain instances. One could be if the court just got Chevron wrong as a matter of theory. And the key theory that the Chevron court pushed was one of delegated authority to interpret. And so what Chevron did was give interpretive primacy to agencies to interpret ambiguous provisions or gaps in a statute. And there was quite a bit of debate about whether this was a fictional presumption that was created. And I had done some work several years ago where I tried to look at instances in which Congress had spoken on notions of judicial deference. It very rarely does so, and I give that as a significant caveat. The Congress doesn't actually talk about deference really writ large or in smaller areas very often, but it does do so. And when I looked at those cases, it all indicated that Congress was comfortable with Chevron as the appropriate theory. The key area where you could look at this is first, the fact that Congress has refused to abrogate Chevron numerous times, both before Chevron was even decided in what was referred to as the bumper amendments from a senator from Arkansas, all the way through to 2017, 2019, and even 2023. It still hasn't passed, even after going through the House. And those recent dates are important because the court, when talking about stare decisis, found it relevant, as with our deference, that even after the court had determined that there were questions about the underlying doctrine, Congress had refused to act. Well, it's the exact same thing with Chevron. Congress also relies upon the presumption of Chevron. So if we turn to one of its most significant acts in recent memory, the Dodd-Frank Wall Street Reform Act, there's a striking provision in that act where for the OCC, the Office of the Comptroller of the Currency, they can make certain preemption decisions over state consumer financial protection laws. And Congress did something new there that it hadn't done before. It said that courts were to review those preemption decisions under the Skidmore factors, and it listed the Skidmore factors. It then had another provision that was like a savings clause that said that the OCC's preemption ruling does not, quote, affect the doctrine that a court may afford the OCC's interpretations. Well, what is that deference that a court may afford? Well, if you turn to the Senate report that was provided, the Senate was clear that it understood that Chevron deference was the default, and it wanted Chevron to apply to all of the other decisions by the OCC. Indeed, there were dissenters to this section of Dodd-Frank. There were Republican senators that dissented. But you know what their dissent was? That Chevron should have applied to everything, that we shouldn't have used Skidmore for it. They understood that as the better rule to move forward with congressional drafting. Also in Dodd-Frank, we see even a more reticulated form of this. Congress appeared aware of a long simmering debate about whether agencies should get Chevron deference when more than one agency interprets a statute, or has administrative authority over a statute. And Congress once again did something really interesting. It created the Consumer Financial Protection Bureau. And after it did that, it started reallocating power over consumer protection statutes. It gave some instances where it said this one agency should be treated as if it were the only administering agency. Why would it do that? Because only one agency would get Chevron deference. Other times it says, treat every one of those agencies as if it's the administering agency. Why? So all of them are eligible for Chevron deference. So you have that sitting there of Congress that appears aware that Chevron is the default rule, has adopted it, and has refused to abrogate it. We might say it's better instead to look at the time that the APA was enacted, 1946. And ultimately, where Chris and I came down on this, is that there's no clear answer as to what Congress in 1946 thought about deference. And one of the participants today, Professor Aditya Bamzai, I'm sure will go into some more detail on this, but he has an argument that the APA is best read to provide a de novo form of review, and indeed that's what the drafters were trying to do. But that has been certainly argued against, if not rebutted, by Professors Ron Levin and Cass Sunstein, who look at this and say that the evidence is much more muddled. If anything, it's stronger to suggest that Congress was intending deference to continue. And indeed, there is a dog that didn't bark problem in that the court kept using deference after the APA, and no one had any strong opposition to it. And forms of deference, although somewhat inconsistently until Chevron, continued to pervade administrative law for the coming decades. The final reason that stare decisis may not be terribly significant could be if Chevron violates the Constitution, of course. And there are two key arguments that are being made. One, an Article 1 argument, a second, an Article 3 argument, and I'll very quickly deal with both of these. The Article 1 argument is that Chevron encourages a broader delegation to agencies and creates a non-delegation problem. But if there is a non-delegation problem, it's not Chevron that's causing it, it's the delegation of too much power. And one can patrol those boundaries by looking for an intelligible principle. Or if one wants to take something that's closer to the Gorsuchian view, that we will look to see whether Congress has indeed decided important subjects or created general provisions for agencies. But even under a strict reading of the non-delegation doctrine, going back to Chief Justice Marshall, agencies have the power to, quote, fill up the details. Well, Chevron allows all of this. As long as we have a standard that is sufficient under the non-delegation doctrine, and Congress has not been clear with its actual intent, then Congress has allowed the agencies to fill up those details. Finally, we have an Article 3 argument. And this is the one I think that is the most underdeveloped, but we have seen some purchase on the Supreme Court with this argument. And the argument is fairly simple, that Chevron violates the idea that the courts say what the law is, a la Marbury versus Madison. And that's really it. We cite one case and we move on. But Article 3 is so much more complex than just Marbury versus Madison. For instance, we've had some form of reasonableness review going back to the founding. Indeed, even in Marbury itself, the court refused to grant mandamus on matters that fell within the discretion of the executive, instead only granting a remedy to something that was ministerial. Well, if you think about that, that's much like Chevron. If Congress has required something of Congress, then Congress has to do that thing. But if Congress hasn't done that, then the executive is within a discretionary space. For those who argue that there's an Article 3 problem with Chevron, there has to be much more than just citing Marbury. You have to come up with the theory for why, for instance, mandamus was appropriate at that point, but other forms of review aren't appropriate, especially when Chevron's remedies look a bit like mandamus, or they're at least like injunctive relief, a set-aside relief under the APA. Why is that different than what we saw with mandamus? The final way to think about this, too, is there is an entire world of Article 3 doctrine that's quite complex, but one key thing it does is that it asks over and over in Article 3 whether or not Congress has a greater power. If it has a greater power, then it has a lesser power. It uses greater and lesser power reasoning. Well, one of the greater powers Congress has that the court has never had a categorical objection to is that it can stop review of agency actions. In other words, create no review provisions. Well, if you can have no review, it's really hard to see how creating reasonableness review, which is significantly broader, creates an Article 3 issue. And that's especially true when Congress in other areas does not permit plenary review of federal courts, such as with the review of state judgments in habeas or arbitration decisions, even those that are required under a statutory scheme. So we take all of those together, these arguments about intent, whether the more recent Congress, the Congress of the APA, and the constitutional arguments, and ultimately say that stare decisis strongly supports Chevron deference continued existence.
Thank you, Professor. Professor Walker, I think we're going to continue the conversation and build on those remarks, or I thought we were going to...
Tom?
Oh, I don't really care.
What? You're going to go right on stare decisis? Or? Yeah. Sure, yeah, you can go first.
Excellent.
My thanks for the invitation to the George Mason folks and the Gray Center, and thanks to you, Judge Maddie, for explaining my Chevron addiction that I've had. Sort of analogous to a comic book addiction. It's better than some addictions, I guess. But I had thought when I wrote the book in 2022 that I was going to be cured of this. I didn't have to join Chevron Professors Anonymous or something like that, but it looks like that was premature. Let me start with a few words about the decision a couple of weeks ago by the Supreme Court to grant cert in this case called Relentless versus Department of Commerce. My colleague, Philip Hamburger at Columbia, was one of the lawyers through the new Civil Liberties Alliance that represents the petitioner in Relentless. And I said, hey, Philip, what's going on here? Why are you jumping on board with the Loper-Bright issue in this case? And he said, it's very simple. He said, our client, who owns a herring fishing boat and was very upset by this regulation by the Commerce Department, is eager to gain relief, and so we wanted to track the questions presented in Loper-Bright to make sure that whatever happened in that case also applies to our client. So no big strategic objective here on the part of the petitioners by filing that second case. We had some amusing discussion at dinner last night about which of these two cases, Loper-Bright or Relentless, will be the caption case, assuming that they're consolidated together for argument and decision. I hope the report of decisions does not make it Relentless, because you can imagine all the jokes and all the quirky, cutesy law review article titles about the Relentless doctrine, you know. So we'll see what happens there. The interesting question is why the court granted Relentless as opposed to simply holding it to dispose of in light of Loper-Bright. The most obvious explanation is that the court just was being courteous to Justice Jackson, who was recused from Loper-Bright, but not from Relentless comes out of the First Circuit rather than the D.C. Circuit. So that's the simple explanation, probably the best explanation. A more interesting, somewhat strategic explanation would be that there's some segment of the court, maybe Chief Justice Roberts, that would like to reach a kind of intermediate position here, not overruling Chevron, but tweaking it. And he may think he needs some more votes to reach that outcome, and Justice Jackson might be one of those votes. So that's a possibility. Another thing that's been raised here is, how do we know the Supreme Court's not just going to duck this question again? Some of you may know that the court has not itself applied the Chevron doctrine in its classic form since 2016. And in more recent years, they haven't mentioned Chevron at all. In the 2022 year, there were something like 7 cases in which the parties vigorously pressed on the court the need to modify or overturn the Chevron doctrine. And Chevron hardly appears at all in any of the opinions that the court rendered that year. The sort of Chevron is treated like the crazy uncle in the attic that no one wants to mention. So is the court just going to do that again? Decide Loper-Bright / Relentless on the merits, de novo, pretending that the agency doesn't exist, and kick the can down the road one more time? I think it's unlikely. The court has, as was mentioned in the review of comic books, recently articulated the major questions doctrine. There's no way you can construe the regulation at issue in Loper-Bright Relentless as a major question. It involves, expenditures by people that have herring boats in the herring fisheries in the North Atlantic. I also think that the court was very careful to limit the grant to question 1 in both cases. The question 1 asks the court to overturn or overrule Chevron, or to hold that Chevron does not apply to silences in the statute where the same issue is expressly addressed elsewhere in the statute. The latter half of that question, I think, could conceivably result in a narrower decision, but I agree with Carolyn Seacott's paper that it's very implausible to carve out an exception for silences because any ambiguity could ultimately be construed as a silence of sorts. So I think the court has sort of boxed itself in. It deliberately granted certain these cases because I think the court must be very, very aware that the lower courts and the agencies are quite perplexed about the status of Chevron given the court's prolonged silence and its development of the major questions doctrine. So I think the best betting here would be that the court is planning to say something significant about Chevron in these cases. What is my position here? I filed an amicus brief in Loper-Bright as well. My position is basically mend it, don't end it, or fix it, don't nix it, or whatever you want to say. Why is that? Let me just briefly say what I think. I think why mend it? I think, as I will hopefully discuss very briefly and at greater length in the paper that I submitted, that Chevron has been revealed to have some significant problems. And this gives the court an opportunity to at least ameliorate those problems or do something about some of those problems. So that's why I would take the amend it rather than reaffirm it or end it position. Also, I think it's very implausible as a matter of realistic litigation strategy to think that after all the fulminations about Chevron coming from Justice Thomas and Justice Gorsuch primarily, and the sort of conservative legal movement's decision, I guess, to hyperventilate about Chevron as the symbol of the deep state that they think is taking over our country, it's implausible to think that 6 conservative justices are not going to do something to tweak Chevron, at least going forward. They're not going to reaffirm the classic Chevron doctrine. Why not end it? Multiple reasons. One is that a whole lot of human capital has been invested in understanding Chevron, both by lower court judges and by agency lawyers and private lawyers litigating against agencies. and learning the Chevron two-step, et cetera, and the various exceptions to it. And it would seem to require a pretty good reason to just throw this overboard in one fell swoop. Also, it's not clear what would replace it. The court doesn't seem to have a very clear idea of what sort of deference doctrine, if any, it would replace it with, other than de novo review, which I agree with other people is not doable for the lower courts, maybe for the Supreme Court. And I think so. Some kind of deference doctrine is necessary. We've always had one going back to the beginning of the Republic, and the court needs to. If the court were to replace Chevron, it would have to invest a lot of effort and time in defining what that replacement is, and there'd be transition costs and so forth. Not clear that all that's worthwhile. Finally, I think the court is treading on thin ice with the legal community, if not the public more generally, in terms of a series of dramatic and highly visible changes in the law that have been made in the last few years. Alexander Hamilton famously observed in Federalist number 78 that the court is essentially a powerless institution. It has neither the sword nor the purse. The source of the court's authority to command obedience from lower courts and everyone else is the perception that the court means it when it says it and it sticks to its guns about what its understanding of settled principles of law are. To put it somewhat over-dramatically, but I think not totally wrong, if the court doesn't follow its own precedents, no one else will either. So I think for those reasons, I would support not overturning Chevron outright. What about stare decisis more particularly? I do not think that the court has made many statements about stare decisis in the statutory context and in the constitutional context. Chevron does not really involve either the interpretation of a statute or a constitutional issue per se. It is what I would call a doctrine about legal method, how courts should proceed when reviewing legal interpretations that agencies offer in administering their own statutes. It's pure common law. The court did not cite the Administrative Procedure Act. It should have in Chevron, but it paid no attention to the Administrative Procedure Act, Section 706, throughout the nearly 30-plus years in which Chevron was being applied. Only late, toward the end in 2015, did some reference to the APA start creeping up indirectly in some of these cases. So it's not statutory stare decisis, and it's not constitutional stare decisis. What the heck is it? The court has said very little about the kind of degree of respect that the court itself and other courts should give to questions of legal method. Justice Kavanaugh had a brief statement about this in his little essay on stare decisis in the Ramos versus Louisiana case, but he didn't elaborate. There's a big, thick book about precedent that has been published by Brian Garner. It's about 900 or 100 or so pages long. There's like maybe one page on stare decisis to questions of legal method. So we're this kind of uncharted at this point. My own view, I guess, would be that it would depend on whether the question of legal method is well settled or not. So on the well-settled end of things, you'd have something like the norms that govern appeals courts in reviewing questions of fact by trial courts. That's well settled, and I think a lower court, an appeals court, court of appeals that decided to find the facts de novo would be reversed by the Supreme Court as a matter of precedent and stare decisis. On the other side of things, you have less settled propositions like whether or not you can use legislative history to interpret a statute. The idea seems to be that every judge or justice can decide for him or herself whether to use legislative history or not. There's no binding principle here that's controlling as a matter of law on anybody else. Chevron is somewhat in between. Chevron was considered to be a well-settled doctrine for many decades. The court actually reversed lower court decisions for failing to apply the Chevron doctrine, suggesting that it was regarded as a principle of law. On the other hand, Chevron has been modified several times, as Kent has already mentioned, and that should give the legal community a clear understanding that other changes are possibly forthcoming in the future. So I think the Kaiser versus Wilkie case is the right model, as Kent suggested, for the degree of respect that the court should give to Chevron. In other words, preserve the doctrine in the interest of continuity, the basic framework, but don't overturn it. Make some modifications, but don't overturn it. I had a lot more to say, but I guess my time's up, so I'm going to turn over the mic to Christopher.
Awesome. Well, I'm going to, I love the title of the symposium of Chevron on Trial, because in my mind, you can kind of come into that different ways. I was a civil litigator, so I would think, well, is this like preponderance of the evidence, 50% plus one to Chevron, do we keep it or not? But that's really not what we're dealing with, right? I mean, stare decisis is in the backdrop. This is a bedrock precedent. So we at least have, I would think of stare decisis maybe of like clear and convincing evidence, might be the normal kind of view of if we're trying to map it on to litigation. But as Ken and I argue in our paper, and I'll disagree just briefly with Professor Merrill, when it comes to statutory stare decisis, which I think that is the proper framework here, it's more like beyond a reasonable doubt, maybe not quite there. And the reason why is that Congress, it's interpreting a statute, Section 706 of the APA, even though the Chevron decision itself did not say that. The court said that in Meade, the way that Congress has reacted to it, whenever they want to decide whether to get rid of it, its Separation of Powers Act is to amend the APA. It's the way that we understand its place in the administrative state. And so it really is, the burden's really, really high in my mind. And why is that? Because Congress can change it. This is a separation of powers issue now. This is a doctrine that's been on the books for decades. Congress legislates against the backdrop, but as Kent said, if you look at how congressional staffers and agency rule drafters use it, it's the number one tool they use when they're interpreting statutes, drafting statutes, and drafting regulations. And I'll talk a little bit more on my remarks today. It's what the lower courts have been using, forever. It's the run. It is what we do. And if we had another study, I'm sure you could also say it's how regulated industry has operated for the last 40 years. And so it's a deeply embedded precedent. Kent and I argue it's a statutory precedent. And for that reason, that really is where we have to begin on what's on trial. What kind of trial are we holding, I think is a really important component of that. I want to talk about the rule of law values, though, of Chevron. And the ones that you normally talk about are congressional delegation, that Congress has decided to delegate that ambiguity to agencies, either implicitly or expressly, comparative agency expertise, that they know how to deal with these issues of policy implementation when there's an ambiguity in a statute better than a court would, and that they have a process to do that through notice and comment rulemaking. We can have debates about adjudication, maybe another day, that involves the public, that leverages the expertise of both the agency and the public in ways that courts just can't remotely do to implement statutory schemes. But the two that are left off the table and not given as much attention is uniformity in federal law and political accountability. And you'll see that uniformity in federal law is, I'm going to show you a bunch of stats that Ken and I did. We read every single Chevron decision over an 11-year period that the lower courts had, the circuit courts had where they'd used Chevron. And one of the big arguments you see in the amicus briefing against Chevron is that it's an unworkable standard. And I think Tom hit it like the nail on the head. Well, what's the replacement? Is that actually going to be workable or not? And more importantly, as I'll show you in a second, it is a workable standard. And at least it was when our data set was done 10 years ago. You can maybe say it's changed a little bit in the years since with the changing composition of the court, with the way the Trump administration and the Biden administration invoke and use Chevron in litigation. But this is like this idea of political accountability, the second value, is also kind of tied to national uniformity in some ways. So this is right out of Chevron. Judges aren't experts in the field. They're not part of either political branch. So courts sometimes have to resolve competing political interests. That's really not what they're supposed to do. Instead, look at agencies. You have a president that heads the executive branch. You have Congress that exercises oversight and legislative control over those agencies. And so if we have to decide between the court or agencies on who should implement statutes that are ambiguous, interpret them, it should be agencies that are more politically accountable. And there have been prior, and when we did our work on this, I kind of decided to troll a little bit. And I went on the Law and Liberty website and published an essay called The Federal Society's Deference Dilemma. And the point of this I was trying to make is that you kind of have like two different views on the right about what judges should do. and I'm way, way oversimplifying, a lot of granularity. But you have those that kind of are liberty-driven, and the courts are there to kind of plow through and recognize the rights the Constitution has recognized. And then you have maybe the six of us that are left that are more judicial conservatives, deference to political branches, stare decisis, move slowly, let elected officials take the lead on major policy decisions. And I kind of just said that Chevron is one of those areas where you have this kind of conflict, whether to get rid of it or not, or to keep it. I mean, it was originally a very conservative doctrine to allow the Reagan administration to deregulate. And there was a great lecture that Judge Kavanaugh gave at Heritage before he was nominated to the Supreme Court, where he says, "My goal is to help make statutory interpretation a more neutral and impartial process where like cases are treated alike by judges of all ideological stripes, regardless of the issue and regardless of the identity of the parties in the case." I'm like, yes, Chevron, yes, it's going to preserve, get judges out of politics. And no, the problem with certain applications of Chevron. And so the whole talk's about how, not the whole talk, but a lot of the talk is about how Chevron increases politics, judicial decision making. And that's where Ken and I's research come in. I'm going to just quickly kind of go through what we did. And again, this is 10 years ago. I do think things have changed. Maybe we could talk about that a little bit in the Q&A. But we looked at every single case in the Court of Appeals that cited Chevron or Skidmore using broad terms. So we had about 1,600 statutory interpretations in those cases that were about 1,400 relevant cases. And our goal here, kind of the big picture, which you may love, or you can use this slide whether you're pro or anti-Chevron, is that Chevron really matters in the lower courts. At least it did during that 10-year period. The difference in win rate when you had Chevron or you didn't, it's 77% when the Chevron deference framework applied. And if you went to de novo, it was 40%, and Skidmore was 56%. There are methodological warts we can talk through and selection effects, but kind of give a sense of where that's at. The other big takeaway is when you get to step two, the agency almost always wins, which shouldn't surprise anybody else who've litigated or read cases. Up at almost 95% of the cases, they almost win. But what we are more interested in is the political story. In other words, if courts are completely political and Chevron does not constrain, you'd expect a really liberal panel to always agree with liberal interpretations and a really conservative panel to always disagree with liberal interpretations and vice versa. That's the attitudinal model of judicial decision making. As opposed to if Chevron is playing a role in constraining, you'd expect politics are always still going to matter to some degree, but you'd expect a more flat curve. So let me show you what we found in our data. And this, by the way, we did the second paper that came out in Vanderbilt with our co-author, Christina Boyd, who's a political scientist at the University of Georgia. And so when you look at when Chevron applies to liberal interpretations, the negative is, I did do this on purpose, or the liberals, so like the most liberal panel is like your negative 0.5, and the agency wins about 90% of the time. Your most conservative panel, so three-judge, very conservative panel, the agency wins, I think, about 78% of the time. So there's a little bit of a difference. Politics does matter even under Chevron, but take a look when Chevron doesn't apply. It's an 82% or so win rate for the most liberal panel of a liberal interpretation, and we're down, I think, at 24% for a more conservative, completely conservative. So when Chevron doesn't apply, you see the political model really kind of come out. On the conservative ones, it's not quite as much, and conservative interpretations don't win as much. And I think some of that's immigration, and that actually does show up on our study. Both conservatives and liberals just don't like immigration adjudications. But you're at like 50% when Chevron applies for the most liberal panel. So it's a coin flip, up to about, I think, 64% when it doesn't. Or sorry, for most conservative one. And if you take out Chevron, the cases where they don't apply Chevron, you're at 22% versus about 50%. So you kind of see kind of our bottom line takeaway here is that if you care about judges not being political or being perceived as political, which is a value that a lot of us judicial conservatives carry a lot about, Chevron really does play an important role. The bigger takeaway is if you care about national uniformity in law, predictability in law, as Justice Scalia said in City of Arlington versus FCC, Chevron has a stabilizing force because it forces the lower courts to more likely agree with the national interpretation that an agency has advanced. And these are just two really important rule of law values that you have in Chevron that the court really, I think, has to grapple with more if it's going to get into the policy debate along those lines. Now, I think within 48 hours after I posted this little trollish blog post on law and liberty, Philip Hamburger, I'm going to skip the whistleblower effects. Philip Hamburger posts his response, Chevron bias illustrated by statistics. In other words, all of our data shows that Chevron biases courts to rule for the government. And my response is, yeah. I mean, not that it biases it, but Chevron is a tool to bring stability to the law to allow for elected representatives to play a larger role in how statutes are implemented and to remove courts from being political and letting their kind of role play. So sure, I mean, that's one of the main reasons we have Chevron. And I think those are good reasons, not that it's biased, but that it encourages uniformity in law, discourages politics and judicial decision-making. And that's something the court's going to have to really consider seriously. Now, that doesn't mean that's enough to keep Chevron. I think stare decisis plays a really big role here. And some people might value stare decisis less than others, although every member of the Supreme Court, when it comes to statutory stare decisis, has a view that it matters. But that's kind of where we're at. Now, I want to just briefly, and maybe we'll get back to this in the Q&A. The last thing we say in our article is the court's already striking the right balance. Of the concerns that petitioners raise, the court's already responding to them. More searching, step one, whether that's clear enough for Gorsuch or for Kavanaugh, takes Chevron footnote 9 seriously. Kagan for the court has encouraged a more searching, arbitrary, and capricious review under step 2. And then, of course, as Tom mentioned, we've got this new major questions doctrine that's going after the big, value judgments and making Congress speak clearly on those. So what we have left of Chevron is when a statute is truly ambiguous, when the agency has acted reasonably and not arbitrarily, and they're dealing with implementation details and not major questions. I don't know what's left to complain about Chevron as a policy matter in the world that we live in today.
Thanks to all the panelists for those remarks, and I'd like to sort of start by picking up on that last point. One of the, it touches upon something you just said, Professor Walker, but I also want to rope in something that Professor Merrill mentioned. Why are we here? Why is de novo review, Professor Merrill, as you said, not doable? Why is it that, as Chevron said, judges are not experts in the field, when that field seems to be the interpretation of statutes, which I suspect at least some of us think is the whole point of the job? So what exactly is the complication that is unique to the interpretations of agency action versus mine run of statutory construction?
All right, let me take a crack at that. I do think Chevron promotes uniformity relative to de novo review because if you had all 13 courts of appeals we have, is that right? Deciding these issues de novo, you would inevitably have lots of disagreements about how to interpret these administrative statutes. And I don't think the Supreme Court, which is the other institution that promotes uniformity of federal law, has the decisional capacity to review all the circuit conflicts that would emerge if every court of appeals was, if the issue was common enough, let's say the Social Security statute or something like that, issue was common enough so that they had different interpretations coming out of every circuit. The court doesn't have the capacity to sort out all the conflicts, and it would take time to sort out all the conflicts. So I do think that having a kind of default position that in cases of uncertainty that you go with the agency, as Justice Stevens said in his conference comments in the Chevron case, does promote uniformity relative to de novo review. De novo review, if done seriously with a statute like the Medicare and Medicaid statutes, as the court did in a couple of cases in 2022, is a very time-consuming task. You have to go through these sort of extremely convoluted statutory provisions and weigh lots of different variables. And again, I don't think the lower courts that face a lot of these cases really have the decisional capacity that the Supreme Court does to do a really meaningful and correct de novo review exercise. The final point to make, which I think is made strongly in the paper that Vermeule presented through the conference, is that there is no inconsistency between de novo review and deference to agency interpretations if you take seriously the proposition that de novo review reveals that, in fact, Congress did actually delegate to the agency authority to resolve the provision in question. This is probably the biggest theme in my book, that Chevron talks about explicit and implicit delegations. There's no evidence, I think, that Justice Stevens thought implicit delegations means that whenever the statute requires interpretation, you automatically defer to the agency. I think what he thought was that if you do a serious exercise in review, as they did in Chevron, and conclude that Congress had implicitly but actually delegated authority to the agency to decide the question, then it's appropriate, as a matter of de novo review, to defer to the agency. So I do think that there's an ultimate consistency between de novo review and deference per Chevron.
No, go ahead.
I mean, I just say, having read, 1,600 of these, circuit court decisions, I mean, so many of them, and I think Adrian Vermeule's done a Twitter thread on this too. I mean, so many of these are what is fair and reasonable? What is an acceptable level of risk? What is the best system of emission reduction? It might not be the best example from the rest. Sure, you could say, well, that's subject to multiple interpretations. A court could say the best interpretation is this, but why would they know that stuff better than others? I mean, a lot of this is more interstitial implementation details, and if you view Chevron as that, and I have to say, I think Justice Kavanaugh's view of Chevron is kind of like that. In other words, the only way he would change Chevron, at least in his Kaiser concurrence, is that he would say, if the court thinks there is a best interpretation, an actual interpretation that the law says is the law, treat step one seriously, say what the best interpretation is, and don't give ambiguity. But if not, we're in policymaking realm now, and arbitrary and capricious review applies. And I guess my slight disagreement with that, having read a lot of these circuit court decisions that are highly technical and trying to implement statutes that clearly leave some room for scientific and other expertise, is that trying to guess the best interpretation can get really political. That makes sense? I mean, at some point, the law runs out. And for me, the law runs out a lot earlier than it did for Justice Scalia and then for maybe Justice Kavanaugh. So I think some of the debate is really about, do they have to decide what the best interpretation is? And at what point do they say, in Justice Kavanaugh's book review and the Harvard Law Review, do we have to be 60% certain that it's unambiguous? Do we have to be 90%? And I would be much closer to 90% than 50% plus one, for the reasons we kind of already talked about, the rule of law values of Chevron.
One quick thought on that. There's been much made over the difficulty of figuring out what is ambiguous, and Chevron leads us in this place where we have to figure out, how deep should the inquiry be? How do we know whether we should be moving to step two or not? Maybe it's the contracts professor in me talking, but we already do this. We do it with contracts. It's a legal question whether or not a contract is ambiguous. There is some point where we have to have some faith in the judges that they can make that kind of determination because they make it in other places as well. But to Judge Mady's question, I think a lot of this actually comes down to the different ways we think about judging. And so do you take a model that is often referred to as the legal model, which is this great faith in judges, they can put all politics aside, and I think pushing that a little further, which you might see more out of judicial conservatives, that you can find a right answer. There is a platonic correct answer sitting out there, whether you can uncover it through originalism in the Constitution or through some form of use of canons and forms of interpretation when looking at statutes. That's one side. The other side is going to be more attitudinal. That is that politics are going to have a role in how courts resolve disputed issues. And I think that would be especially true in cases concerning agencies, which are inherently going to be issues that are more political. So to the extent you think the attitudinal model does have some purchase on courts, then I think this is the area you may be the most concerned about, what the effects are going to be longer term.
Is the problem politics, or is it diligence. I wonder that because in my experience, recent and old, what I have often seen is, and this picks up on Justice Kavanaugh's point, that this phrase ambiguous has become an off-ramp from the highway of interpretation for courts that may, for whatever reason, wish to not engage in the sometimes complex problems of interpretation, a point that Justice Kagan highlighted in Kaiser, that just because something's hard doesn't mean it's ambiguous, but yet the reporters are filled with cases that say, oh, the statute says you must make an effort. Oh, well, who knows what that means, so let's just defer to the agency. And so I wonder if anything will change after Loper, right? Won't judges faced with the next complex bubble concept say, okay, we're engaging in whatever the new Loper-Bright standard is, but what we really do is just read the government's brief and then say, that's what we've arrived at as an independent determination. So, I mean, isn't this just sort of Skidmore all the way down? Call it what you want, but how do you force courts to disregard an agency interpretation with some sort of methodological imperative?
Good question.
I mean, I have to go back to work on Monday, so I really need
you
an
have to
answer
go
to
back.
this.
I mean, Justice Kennedy, before he retired, offered a separate opinion in which he said that he was increasingly, he was a big proponent of Chevron for years. He offered a concurring opinion when he said that he was increasingly disturbed by what he perceived to be the reflexive application of deference by lower courts based on a cursory analysis. So that's an example of a Supreme Court justice who is perceiving what you call the lack of diligence as opposed to political meddling. And I think that is a serious problem. I would hope that the court, at a minimum, would reiterate that in any case where there's a fair doubt about this, the judges have to decide de novo whether the agency is, A, acting within the scope of its regulatory authority, and B, whether this is a provision that Congress has implicitly wanted them to interpret. That's going to require more effort than the two-step Chevron doctrine in its classic form. The classic form of the Chevron doctrine was rule-like only in the sense of it mandated a certain sequencing of inquiries. First, you look at the statute de novo. Second, you ask whether the agency interpretation is reasonable. In practice, what it is two very cosmically broad standards, clarity and reasonableness, linked together in a composite. So if you have willful judges or if you have judges that are just not diligent, there's lots of room there to misbehave under the Chevron test itself. So your question is a very serious one. There needs to be perhaps some attitudinal change, and how, if at all, can the Supreme Court try to make that attitudinal change other than by acting by example. Yeah.
I think part of the problem with Chevron is it was very unclear on what, quote unquote, those traditional tools of statutory interpretation are that one is supposed to use at step one. But that's not just a failing of Chevron. That is a larger failing with statutory interpretation altogether, where the courts, if we even look at courts of appeals, they're notoriously inconsistent about when they pick up certain canons of construction, when they're going to use certain rules. There has to be much more guidance on what the order of battle is. How are you going to think through step one? What is it that the Supreme Court is going to set up as the methodology for the lower courts? They haven't done that. And I don't want to be too harsh on Justice Stevens, because I think part of the issue is historical here. When you were looking at 1984, you largely found judges who basically all fell into a legal process school where there are lots of canons of construction. You kind of know when you're going to pick the best one, and it just takes wisdom, and you do this.
Totally dominated in 1984.
Yeah, it's a different interpretive world at that time. Now there's much more dynamism, at least, in how judges approach statutory interpretation, and I think views that are not consistent with what we saw with judges in 1984. But if they're going to have inconsistent views, well, say what those are. Say how you should go about interpreting that statute since you're providing guidance. It's a little bit cowardly to say as the Supreme Court, well, those lower courts, you just don't know what they're going to do at step one. They just may pass the buck way too quickly when you haven't given the instruction on how they should approach that step.
And likewise, there's also no recognition as to what the role of the so-called substantive canons of construction are, right? I mean, this is a point that Justice Kagan made recently. Mm-hmm. And if you look at Chevron as a substantive canon of deference and then look at the Congress's failure to repudiate Chevron as another substantive canon that gives life to the substantive canon, but the court has never sort of told us what we're supposed to do with these substantive canons, it does get rather tricky. We've talked, a couple have made the point that the court has simply never said Chevron has one step, that we review the agency interpretation for reasonableness using the traditional tools. Is that a sufficient outcome here? Is that something we might see? And are there predictions, I suppose, as to what will happen?
I very strongly disagree with the one-step idea. The utility of the two-step approach to Chevron is that it establishes whether or not the agency has discretion to change its mind in the future. So if the case is decided at step one, the court has determined that the law has a determinate meaning, which is binding on the agency going forward. And so that sort of ends the room for agency discretion to alter its legal position in the future. If it goes to step two, the question is whether the agency's interpretation of an unclear statute is permissible or not. The court could uphold the agency at step two, as it usually does, or it could occasionally disapprove it at step two. But whichever outcome, going to step two indicates that this is a matter as to which the agency has ongoing discretion. If you collapse everything into reasonableness in one step, then you're just back to the pre-Chevron regime, where courts would use an eclectic mix of interpretive canons in reviewing agency decisions, and it was very uncertain whether agencies had further discretion to reinterpret or not.
Agree? Disagree?
I think that's right. It gets back to kind of Justice Kavanaugh's view of, well, at least how I read Justice Kavanaugh's view, is that step one would be, and you would still have a reasonableness review even without Chevron. It would just be, once you determine that the laws run out, the agency can you make policy, that's where you have. But I agree with Tom. I think that's definitely each step plays an independent role, even though step two, the agency almost always wins. Now, could we see that get more reinvigorated with more of an APA arbitrary and capricious review? Yeah, and Tom's in his book, and all three of us agree that step two can play a bigger role than it does right now.
Putting more weight on the consistency over time of the agency interpretation, which would produce some stability. You wouldn't have every change in administration either adopting or repudiating net neutrality rules for internet service providers.
Yeah, and we haven't really talked about that, but the falling out of love with Chevron in your comic book story, one really simple view is like there's a change in the courts, right? The courts have become more conservative. But that's like chronologically just not right. I mean, the distaste for Chevron happened long before that. And I think when you think about why, I think one of the reasons why is what Tom is saying is that you see kind of a rise of presidentialism of, instead of trying to go through Congress, doing it on your own and getting kind of more aggressive with older statutes. I think that's kind of part of it is, and I think particularly the second term of the Obama administration, all of the Trump administration and a lot of the Biden administration, it's not like 30-degree course corrections or changes. It's 180 or 90, and it's kind of jarring, and I do think that leads to a lot less predictability in the law, to put it mildly. And I think that is one of the issues that the court and Chevron skeptics are struggling with or responding to, is the fact that we have we're using regulations, it seems, in a different way. Now, maybe some of the other panelists later in the day will disagree with me on that. But I do think that's part of the story of why you have some distaste with Chevron as a continuing doctrine.
Yeah, I agree with that. The simplistic political science story that Chevron is just basically one tool that the conservative justices are using to try to push back against policies they don't like is inconsistent with the firm commitment to Chevron by the mostly Republican-appointed justices during the Clinton administration, and with the fact that once the Trump administration got going, the opposition to Chevron only grew among the justices, where the political science, the sort of one-on-one, correlation between political attitudinalism and support or opposition to Chevron would suggest that all of a sudden they should have turned on a dime and become rabid Chevron fans, but that didn't happen. They became even more opposed, yeah.
Is it too naive to ask the question, why not just amend the APA and resolve this and all sorts of other questions that have arisen since that grand compromise was passed? It has been a moment since 1946, right? So why not train some of the fire on that question?
I think it's a fair question, and I think it's something I know we have talked about before. There are so many areas of the APA that need updating, clarifying, and you just can't get it through. They just will not send it, usually even through committee, and then it can't even get through one of the chambers. And these are things where we have bipartisan agreement. Things aren't terribly controversial in providing more details, let's say, on even just rulemaking or adjudication and how things fit in with different components. But I would also turn that question around a bit. I mean, if the idea is that if Congress really wants to keep something, then it should have to act for it. Well, that would apply in all other situations too. If we're talking about something the Biden administration is doing on environmental law, then I think the same argument would be, well, I guess we'll let the Biden administration do it. And if Congress doesn't want to do something that the Biden administration is doing, then it should enact the law. But that isn't how the current Supreme Court acts at all. So I would just want to know why this question. Why is this the one that Congress has to respond to if it doesn't want the law to change, but we don't do that in other contexts?
And I want to zoom out on this because this is often brought as an argument for why stare decisis should be less. The APA has been amended less than 20 times, although it was amended last year, and the administrative law professor listserv geeked out about this because it added this new provision. You have to provide a 100-word simple summary on a website about what a rule is, which is super exciting. But I want to really, really push back on this because the Administrative Procedure Act is a framework statute that sets the default rules for how agencies regulate and how courts review agency action. But those default rules, as all of you that practice in different regulatory fields know, Congress departs dramatically from those in particular regulatory fields. They pass hundreds of statutes, reauthorizing agencies, amending statutes that govern agencies, where they adopt a different standard of review, as Ken had talked about earlier, or they adopt a different process that has to be applied, or they preclude judicial review altogether. And so when I think about should we amend the APA to fix Chevron because Chevron needs to be fixed, which I don't necessarily think it does, but Congress is already tinkering on a regular basis when they reauthorize statutes that govern agencies. And when they do so against the backdrop of Chevron. And that's why I think when you think about settled expectations, and I don't want to use the word reliance interest because that bothers me, but settled expectations about how the administrative state functions, Chevron's a core part of that on the Hill.
I want to expand the conversation. I think we have 50 more. Yeah, absolutely. We're going to go to Professor Merrill, but if there are questions and we have the ability to have them asked, we'll do that after Professor Merrill's point.
Yeah, I just wanted to make a point about the empirical studies that Chris was talking about, showing that there's a correlation between the application of the Chevron doctrine and affirmance of agency decisions, legal interpretations, without regard to whether they're liberal or conservative or the panel is liberal or conservative. I'm surrounded now, as many law professors are, by a whole bunch of empiricists, unfortunately. So this may mistake correlation for causation. The problem is that if you're on a panel and you decide to affirm an agency, an easy way to do that is to trot out the Chevron doctrine, which has this historical connotation of being pro-deference. And so it's an easy way to write an opinion affirming an agency. If you decide to reverse an agency, it's much easier to sort of ignore Chevron or else use some different doctrine that gives you more leeway to do that. So it's very difficult to peel apart the causal influence of Chevron and the use of Chevron as an item of justification in the opinion writing.
A point that you well make in the book where you recount the conference notes and history of the Chevron decision itself, which seems to reveal confusion and perhaps skepticism about the interpretive methodology, but a desire to simply sort of find a way to land the plane that was necessary because of the cert grant. So perhaps that shows that this has been a problem that goes all the way back to 1984 when the court was first trying to figure out what to do, and maybe it was more important than what it thought it was creating.
It's the June crunch is the explanation of Chevron. Right?
Exactly. Let's expand the conversation. I believe there's a microphone, so if you have a question for the panel, please raise your hand and we'll move you over. I see right behind you there's one over there. I'm going to turn around. There you go.
Hi, thank you very much. My question is about whether the focus of the litigation is the best place to be, as opposed to in terms of what should the courts be doing in deference. It seems that the bigger problem with Chevron was not the theory, courts are not experts, courts are not politically accountable, but the operationalization of that. Sorry, I didn't say that well. In terms of many agencies, including my former agency, treated deference as abdication. And so at step 2, where you're supposed to be saying, is this reasonable? They would bring nothing to the table, make no record, and say, we win because you have to assume what we want is reasonable. And so just to give an example of what's happening in my little world, which is veterans law, a form of administrative law, and what's happened in Kaiser. I just want to get your thoughts on what they've done with Kaiser. So there's a recent case called Kearns, where Judge Allen treated Kaiser as step 1, this is ambiguous. Step 2, have you earned deference? Agency, you say what you want, but you brought nothing to the table explaining why that's your expert opinion, what's the foundation for this, how this leads to a better result, or how this was in question that rose to the political levels of the agencies. So there's a political thing. So you failed to earn deference, so I'm going back to de novo review. I think the other reading is better, so you lose. Could this be more about making agency decision-making more transparent in a way that where we have a conversation about what does an agency have to do to earn deference from the courts, so it's not just abdication in the face of ambiguity, it's a real question of is there expertise, is there political thought that goes into it that should be owed deference, as opposed to this just looks like the opinion of the agency attorney writing the brief, who doesn't have any of that backing. So sorry if that was a long question.
Yeah, I think that's great. There's a nice article by Aaron Nielsen and Kristen Hickman a few years back, which suggests that Chevron should be limited to interpretations rendered through notice and comment rulemaking. And I initially thought this was a bit too aggressive, but the more I thought about it, the more I thought it makes a lot of sense for precisely the reasons you're saying. But if you use it in rulemaking, you're going to have public participation, and you're going to have the agencies under this duty, which has been created under the way we understand rulemaking, to respond to material objections to their interpretation. And so presumably that would improve the quality of interpretations. I also think that it would help respond to the bias objection that my friend Hamburger and his various libertarian cohorts have been making. I think the bias problem is the most severe when you have an agency that's bringing an enforcement action and the agency prosecutor is arguing for one interpretation and the agency ALJ or judge that's deciding the case is under some kind of implicit pressure to agree with the agency's view about the law. With rulemaking, it's not quite so clear to me that there's a bias problem. It's like Congress has told the agency to implement the statute in certain ways through rulemaking, and so everybody gets their chance to be heard, and the agency has to defend its position. And that weeds out bias. It doesn't completely eliminate it, but would help with the bias problem. So I think that, and the truth is that Chevron itself was a rulemaking case, and 90+%, I think, of the Supreme Court Chevron cases have involved rulemaking. It's creeping over to adjudication, I think, was just an accident of path dependency. Once the court did it once, it's felt it had to uphold that in subsequent opinions like Meade. So that would be another change to step 2 that I think at some point in time, not in this Loper-Bright case because that was a rulemaking case, but in some future case the court should consider limiting Chevron to rulemaking.
I think related to that, and it's consistent with what Tom is saying, what Chris and I have written separately in a different article, that not only does the court need to provide more guidance at step 1, but at step 2 as well. And kind of the key takeaway we found when we looked at what the Supreme Court did, and then we looked at every time the agency lost at step 2, which it was a smaller subset of cases, of course, what we saw was something that was fairly inconsistent, where you had the court that would say it wants reviewing courts to treat step 2 as arbitrary and capricious review. And I think that would be really useful because it would then follow kind of the rule-making ideas. We could import in what we expect to see in a record where you would have to provide the basis for the opinion. The problem is if you read the Supreme Court decisions, they aren't actually doing arbitrary and capricious review at step 2. They're doing something we refer to as hypertextualism. They just go back to the text again. They don't turn to anything like a record. So then you get this issue in the lower courts, and the lower courts are trying to figure out, well, what is it we're supposed to do? Do we do what you tell us to do, or do we do what you actually do in the cases? And it's a mix. More of them pick up the arbitrary and capricious than some of the other forms, but it's not well resolved. So what could the Supreme Court do? Make it clear that it is arbitrary and capricious review at step 2, which would render Chevron more consistent with section 706 because you could tap into the arbitrary and capricious review. We would understand what a record typically looks like for that, and I think it would, as Tom said, get us around some of those bias concerns that we have. But it's going to take the court not only saying it, but also doing it in its opinions as well.
I'd just add to that, though, so it sounds in Tom's article in amicus brief, kind of like Kaiserizing Chevron, adding a bunch of steps. And I just, the one word of caution I have with that is Andrew Hammond and I just spent the last few years reading every Kaiser decision in the lower courts. And not surprisingly, it is an absolute train wreck. I mean, courts don't even know what to do. They're not applying the framework. I mean, I think Kagan thought I'm going to be like Scalia. I'm going to have like this really rules-based, as opposed to a standard everyone can follow and apply. And it turns out 5 steps is probably too many if you're trying to do a rule. And also, if you can't even get 5 votes for the pro-deference side of your opinion, like it's not going to end up being a very durable approach. So I'm worried if, from a predictability, rule of law, uniformity in law, if we end up with a Kaiser-like Chevron, it's just going to cause chaos in how lower courts approach. Right now, you got 2 questions, and I agree with you. They are a little bit more standards, but they're standards and more rules. I hadn't thought of it that way, but yeah. But they're 2 questions, and they're really just one because once you get to reasonableness, the agency almost always wins. But the 5-step is going to end up, I think, just being a disaster for how lower courts implement it.
Well, and just briefly to that point, if one of the concerns is what do you do if we get rid of Chevron, and one leading idea is that you would move to Skidmore. Well, Skidmore already has, depending on how you count, somewhere between 3 to 6 factors. It includes all of those things which could persuade, so it makes it quite a bit more capacious. I think one thing not to forget is before Chevron, Skidmore in some courts had turned to an 11-factor test. It just became unworkable. And so I think we kind of have to worry about factor creep in any of these tests that we use.
It is fascinating, though. Like in Loper-Bright, the petitioners, I think, very strategically don't tell us what to replace Chevron with, which I'm guessing in an oral argument, the court's going to spend a lot of time in kind of what Will Bode calls Justice Barrett's look before you leap approach. Like, I'm not just going to get rid of a doctrine without figuring out what's going to happen afterwards, which I fully support and love. You're gonna see the court have to really grapple with that, and that might be one reason they don't get rid of Chevron. One of the main reasons is that there's not a replacement, that they can't envision what the replacement will do on the ground. Oh wow, there's lots of questions. Shoot.
Yeah. I think you got a couple right there.
Mark Chenoweth, New Civil Liberties Alliance. So I work for Hamburger and represent the folks in Relentless. So just to let you know where I'm coming from. The panel did the same thing that the court did in Kaiser, which is completely ignore the 2 strongest constitutional arguments against Chevron. Professor Barnett, you mentioned the Article 3 argument, but you caricatured it as one sentence from Marbury, which is not what the argument is at all. Don't have time to give the entire argument here, but of course Philip Hamburger does that in his Chevron bias article, and you can go reread that if you haven't read it already. But the argument that I wanted to talk about or ask a question about is which Professor Merrill did allude to there at the end of the question period is the bias argument, the due process argument that judges have a duty to impartially judge the matter before them, and when they're replacing their own independent judgment by deferring to the judgment of the executive branch, which is one of the parties before them, then they are systematically engaging in bias, which is contrary to the due process of law. So my question to the panel is, what is your strongest argument against that, which I perceive to be an extremely strong constitutional objection to Chevron deference?
I can start. We may have to agree to disagree over how I have framed the argument. I've written an entire article responding to those arguments, and they aren't terribly well developed. They do tend to come back to the same notion this needs to be de novo. Why? Because courts have a duty to say what the law is. But you can read my article. I'll be happy to reread his again as well. But I think on the due process side, I think you have to ask, well, what else does that mean? In other forms of cases where we have things that are a form of deference, so let's start with habeas cases. Well, with habeas cases, the way we have EDPA set up right now, courts must defer to the state interpretations of federal law. I mean, is that a bias in favor because the courts aren't using their own independent judgment? What about enforcement of arbitrators' decisions? Not all arbitrations are actually voluntary. There are some, including in one that was a case decided in the 1980s by the Supreme Court, where it's mandatory for anyone that seeks certain licensing from the government. In those cases, there can be legal determinations that are made too, and the court cannot use its independent judgment. Indeed, in some cases, we're not even sure if they can actually review the legal questions that are provided, or if they can under an extremely deferential standard. So I think you've got to then grapple with this question, well, why is it okay sometimes, but not in this one case, especially when we say it's the executive? Why would that create a due process bias question, as opposed to perhaps a separation of powers question, because you're invoking the executive branch?
Yeah, I just have to say on that, if the argument's just about purely private rights, which Hamburger's first book was all about, and not about the 99% of the rest of the administrative state, which deals with welfare programs, public benefits, immigration. I think there is some purchase, and we do in our brief and in our essay flag that if it's a purely private right, Chevron is complicated, more complicated there. But it's a pretty, I don't want to say lazy, but I just did. Lazy argument to bring that out to all of Chevron and say there's a due process issue. And I have read Hamburger's article several times. It's just, honestly, it's just not a very good argument for getting rid of Chevron generally. It might be a good argument for purely private rights, but it just doesn't stand much scrutiny beyond that. You have to get rid of a whole bunch of other history, tradition, habeas, everything else that Kent mentioned. In that view, and that's just not that it would fly in the face of what we've been doing, since the founding. So I think you'd have a big issue you'd have to deal with.
I think we can squeeze one more quick question in, push the clock a little bit. I think there's a hand or two over there.
John Vecchione, I'm counsel of record in Relentless. In this case, one of the things here is that the question isn't really a question of expertise of the agency. It's a matter of who pays. And this who pays question strikes me as a core congressional question. That's what they do all the time, who pays. And there's no suggestion that they've delegated the who pays question. This isn't the sort of thing, how many herring can you take? What should the quotas be? How big the net should be? It's not like that. It's a congressional question of who pays. And so why should they be given deference, and why should Chevron be used? Because I think one of the problems is everything becomes Chevron because it's so easy. Read the First Circuit's Relentless. It's just sloppy. It's not like Srinivasan in D.C. It's just sloppy. Yeah, step one, step two, I don't know, but they can do it. So that's my question. There's no agency competence in who pays, and they actually didn't like how much Congress was appropriating, which also seems like they're going against Congress. So that's my question.
I can respond briefly with that. One, I don't see an inconsistency between those two things. So as I mentioned, we filed an amicus brief in favor of neither party. I think Chevron should continue to be the deference regime that applies to these questions of agency interpretations. But the reason we didn't file it in behalf of a party is, personally, I was persuaded by Judge Walker's dissent in Loper Bright. I thought, even applying the framework, that the fishermen should still win the case at the end of the day. I didn't think it decided the matter. It was a separate question. Then, just briefly on the second part, where you said that the assignment of fees doesn't deal with expertise. It's essentially kind of making this policy decision on costs, which may be different. I think that's actually very insightful. And in part of what I would say is, when I was doing my analysis over why Congress decided to say to the OCC, you get Skidmore deference, you don't get Chevron deference for those preemption decisions, when you went back to the legislative history where they were having the committee meetings and the committee reports, it was all because they thought the OCC wasn't using its expertise. They thought it was being driven by something else, and they said, if the agency's not using its expertise, it shouldn't get this kind of deference. And so that's why they turned to Skidmore with it. I think that understanding that questions that involve the agency's expertise are the ones that deserve Chevron deference should be taken more seriously. It was actually points that Justice Breyer had been making for decades, but it kind of fell on deaf ears on the court.
I want to just jump in, though. I think this is a fairly easy step one case the agency should lose. But on your idea of a policy, no. Agencies have a lot of expertise in deciding regulatory schemes. That includes who pays what fees and who carries the burden of the regulatory process. And if it's a major question, you might have your major questions doctrine. I don't view this as a major question, and I would not love an idea of the court declaring that agencies don't have expertise in deciding how to shift costs among different regulatory parties, because that's what they do. That's where they do have a lot of expertise. So I'm not a fan on that part, but on the step one issue, I agree with Kent.
As always, the best conversations are the ones that end too soon. I want to thank the center. I want to thank George Mason, and on behalf of the panel, I want to thank all of you for your participation today. We look forward to seeing you throughout the day. Thank you again.
Thank you.
Quick break. Yeah, I need to go. Check what date that I thought it would be later. Next Thursday. Right. Yeah. Well, before you retract that, let me I'm going to contact my wife. Well, we just.
I mean, probably just to get everybody situated, but if there's a button there that I can do, then they don't have to be watching. Oh, yeah, great, that's perfect. Okay.
20 minutes of peace. If they want to go a little shorter, I mean, if you're thinking of flashing cards out, I'd be surprised.
I have a non-substantive question. I just got my first appearance of
Right, if everybody could take their seats, we're about ready to start the second panel. All right, so I have to say, I loved the really engaged Q&A period after panel one, so that should serve as a model for the rest of the day. Real-time live discussion here at the Gray Center Conference about upcoming litigation with the leading litigators in the room, the leading scholars in the room, and what could be more fun. So we're gonna have a equally lively panel, I'm sure, panel two, on is Chevron inevitable and what should replace it, which I think actually builds nicely on some of the questions that were raised and opened up a little bit on panel one. So to moderate that panel and introduce our panelists, we are so pleased to have the Honorable David Porter, Judge on the U.S. Court of Appeals for the Third Circuit, and perhaps even more importantly, a Scalia Law School alum, formerly of the George Mason Law Review notes editor. So we're keeping it here on the home turf this morning, and so grateful for your time and that of the panelists in joining us. Thanks so much.
Thank you, Jen. Well, this panel's topic, whether Chevron or a similar deference rule is inevitable, stems from maybe two basic facts. First, the English language allows Congress to express its intent more or less ambiguously. That's not to say that language is always ambiguous, but it allows for drafters to use as much ambiguity as they wish when codifying Congress's intent, including ambiguity that results from the failure to speak, from silence. Second, Congress likes to delegate. It routinely gives unelected agency officials the power to create consequential and politically sensitive policy. Congress could stop delegating so much, and it could often draft more clearly. But without a meaningful non-delegation doctrine, that's unlikely to happen. So what are courts to do? We can only decide specific cases that come before us, and we take the statutes as they come to us. Does that make deference inevitable? Well, our panelists will unambiguously attempt to answer that question. We're just going to go in order, and I'm not going to give you the full bio that's in your program, but I am going to mention their clerkships because I think that's relevant. Since our panel, in part at least, isn't making sort of normative arguments about what courts should do, it's making predictive judgments about what courts do and would do if Chevron were to evaporate, later this year. Dan Walters is and so their judicial experience as law clerks, is sort of relevant to making those factual predictive judgments. Dan Walters is a professor at Texas A&M University School of Law. He clerked for Judge Margaret McCune on the Ninth Circuit. John Duffy is a professor at UVA and clerked for Stephen Williams on the DC Circuit and for Justice Scalia. And Professor Bressman is at Vanderbilt University. She clerked for Judge Cabranes and for Justice Breyer. I want to mention she's co-author with Abby Gluck of the two-part articles, Statutory Interpretation from the Inside, which have been influential in this, in this space. So, Professor Bressman, please take it away.
Thank you so much. Thanks for that nice introduction. Thanks to everybody for coming and for the invitation to present here. The last panel is a hard one to follow, especially because we're in the position here of predicting the future. I won't make jokes about predictions and how predictive they are. Instead, I will just take that as the motivating question and offer some remarks about where I think lower courts might go after Loper-Bright, after Relentless, whatever it gets called. So what I think, what I predict, maybe what I hope, is that whatever rule Loper-Bright announces or ushers in, that the decision ultimately may have less practical effect in the lower courts than we might expect. And to begin, it's important to note that Loper-Bright, and I'm just going to refer to it as Loper-Bright, is unlikely to change how lower courts approach typical cases at all. Let me tell you about typical cases. This is not an empirical paper, but like Kent and Chris, I've read a lot of opinions. from lower courts. So this is truly a guess. Nevertheless, in the typical case, which I describe as involving the routine, often specialized questions that agencies decide in the normal course of implementing their statutes. Elsewhere, I call these ordinary questions. And I think rather than focusing on major questions and what falls into that box, we ought to consider the large range, the countless number of ordinary questions that lower courts confront. In cases involving ordinary questions, judges will search for the meaning of imprecise or broad statutory language no differently than they did before. They will examine the relevant statutory text, the purpose, the structure, and the context using the same interpretive tools and the same methodologies as they did before. And that means that textualists will continue to excel at finding clear meaning. Justice Scalia reminded us of that long ago. Or they will find clear enough meaning, as Justice Gorsuch has said more recently. And textualism may well be ascendant among lower courts, or as there are more proponents of the methodology on the bench, or it may become more dominant simply because lower courts take their cue from the Supreme Court and that methodology. So, step one, statutory interpretation will remain basically the same. Now, courts begin every opinion by asking whether the agency has authority to decide a particular issue or reach a particular subject. Well, they certainly will if Loper-Bright instructs them to do so. But even here, the authority question, the answer is likely to be yes if the question of statutory interpretation is non-major and arises under imprecise or broad statutory language. That's just how congressional delegation works. Congress leaves the details to the agency, even many important ones. Moreover, courts may be uncertain how to answer the authority question other than through standard statutory interpretation. So they will continue to reach for their interpretive toolkits to determine whether the agency's interpretation is authorized or whether the relevant statutory language precludes that interpretation or requires another. The authority question might well look differently in cases like Loper-Bright, and I won't go into detail about cases like Loper-Bright, except to note that it's a legislative silence case. Legislative silence has never been particularly reliable in statutory interpretation, so we may well see a difference there. But I want to talk about the run-of-the-mill cases, the typical cases. When courts do not find clear meaning or clear enough meaning for the relevant statutory language in these typical cases, the next question, step two, they will decide if the agency's interpretation ought to prevail. That's what they do. That's what they're asked to do. That's what judicial review is. They will evaluate the agency's interpretation in view of statutory sources, including the text, the purpose, the structure, the context. They will consider whether the agency's interpretation reflects considered informed judgment. We've heard about this already. Was the interpretation reached through a formalized process? Has it been consistently held? Does it rely on expertise? Is it well-reasoned? And here's the bottom line. The more specialized the interpretation along these dimensions, the more likely the court will be to agree with it. And that's not for any reason other than that's long been the rule from Skidmore versus Swift. That case was decided 4 decades before Chevron, and these considerations are basically the ones that have woven themselves into various steps under Chevron. So when courts are determining whether Chevron applies at all to the agency's interpretation under so-called step 0, whether the relevant statutory language is clear or clear enough to unambiguously prohibit the agency's interpretation at step 1, whether the interpretation is reasonable under step 2, these questions arise. Of course, the difference is that when courts defer to the agency's interpretation under Chevron at the end of all this, they accorded the agency's interpretation controlling weight. And that is exactly what noted, have studied, makes a difference. So it turns out, as they shared with us, that agency interpretations are significantly more likely to prevail under Chevron deference than under Skidmore deference, and especially under de novo review. So deference matters. It also matters in another way that we've touched upon. Deference per se prevents agencies from losing only in the short term. Only Chevron deference prevents them from losing interpretive authority for the future. So even when a court defers to the agency, it only gives the agency's interpretation the power to persuade, and it decides the relevant question, not the agency. The issue of institutional authority doesn't matter much. It doesn't matter always. It doesn't matter much in particular when the agency's interpretation is longstanding, when the statutory language requires a determinate meaning and it's not likely to change. Then the precise level of deference doesn't make that much difference. And this is something that Justice Breyer observed in 1989 before he took his position on the Supreme Court. But usually, in the typical cases to which I refer, the ordinary questions cases, deference matters a lot. Agencies need the flexibility to modify, replace, rescind their interpretations if underlying circumstances change, whether those circumstances are scientific, technical, economic, social, or political. This flexibility is the hallmark of the administrative state. That's a quote. It comes from Justice Scalia. An agency that lacks interpretive authority will have to take its chances of persuading the reviewing court to bless any new interpretation, plain and simple. Now, here's my prediction. My prediction is that deference of the controlling variety is unlikely to disappear after Loper-Bright, even if the court shuts down Chevron and requires de novo review for questions of law. The reason is that judges may feel conflicted about deciding a question independently when deference matters the most. And that's when, in these typical cases, the interpretive dispute comes down to a policy disagreement. These cases tend to have common features. First, the relevant statutory language neither prohibits the agency's interpretation nor requires another. Second, the agency's interpretation is specialized in a concrete, identifiable sense. So, it involves the evaluation of empirical studies or statistical data. It involves fact-finding based on experience with the statutory scheme. It involves the selection or application of decision-making methods. It involves the identification of discretionary factors relevant to the decision, or it involves the choice between or among policy options. Judges know that these are not the sort of matters that they normally review de novo, and not just because Chevron said so. These factors come right out of State Farm, that other case. State Farm, which tells courts not to substitute their judgment for that of the agency. And the Supreme Court has continued to reiterate that message in full. State Farm is an elaboration of the arbitrary and capricious test of the APA, but it establishes strong norms of judicial behavior. And Chevron enforced those norms on the statutory interpretation side for 40 years. If Chevron is no longer available to enforce those norms, judges may begin to consider, whether consciously or subconsciously, whether State Farm should step up. Put differently, judges may begin to ask whether the agency interpretation is more appropriately understood as a policy decision to which State Farm applies. Now, that's not step 2 plus State Farm. What that is a choice between doctrinal regimes. Is this a Chevron case or is this a State Farm case? Lower courts have not had to think that much about it. Chevron bossed its way to the front of the room, and so courts applied it. And in doing so, Chevron became the dominant doctrine. And there was absolutely no harm in that when Chevron and State Farm pointed in the same direction. Now, that doctrinal regime choice is the difference between, possibly, de novo review and deferential review under the arbitrary and capricious test. And that choice is going to weigh on judges. Now, many cases are obviously straight up Chevron cases. Nobody would disagree that they involve statutory interpretation, but many cases that involve statutory language are really statutory implementation or policymaking cases. And here's the thing. Chevron has been cited twice as much as State Farm. So twice as many interpretive questions as policy questions under regulatory statutes. And they've both been cited a huge amount, 19,000 to 8,000. But that's a big discrepancy. And this is very, very impressionistic, but so are predictions. What's in that discrepancy? Are there cases in there where the courts defaulted to Chevron instead of asking whether Chevron applies? Are there cases in there where the court hedged its bets and applied both Chevron and State Farm, but didn't decide which one applied? We don't know. But the discrepancy prompts questions at the very least. And it may sit with lower courts to decide. Lower courts, at the end of the day, get to decide the effect of Loper-Bright. And they may moderate its effect if they step back and they think about what they are looking at and whether they really are confronting a Loper-Bright case or a State Farm case. Now, again, predictions, dangerous. Will that happen? Is this just my imagination? Well, this short comment is not offered as any kind of apology for overruling Chevron for many of the reasons, the stare decisis reasons that we heard in the last panel. What it is to say is that it's not the end of the game, that courts will still have to step back, and they do have the competence to decide what sort of case they're looking at, which standard of review applies, and they do not need to accept the party's characterization. That they can review de novo. Now, if courts want to decide cases for the agency or against the agency, they will, but that's not because of Loper-Bright. They could do that under Chevron. Loper-Bright will just be a new tool. So I guess I'll conclude at the end of the day by backing off the idea of prediction. I stick to the idea that statutory interpretation in typical cases will pretty much look the same, whatever that means. But I hope in typical cases where statutory interpretation fairly runs out, that lower courts will feel the conflict in appreciation of the norms that have been around for longer than Chevron, and think about, critically, what sort of case they're looking at. Thanks.
Okay, thank you. Professor Duffy. Okay, thank you very much. And thank you for those remarks, because I think they lead naturally into my remarks. I think I agree with the view that a change, and even a change to de novo review, which I support, might not make as much difference as people make, because Congress delegates a lot of power to some agencies. But if I had to say what's really wrong with Chevron, and I articulated this in an article some years ago, I'd say that it's similar, but it's on a completely different track. As Tom Merrill said, and I said this in the article, it's like Chevron is judge-made common law about how we should handle administrative review of agency actions. But there is a statute, a comprehensive statute that the court has said over and over again should be the basis of all judicial review. And I think that statutory framework, which is the APA, of course, lays out a very clear framework for evaluating Chevron and other cases, including the Loper-Bright case, and I'll take your convention Although one might say maybe you should say it's Loper bright if they overrule Chevron, because I think it would be a bright spot. It's relentless if they affirm Chevron, because it just keeps coming at you. So maybe that should be the decision that they use in judging the caption. But I think that if you look at Chevron itself, there is a pretty clear way to evaluate it. And I will say on the stare decisis question, I don't think that this is stare decisis, because the key question is, what does the APA mean? And the APA wasn't even cited to the court in the merits briefing. And I think there is law about stare decisis. Stare decisis law says explicitly, this is Supreme Court precedent, questions which merely lurk in the record, neither brought to the attention to the court nor ruled upon, are not to be considered as having been so decided as to constitute precedents. So the crucial question is, what does the APA mean? And I'm assuming that in a choice between judge-made common law and statutes, the statute actually should prevail. This is a common thing that happened in judicial review in the late 20th century, that the courts just treated the issue as an issue of common law, that they can make up the law. That's changing now, and I think a watershed case, and this is in my earlier article, is Darby versus Cisneros, which dealt with the exhaustion doctrine, and the court expressed surprise that, gee, this issue about the meaning of a provision of the APA has, been unnoticed for 40 years. And the leading commentator on administrative law in the mid-20th century, the leading treatise writer, said this is traditionally ignored by courts. The statute is simply ignored by courts. And I must say that was true in that case. It was absolutely true. The amazing thing is the lower court ruling in that case never mentioned the precedent, never mentioned, the statute. And you might think like, oh, well, the parties didn't cite the statute. In that case, you go down, if you were to call for the record and look at the briefs, you'd find that that was their number one argument that they devoted the bulk of their appellate brief to. And the court ruled as if it just didn't exist. The Supreme Court reversed unanimously and said the statute controls, not the judge-made common law. And I think that's what the court should do here. The court should evaluate Chevron and evaluate the doctrine using the APA. That's what should replace Chevron. I have a very clear answer as to what should replace Chevron, and it's the APA. And I think the APA framework works very nicely. Here's three specific things that are really wrong with Chevron. First, the court said that it treated the issue as a matter of interpretation. That's not at all what was going on in Chevron. And I encourage people to look at the actual rule that was signed into regulations by Ann Gorsuch. By the way, that's a little factoid that some people in DC know, but I think it's a fun thing. It's Justice Gorsuch's mom who signed the order in Chevron. And I think it's legal under, obviously it was sustained, the legality of it was sustained unanimously by the court. I think the order is legal under the APA too. That rule defines stationary source. We often say sort of generally, oh, it's a bubble concept. The word bubble doesn't appear in the regulation. And here's the regulation. It says, look, in order for this to be the same source, we're going to group all the pollution-emitting activities which belong to the same industrial grouping, are located on contiguous or adjacent properties, or controlled by the same person or persons under common control. Let me tell you, that is a lot of detail. You can't look up a dictionary for source or stationary source and get all that detail. And as if to top it off, you might say, what is an industrial grouping? Well, the regulation tells you. An industrial grouping is the one that's a major group, which means the same two-digit code as described in the Standard Industrial Classification Manual 1972, as amended in its 1977 supplement. There's no way a court would ever come up with this complex a definition if it was engaged in what we know as interpretation. They would never look to some 1972 as updated in 1977 industrial grouping to try and sort of put sources together. It's just too complex. This is an act of legislative rulemaking, which of course it was. So it's really about the question, the correct question is not interpretation, it's about the exercise of delegated lawmaking power. And the second thing I'd say is that the court says, another major thing that I think the court says that is just really misleading, So the court says sometimes legislative delegation to an agency on a particular question is implicit rather than explicit. This, again, has nothing to do with Chevron. Chevron, the EPA, had an explicit rulemaking authority that was quoted in the brief by DOJ defending the agency in full, right up towards the front end of the brief, because that is the predicate to engage in this. It's not interpretive power, it's legislative rulemaking power that's essential to write this complex definition of source. And that's clearly what Congress wanted, because after all, if you leave a crucial term in the statute that the agency needs to know a definition of in order to begin licensing, and you give the agency a rulemaking power, this is an obvious target for something that simply has to be defined. And then finally, the court said, and this is often summarized, and if you look at the language of the opinion, it's a little more nuanced, but the judges are not experts in the field, neither are they part of either political branch of government. And this is often summarized in sort of what is Chevron to say, well, agencies are to be preferred because they have expertise in political accountability. I think those are decent reasons that Congress may want to give an agency significant delegation of power, but not always. So, for example, the area of regulation that I study and have a casebook in is the patent system. That's unusual for administrative law people. They often look at environmental law. But if you look at the patent system, Chevron has never applied even to core terms in the patent statute that are very, very hard to define and occupy lots and lots of case law, like what is a non-obvious invention. That's crucial. That's considered the crucial gatekeeper to getting a patent. The courts never defer on that. And yet the agency has political accountability. It's in the Department of Commerce. The head of the agency is nominated by the president and confirmed by the Senate. Go see Arthrex if you want to know more about the agency. But it has tremendous political accountability. And talk about agency expertise in an area that's both legally and technologically complex. I mean, that would seem to be the bullseye of where Chevron should apply. It doesn't. Why? Why not? Because Congress chose not to make this agency powerful. It didn't give it delegated lawmaking authority, generally. That's true historically. You could write a whole article on this, because I have. But the thing is that, sometimes agencies, or Congress makes choices about how much power to give a particular agency, and this metric about political accountability and expertise is not necessarily a good guide. Crucial to my thesis is it is a congressional question, how much power to give an agency. And it's true that the EPA had a lot of power and could define stationary source reasonably. And that means that the order was legal, but the analysis is just completely sideways to the statute. If you want to know more detail, one of the things that's interesting is why didn't people cite the APA? DOJ didn't cite it because, they weren't so wild about it. They knew that, one might think they knew that there was some danger in that first sentence that says courts shall decide all issues of law. And if you look at the legislative history and other things, if you look at judicial precedents that bother to interpret Section 706, they were relatively uniform, saying it's de novo review. The petitioner, so the respondents, DOJ didn't say it. The respondents actually their amici at the cert stage actually cited 706. But they cited the arbitrary and capricious test, actually. And they said something really interesting. They said, boy, the DC Circuit is really beginning to have this test that's very stringent. See this State Farm case in the lower court that they've done this awful thing of overturning an agency. And of course, that was 1983. In the spring of 1983, the cert gets granted in Chevron in May of 1983. In June of 1983, the State Farm decision comes out and affirms the DC Circuit's overturning of the agency rule there. So suddenly the petitioners realize, gee, Section 706 may not have some great stuff in it for us. We're going to stay away from it. It's not clear why the respondents didn't cite Section 706. I think as a strategic matter, they maybe they thought that a common law approach to this was the way to go. They spent most of their brief trying to explain the complex statutory system to the court, and they might have thought that was their best thing to do. I think the way the court should have decided it is the following way, and I think this is straightforward. This is just following the APA. First, they should have looked at the agency action and realized this is the legislative rule. This is not about interpretation. You don't get all these details without actually legislating. Then you have to go to a provision that people don't often go to, which is 558B, which says that agencies can issue legislative rules in jurisdiction delegated to the agency and as authorized by law. So in order to have a legislative rule, you not only need it to be in the general jurisdiction of the agency, like the patent system is within the jurisdiction of the PTO, you need to have some authorization by law. If they looked at the Clean Air Act, they'd find it. They'd find the general rulemaking power that the EPA administrator had. And they would look at that statute in looking for the delegation. They would be exercising de novo review. They find the delegation, well, then they turn to Section 706 2A and the arbitrary and capricious test. They say, this agency does have the power to write rules, pretty broad power, pretty unencumbered power to write rules. Is this rule reasonable and reasonably, is it a reflection of reasoned decision-making, which is something that the State Farm case had just decided. One of the odd things about Chevron is it creates this parallel world. And step two, there's this huge lower court and Supreme Court sort of back and forth about, well, how does step two relate to the arbitrary and capricious test? And I think you can simplify the law by just saying you have to apply the arbitrary and capricious test. One thing about this theory is it actually, by forcing courts to look de novo for the statutes, it actually says, look, there's not simply one mode that Congress delegates power. There's agencies like the PTO that don't have a lot of power to define key substantive ambiguities in their statute. The EEOC is another one, although it's gotten more power as time goes on. So Congress originally wanted it quite powerless and toothless. It's added power. The EPA and Chevron is kind of in the middle. I think that is probably where many agencies lie. And then the interesting thing about this delegation point is that it explains agencies that have super rulemaking powers, like the FCC and the Secretary of Education in the Biden versus Nebraska. It says sometimes agencies can overrule explicit, clear statutory language if they have one of these broad rulemaking powers. And I think that is, sort of, again, we're focused on delegation. We're focused on how much power Congress has given us, given the agency. And that's a de novo question. And by the way, I'm running short on time, but I want to say two more things. That's very similar to not only the Chief Justice's view in the city of Arlington, but also Justice Breyer's view in the city of Arlington, both of whom say that the courts have to decide independently delegation, not jurisdiction. That case was sort of brought up in a weird way, and the advocate was arguing about jurisdiction. If you look at the Breyer opinion and the Chief Justice's opinion, they talk about delegation. So finally, I want to conclude about how this applies in Loper Bright and Relentless. And I really think this is extremely important, which is that if you look at this statute, one of the interesting things, the statute that's involved there, is that the statute actually begins in Section 1, it lays forth principles, and then Section 1B, and it's actually 1851 and 1852, or it's Section 1, 2, 3, 4 in the 1850s. But I'm just going to say Section 1 of this part of the statute says, here are the standards for these fishery plans. B, subsection B, within that first section, says the Secretary shall establish advisory guidelines, parenthetical, which shall not have the force and effect of law. That's an unusual thing to see in administrative law. Based on national standards, which are the things just applied to assist in the development of these fishery management plans. Very unusual, and I actually went back to the legislative history, which I know is verboten for an ex-Scalia clerk, but I did it anyway. That parenthetical was added by amendment in 1983, and that amendment says, the committee, this is a committee report, intends that the national standards themselves, and not the interpretations of such standards as contained in any guidelines, are the basis for the adequacy of the particular plan to be judged. Then if you look, so that I think is a huge, really unusual, it's a very good indicator that this agency is on that one side of the spectrum with less deference. And if you go through the other sections, which I don't have time to do, but maybe we can do in the question and answer period, you actually see that they have a very, odd notice and comment process where the secretary has to promulgate the rules that are produced by these councils, which are staffed with, at best, inferior officers. So to actually think this agency has broad power seems completely contrary to the statute. And I think that's the key thing here. We should look at delegations de novo. And that, in this very case, is the poster child for what's wrong with Chevron. Lots of people have assumed this agency, it has some sort of rulemaking power, so that's good enough. They haven't looked carefully about this agency's delegated power. If you do look closely at its delegated power, you find that it is not like the EPA and should not get a strong form of ability to write powerful rules.
Thank you very much. Professor Walters.
Great. Well, I've very much enjoyed the remarks of my co-panelists. I should say at the outset, be really honest, I hesitated to accept the offer to attend this symposium because I was skeptical that there was anything novel that could be said about Chevron. It really is well-trodden terrain. Just about everybody has a take on it, and I've tried to resist writing about Chevron. But I couldn't help but be drawn to this for the opportunity to articulate a political scientist's version of the Chevron story. I'm half political scientist, half lawyer, so I'm very sympathetic to the power of political science as a predictive model, and that is the goal of this panel. So I want to articulate what a political scientist might think about the Chevron doctrine and its likely future. And you heard a little bit about the political science approach to things on the first panel, the attitudinal and the legal model, and maybe this is a fundamental disagreement that only lawyers are going to align with the legal model and only political scientists are going to align with the attitudinal model. In reality, it's a lot more complex than that, and I want to show you why I think there still is a lot of analytical purchase for more of a combined approach to those two things. So let me launch into it. I think we have to understand that at the very beginning, Chevron was very politically contingent. Okay, it's quite explicit at the outset of the Chevron doctrine. You can see that in Justice Scalia's writings. Before he was even on the bench, he very much acknowledged that Chevron was quite beneficial to the Reagan Revolution that he anticipated was about to happen. He talked about how, judges seem painfully unaware that the unelected bureaucrats are now our unelected bureaucrats. I'm paraphrasing, but it's basically that. Right? So I think, Justice Scalia very much understood the political terrain at the outset of the Reagan Revolution and saw Chevron as sort of in line with his policy preferences. I think, as we now know, work that Tom Merrill has done and others have uncovered, what I would characterize as a strategic misstep by Judge Wald in cementing the Chevron doctrine, given her preferences, which very much cut in the other direction of Justice Scalia's. She thought, I think mistakenly, that Chevron could be beneficial for more liberal judges at the time. That turned out to not be entirely true, but it happened to allow Justice Scalia's project of Chevron to take hold. What happened was pretty quickly after the cementing of Chevron deference, the Reagan Revolution, of course, somewhat dissipated. I think it's still with us to some degree, but we entered a period of fierce competition for the presidency, which scrambled some of the predictions that had led Justice Scalia to so confidently say that Chevron was going to be beneficial for his political preferences. So understanding that story, I think, is essential. We can debate the doctrine and the formalistic elements of Chevron all day, but it was born out of a sort of political compromise. So what I want to do in my essay, and what I've tried to do in the draft I submitted, is to try to model this a little bit in the way that a political scientist would do this, thinking about judges as preference maximizers and as efficient allocators of scant resources for deciding cases. And if you think about it, one of the reasons why Justice Scalia was drawn to Chevron is because it's a kind of shortcut for judges in certain situations. namely when there's going to be an alignment between the judge and the agency that is going to produce a rule or a policy that is in alignment with the judge's policy preferences. If that's the case, then the judge need not invest a lot of time and resources to justify the statutory interpretation de novo. They can cite Chevron deference and very quickly move on and basically piggyback on the agency's work. So if you take that model seriously, that judges are trying to maximize their preferences, but they're also trying not to waste effort, Chevron makes a ton of sense in those situations where you've got agencies and courts aligned. The problem with the shortcut, though, is that it's not always applicable. Right? So sometimes the agencies are going to disagree with judges, right? Namely, when you have a new administration coming into town that maybe is misaligned with the judiciary. And so in the paper, I argue that the utility of the shortcut is going to depend on the judge's views on two dimensions. And if it's possible, can I get the slide that I shared up on the screen? So the two dimensions that I identify, and this is a very simple model, by the way. There's more that you could add to this, but I still think it has some purchase. But the two dimensions that matter here for a judge trying to evaluate the utility of the shortcut are first the allyship question, whether agencies are likely going to be aligned with the judge's views in terms of policy preferences. And then the second dimension is the certainty of that prediction over time. And this is, I think, where I would diverge from Tom Merrill's assessment, and I think Chris Walker's assessment of the political model in the first panel. That dimension of uncertainty over time is part of what does the work to allow this political model to work, notwithstanding what we did see about Republican judges following Chevron during the Clinton administration, for instance. This is a more slow-moving kind of thing, and it involves estimates of the uncertainty around this prediction of allyship or opposition. So if we combine these two dimensions that judges are going to think about when assessing the utility of the doctrine, I think we can create this 2x2 contingency table and see how the dimensions interact. Right? So just to walk through this really quickly, it seems like Chevron deference, a relatively strong version of that, is going to prevail when you have a high level of certainty of future allyship between the Supreme Court and the president over a period of time. Right? So I'm not, again, talking about individual one-off administration changes, right? Because a judge would never want to change the doctrine on a dime when a new administration comes to town. That would look quite unseemly, right? They're trying to make a prediction about the certainty of alignment or opposition over time. So yeah, when you have this prediction that there's going to be a lot of alignment over a long period of time, you're going to have Chevron deference. It makes a ton of sense to utilize the shortcut. As you start to relax that assumption of high certainty, you start introducing uncertainty. You are going to move into some exceptions to Chevron, right? So what I would characterize as weak deference is really a Chevron, but with exceptions like for the Meade test, right, where we start to carve out things and treat them separately with Skidmore deference. I think then you would move, as you move into an expectation of future opposition, but with still somewhat low certainty or high uncertainty, to more of a weak anti-deference position. And that might be across the board Skidmore respect for agency decisions. No more preservation of any domain for Chevron deference in its strong form. And then finally, only in a situation where you really have a prediction of future opposition and you're quite certain about that, would you move into the direction of, say, de novo review, completely eradicating Chevron deference. And while this model is not perfect, I'm not making that claim, I do think it fits the data pretty well. It certainly fits Chevron's founding moment pretty well. It also fits the subsequent meatification of Chevron pretty well, as rising political competition through the 90s and the 2000s sort of raised uncertainty among the justices about the predictions of allyship or opposition. It also, I think, explains why we have arrived at this moment where Chevron is on the chopping block. We have a growing rift between the court's ideological predispositions and those of the elected branches, and especially the executive branch. Something seems to have shifted to a prediction of future opposition. Still high uncertainty, low certainty, but a prediction of opposition. And that might be why we're considering moving onto that right side of the table that I shared a little while ago. So the only thing that remains to be seen, I think, and which Loper Bright will tell us the answer to, is the extent to which the justices have high certainty that this is the case, or whether they have some doubts about that. And I think, this model, if nothing else, can maybe give us a little bit of a prediction about how the court might adjudicate between going to full de novo review versus some kind of Skidmore deference. The final part of the paper tries to put this model in the context of what we know generally about politics, and in particular, regime politics and time. It turns out that each of the four possible futures of Chevron is not made equal. Allyship, I think, is far more likely than opposition because of regular replacement of justices by sitting presidents. This is something we know about how our political system works. It goes back to a hypothesis that Robert Dahl, a very famous political scientist back in the middle part of the 20th century, identified. There's never much of a tension, or there isn't often much of a tension between the court, the Supreme Court, and presidents because of that opportunity for regular replacement of justices. In normal times, we know this historically, one party tends to dominate the presidency for a substantial period of time, oftentimes decades at a time. For a long time, Democrats dominated the presidency through periods, and at other times, Republicans dominated it. So that makes it relatively easy to make that kind of prediction, and that has natural consequences for the ideological slant of the Supreme Court. I do acknowledge in the essay that some have argued that we've arrived at a new normal, where this pattern of regime politics, a close relationship between the president and the Supreme Court, is eroding and is unlikely to prevail going forward. In other words, this current Supreme Court, these scholars argue, is out of touch with the current dominant lawmaking coalition, and that's why we're seeing a lot of these splits. It's a sort of historical anomaly from the traditionally occurring pattern. I would say that it is just that, an anomaly. There's no reason to think that this is going to go forward, I think it's quite likely that we'll see the traditional pattern revert, where we do see that alignment between the president and the Supreme Court. Sure, we have partisan competition for the presidency, and we've had that for some time, but that primarily affects the uncertainty dimension. It doesn't really undermine the pattern of allyship. And it would be hard to tip things, I think, into an expectation of opposition, since over time, any anomalies that lead to a divergence between the ideological preferences of the court and the ideological preferences of the average president will normalize. Thus, if we believe that it's true that the Supreme Court will not usually, for long, be out of step with the executive branch on matters of policy, we ought to generally expect Chevron, either with or without exceptions, to prevail. To be clear, it seems likely that we're going to see more uncertainty than uncertainty about the predominant expectation of allyship due to this continued fierce competition for the presidency. But I also argue in the essay that there might be reasons to think that this will change over time, right? There are demographic advantages for Democratic presidential candidates over Republican presidential candidates. They're balanced out to some degree by things like the Electoral College. Political scientists write about this. It's very familiar literature. But it does seem like Democrats have a little bit of an advantage going forward, and that could create at least a temporary mismatch, and maybe one that lasts at least 10, 15 years between the Supreme Court and the dominant party for the presidency. But again, overall, I see a reversion to the historical pattern, which would suggest suggest that we're going to remain on that side of thinking about a large degree of allyship. And the question, therefore, my prediction ultimately, and again, I agree everything with what Lisa said about how dangerous predictions are. But if I was to predict things, I would say we're probably just going to see more of the same from the court, working the way that it did in the Meade case and other cases to carve out exceptions for Chevron, rather than getting rid of it entirely. And I think with that, I'll go ahead and stop.
Okay, thanks very much. So I was intrigued by Professor Bressman's suggestion that rather than reflexively, view everything in terms of Chevron, we should ask, is this a Chevron case or is it really a State Farm case? But if 10 years from now, no one's talking about Chevron and State Farm has become the new Chevron, then wouldn't some of the same arguments that are now being brought to bear against Chevron just be repurposed against State Farm?
I think that's right. So at the end of my essay, I talk about what's to become of the arbitrary and capricious test, and there are parallels to some of the major State Farm decisions and the major questions doctrine. Yeah. And that's where the Supreme Court has started to show some muscle under the arbitrary and capricious test when the presidential administration is doing something opportunistic, perhaps is a good word. So if the arbitrary and capricious test ends up creeping in the way that some predict the major questions doctrine will, yes, some of these problems will arise. But I just want to offer, so that's the end of this essay, sort of a courts can moderate, but let's see if the Supreme Court moderates what lower courts can do. I do want to say one thing, which is that how agencies write their regulations matters, and this came up in the prior panel, excuse me. So if we look not only at the statute, but we look at the substance of the agency's interpretation when there's a record, and you see exactly what the mechanics to implement the statute at issue in Chevron, you would see that it is not something, as John said, that a court could do. And it's not because the court lacks competence. It's not a sort of they're not smart enough. It is in part because they have voluminous dockets and docket pressure, but it's also because they just know. If we talk separation of powers, they just know that they shouldn't be making those kinds of decisions or even second-guessing what the agency has done. And that can be a cooperative relationship that ends up in deference under the arbitrary and capricious test, which comes from the APA.
Okay. I started off with questions. I should have asked whether any of the panelists wanted to say anything in response to what's been said before I start into my questions or audience questions.
I will say one thing in response to the political science analysis, which I think is interesting. I'm not so convinced that drives courts. I mean, I've worked for judges and talked to judges. I think that doing the political calculus is hard. I think Judge Wald, wasn't wrong. She was visionary, right? Because by the 1990s, people are on the left realizing Chevron is a great tool. So she was right. This could be a great tool for regulation. It depends on who the president is. And she probably thought that the agencies could do a better job than her court could do. So maybe that's why she supported Chevron. I do think one political science thing is true. We had a lot of questions on the last panel about why not amend the APA. And the last time I was on, I think it was the last time or the time before, I was on the Hill testifying to the House about, getting rid of Chevron legislatively. And, there was the Republicans who were pushing a bill, and I was one of the Republican witnesses. And that was like 2015 or I guess it was 2016. And as soon as the 2016 election occurred, all resolve to overrule Chevron on the Republican side suddenly vanishes. And that, I think, is pretty clear. If you ask why does it have to be done judicially, it's never going to be high on the president's agenda to decrease deference to his administration or her administration. That's just not going to happen. And you might say, well, the president only has a veto, supermajority could overrule. It's not going to be high on the agenda of his or her party either. So the idea that you can overrule this, or change this legislatively, I think is fictional, and the courts have to say, well, if Congress wants to go the other way, and if we're wrong in Loper Bright or Relentless, whatever we say, Congress can change that too. And I think that's kind of a make-weight argument that you could tack on to every non-constitutional case. Simply say, if Congress doesn't like this, you can overturn it. But the courts, especially in an issue like this, are going to dominate what the law is.
So just really quickly in response to that, I realize it's probably not a popular position in this room among so many lawyers to make the case that judges are political actors. And judges, yeah, no. Not except for you, right. But look, I mean, the evidence is overwhelming. Political scientists who have looked at the data, it's a complicated story. It's more complicated than simply looking at the parties and making a decision, I like that party or I don't like that party. They're thinking more strategically and more over a long period of time. And in fact, they're even making political choices about doctrine, assuming that doctrine is going to shape the behavior of judges, and especially lower court judges, right? I don't think it's too far to say that judges are thinking politically in that sense, right? Not in the sense like I want to reward the party that I like in this case, and I'll just forget about doctrine and do whatever I want. That's a simple attitudinal model, and that has been pretty much debunked by political scientists. There's an entire body of work that takes the strategic choices about doctrine much more seriously, but we can't make any mistake that that's still political action in a sense, right? I agree with what you said. I mean, judges would never own up to this, right? And for good reason, right? Because it has some potential impacts on legitimization of the courts. But I think there's a lot of value in taking a step back and looking at the entire Chevron saga and realizing that it is part and parcel of this larger pattern that political scientists have very well documented. Doesn't mean it's a conscious thing, doesn't mean it's intentional or nefarious, it just means it's happening. And I think we do get some purchase out of assuming away some of the baggage of the legal model, the unadulterated legal model, and trying to think in a more realistic sense about what judges are doing.
But my main point was that the political branches are going to behave politically. And you agree with that, right?
I agree with that,
agree with that, and it's going to be very hard to overturn Chevron with any, thinking president.
Absolutely.
In the White House.
Yeah.
So Chevron has been around for 40 years. On the stare decisis angle, I don't know how, I'm not sure that's venerable. That was almost before I started law school. I hope that's not venerable. But before that, there were 40 years when there was no Chevron, but there was an APA, Professor Duffy. So what if we just went back to pre-Chevron, to the 40 years of APA practice, what would that look like?
Well, during the 20th century, mid-20th century to late 20th century, there was something that Judge Friendly called the new federal common law, and there was an extraordinary enthusiasm for just generating judge-made law. Judge Friendly said something like, we're eager to generate law based on the smallest bit of statutory language or the smallest bit of legislative history. We're off to the races. I think we've left that era behind. If we look at big pictures, I think, if you say to a court, well, you should just decide this and not concern yourself too much with, some statute called the Administrative Procedure Act that was passed unanimously by Congress. That's sort of a off to the side sort of thing. You really should judge this yourself. I think we're not in that era anymore. Yeah. And so even in the 20th century, the interesting thing is that, Section 706, you did have pretty clear statements. So for example, the chairman of the House Subcommittee on Administrative Law, who was authoring the House Committee report on the bill, said the following about Section 706. Said it requires courts to determine independently all relevant questions of law. I mean, that's pretty clear legislative history. And if you look at, lower courts, when they looked at Section 706, they said things like this. This is the Ninth Circuit in 1952. In enacting the Administrative Procedure Act, Congress did not merely express a mood, that's referring sort of a sideways reference to a Supreme Court case, that questions of the law are for the courts rather than the agencies to decide. It's so enacted with explicit phraseology. You can't find a case pre-Chevron that says, 706, that means deference. You just can't find that. You find actually multiple cases that when they read Section 706, say it's de novo review. The most amazing thing I found in writing this article, which was more about this general phenomenon of administrative common law that displaces the APA, is that even after Chevron, lower courts, when they're actually called to the attention of Section 706, they interpreted it as de novo review. In other words, if you didn't mention Chevron and just said, well, wait a minute, look at 706, that's statutory text, what does it mean? Courts repeatedly said, oh, that's a codification of de novo review. So you have these ships passing in the night of, what does 706 mean and, what does the common law doctrine mean? Maybe one way to solve the stare decisis conundrum is say, well, in any case that, either the APA doesn't apply or where nobody cites the APA, then Chevron applies. How about that as a solution to, say, well, then, that's exactly what happened in Chevron. And that's what the court decided. What should be the rule of deference if we have no APA? That's what they decided. And that's all they decided. And if somebody does cite the APA, well, then we have to pay attention to the APA.
It seems like part of the frustration for example, the Loper-Bright petitioners is that under Chevron, reasonableness is too low of a bar. Reasonableness, if you think about con law, it's like rational basis. It's almost no review at all. It's abdication. So if the Supreme Court were to abandon the Chevron reasonableness standard, but realizing that de novo, and if they weren't inclined to do de novo review because of some of the reasons that were expressed on the first panel, it's hard, it creates circuit splits, it's a lot of work for everyone. What would be the next best standard?
Well, I think that there's actually a split in the lower courts, and this is not my work. This is, again, the excellent empirical work of Ken and Chris, showing that there's a variety of interpretations of reasonableness, and sometimes it's arbitrary and capricious review, and sometimes it's a free pass, and sometimes it's hypertextualism. So it would really help if the Supreme Court told lower courts where to go. I think my reading is that the predominant view is the arbitrary and capricious review, but I've got a really, really long footnote in this little bitty essay that lays out the disagreements or sort of weak points, I would describe them as, in the lower courts, let alone in the scholarship. There's very much discussion. So I think the idea that Chevron deference is a free pass to the agency, that's a toss-up, and we could surely use some clarity on the question.
Professor Duffy, you said at one point we should look at delegation de novo, which sounds like a path eventually to revisiting the non-delegation doctrine. The more courts look at delegation de novo, is that a fair prediction?
It does not, no, because I actually think that even under Justice Gorsuch's view of the non-delegation doctrine, a delegation like the EPA has, which is to fill in a reasonable definition of stationary source, passes with flying colors. I just think the court, in looking de novo at delegations, will find more variety than perhaps that Chevron thinks. And I think that's the crucial thing. Now, if you give too much power to an agency, then I think you do bump against the non-delegation doctrine. And I think that's one of the reasons why you should interpret, even on the far extreme of power, these super rulemaking powers that give the agency the power to override clear language, to modify it. I think that's a really powerful reason. The non-delegation doctrine is a really powerful reason, using the canon of constitutional avoidance, to simply interpret that the way the court did in the FCC case, which says, modify means small change. And they basically said the same thing in Biden versus Nebraska, too. And I think that's right, because if you say, modify means rewrite the statute, and that's okay, then you have a very serious non-delegation doctrine. But I think, in the vast majority of administrative statutes, we're pretty comfortably within the range of certainly the modern non-delegation doctrine. But even Justice Gorsuch's test really just, it gets off a few statutes like the the SONRA statute of registering, where there's no standard at all, registering sex offenders retroactively. It picks off a few things like that, but not too many things in the EPA and stuff like that. But if it picks off a little bit more, I'm okay with that. I think the focus should be delegation.
Okay, we've spent almost all of our time before getting to audience questions. Do we have some? 10 minutes, good. Do we have some audience questions before lunch?
It's hard to see the audience with the bright lights.
I guess we're right then. Is that? Oh, okay. We just can't see. We're blinded.
We're blinded
Okay.
by the light.
Yeah.
Who's up?
Well, you're going to get all three relentless attorneys. I'm the third, Kara Rollins. On the what should replace it, one thing I'm always drawn to is haven't the states already answered that question? Since 2018, Wisconsin Tetra Tech, you've seen an increase in Supreme Courts rejecting deference, particularly on the constitutional aspect as being incompatible with the state constitutions. You've seen constitutional amendments in Wisconsin, Arizona, and Florida expressly rejecting it. And as far as I'm aware, the sky hasn't fallen. And for those not familiar sort of with the state deference regimes, California has never applied a Chevron type deference. So I guess sort of the question is, does a replacement have to be provided when we have all of this case law out there sort of answering this question already in the states as a poli-sci person, sort of the test of democracy at the testing that out?
So a really quick thought in response to that is, I'm not sure the states and the federal side are comparable in very important ways. And this gets to some things that were brought up on the first panel. A really big problem with overturning Chevron and replacing it with something else is how you deal with the inevitable circuit splits, the inevitable disagreement that you will see across a very large nation with very diverse preferences, very diverse policies. So that, I think, is a huge hurdle that it really is. I mean, it's still there to some degree in states, but the problem is really, it has boundaries around it, right? And so I'm a little hesitant to read too much into the experience of the states in implementing, some alternatives to Chevron, and then simply saying, well, the sky didn't fall there. It's really not comparable on that level, I think.
I think also, Congress legislates against Chevron. Agencies implement against Chevron. It's been that way since Chevron, which is to say 40 years. So the experience of the states might speak to workability, I suppose, of a new rule. But if we're talking about delegation, and we're talking about delegation under specific statutes, and in particular under specific federal statutes, I think that congressional intent controls, not state intent.
I think it's a great point, but and should be covered in the briefing of the cases that are at the court right now. So, I mean, that it seems to me important. It doesn't answer some of the questions, but it does answer the workability question. Again, I don't think that you'll get lots of splits, because I think the big picture question of is there delegated authority here could be answered at that level. And then you just have arbitrary and capricious review, which does lead to some splits, but there's actually mechanisms to reduce splits. So, for example, you can have consolidated litigation against there's a procedure to get consolidated litigation in one circuit when there's judicial review of a rule. So you're going to get, sort of nationwide nationwide decision that's going to bind the agency. And if the agency loses, the SG can always decide to take it to the Supreme Court. But I think actually the deferential standard in 706(2)A is going to control a lot of cases and won't lead to very many splits.
On the mechanism, really quickly, for constraining circuit splits and the like, I mean, I think one big variable that we don't have a good sense of right now is, how much the Supreme Court is going to tamp down on the shadow docket, right? I mean, this is a game changer in a lot of ways for the strategy of how the Supreme Court relates to the lower courts. And it greatly increases the capacity of the Supreme Court to resolve some of these questions. But we already have seen a lot of dissatisfaction around the shadow docket, and in particular, the use of the nationwide injunction. So, I think it's a big unknown what the court will ultimately do if it's ever squarely faced with those questions. It seems likely that there will be some kind of tamping down of those practices, which makes it very difficult for the Supreme Court to weigh in the vast majority of cases.
Or they can use summary affirmances, which is even more a concern, I think, so that the shadow docket would end up with a lot of summary dispositions. And historically, that norm has been really strong. Very, very few, very, very rare, egregious misapplication of existing precedent. So regardless of how we interpret that, I think an explosion on the shadow docket, not only with respect to nationwide injunctions, but with respect to summary affirmances, is something that I think the court will have to think about in terms of its public perception.
Or maybe they can hear more cases.
Or they can.
That would mean they'd have to work a lot harder.
I know that's not something to add to the briefs and Loper bribe anybody who's the petitioner's side. That probably is not the winning argument to convince the justices to overturn Chevron.
All right, I'm told we have 5 minutes. Can we try to get 2 questions in that 5 minutes? Professor Merrill has one.
Yeah, for John. So I agree with you completely that the courts need to decide de novo whether the agency has delegated authority. That's one of my big themes.
Right.
I don't think, however, that there was no statutory interpretation question in Chevron. The respondents, who had won, of course, in the D.C. Circuit, argued strenuously that the flexibility that the regulation gave to the states under the non-attainment provisions to choose the bubble concept or the individual aperture concept was that this was inconsistent with statute. And the statute for the non-attainment provisions did not define stationary source. It just said that it was a facility that emits more than 250 tons per year. But the respondents said, well, Section 111, which is another stationary source provision, does have a definition of stationary source, which is that it's any building, structure, facility, or installation. And I guess their argument was that under the Nostra Aetate canon, the word facility, which was the operative provision under the non-attainment provisions, should be defined in accordance with building, structure, or installation, which is the narrow sort of aperture kind of understanding. So there was a legal issue. It was rejected by Justice Stevens. He said, well, it could go one way or the other, but it was a legal question, and they ended up deferring to the agency. On the lack of enthusiasm during the after the Trump election for getting rid of Chevron, you will recall that the Separation of Powers Restoration Act did pass the House in 2017 and 18, and I guess in 2023. Now, maybe with not a lot of enthusiasm, I don't know, but they did pass it 3 times.
But do you think the president, any president, would sign that into law?
Well, the Senate didn't go along, so we don't know.
Yeah, we don't know.
And also, the Trump Justice Department seemed very, very reluctant to use Chevron in their Supreme Court briefing.
That's true. I think that this is one pushback against the political science, that things, at least in the courts and maybe even in the political process, have a certain, get a certain rationale behind them, and that carries through longer term, and that people, maybe they pick their issues strategically because they know a Democratic administration can come in later on, but there's sort of an intellectual history to some issues that carries on. I think that the legal issue, when you say that the court decided it in Chevron, I think that's a little inaccurate, because the court said it's up to the agency. So if a new administration comes in and issues a much more narrow definition of source, the very point of Chevron is that's okay too. And that's why I think that unless you find a delegation of power, which of course the agency had there, but hypothetically, if there was no delegation of rulemaking power, I think all you have to do is interpret what stationary source means, that it's fundamentally inconsistent to use a Chevron framework to say that can be consistent with Section 706, because you're not deciding the question. You're saying it's not our choice, it's the agency's choice, if it's a pure question of law. I think if you say what certainly Robert said in his dissent in the city of Arlington, that you first have to, and it's a respecting of Section 706, look to see whether there's a delegation of power, then I think you're respecting Section 706, because you're saying we are giving you de novo review of the law. The law is that within a reasoned decision-making framework, the agency gets to make the call. And that is the correct interpretation of the Clean Air Act.
Okay, we're done. Thank you very much. We don't want to get in the way of you and your lunch.
Oh, yeah. I'm watching him back there. Great. Okay. All right, everybody. If we'll take our seats, we'll get settled in for the keynote session. Well, again, on behalf of the C. Boyden Gray Center and my co-director, Jen Mascott, it's a real pleasure to welcome you all to today's event. We're so grateful to the speakers, the moderators, everybody, including all of you for joining us today. And in thinking about today's event, I thought back to the very beginning of the Gray Center, before Jen was here, before I was here, when Professor Naomi Rao first founded the center in 2015 and 2016. The first conference that she hosted at the center was on Chevron Deference. And in fact, a number of today's authors presented papers at that first conference. Chris Walker, Jonathan Adler, Aditya Bomzai presented his original papers on Chevron Deference then. A number of the original participants were unavailable. For example, our keynote speaker at that conference was Judge Brett Kavanaugh, who is unavailable, I suppose, for this conference, but may have a few things to say about Chevron Deference in the months ahead. And also, just thinking back over the last few years, we've been very proud to help support legal scholarship on these issues. A number of working papers that have come out of the Gray Center's roundtables. I thought about them during the discussions this morning. Randy Kozel wrote a paper, I think it was in the Texas Law Review, on Chevron and stare decisis and what it means to give stare decisis weight to a methodology rather than a substantive decision. Our most recent paper on the subject, it's on our website today, I think, is by Ron Cass on delegation, discretion, deference, and the separation of powers. But I can safely say that even after all the work that Naomi Rao and others have done in the center on Chevron Deference, all the scholarship and debates, this collection today of authors, of moderators, of judges, all of it brought together by Jen Mascott. I can safely say, and I know I'm biased, and Phil Hamburger would call it Chevron bias, but I can safely say this is the best symposium and conference on the subject, and never could have happened at a better time. And so please join me in thanking all the participants. And now it's my honor and pleasure to introduce our keynote speaker. Paul Ray is the he directs the Thomas A. Rowe Institute for Economic Policy Studies at the Heritage Foundation. He's also a senior advisor at Potomac Partners. But maybe more relevant for present purposes, he served as administrator of OIRA from 2019 to 2021. And before that, he was counselor to the United States Secretary of Labor. And before that, clerked for Justice Alito and practiced at Sidley, Austin. He too has a new paper that's up on the Gray Center's homepage today on the issue at hand. It's titled, and I'm pretty sure this is not a typo, Lover, Mystic, Bureaucrat, the Communication of Expertise and the Deference Doctrines. Paul, did I get that basically right? Okay, good. Anyway, he'll come up on the stage in a moment to offer remarks and then be joined in a keynote fireside conversation with our co-director, Jen Mascott. And let me introduce Professor Mascott as well. She's, of course, the co-director of the C. Boyden Gray Center, an assistant professor of law at the Scalia Law School. She served at high levels in the Justice Department. Since coming to the Gray Center, coming back to Scalia Law, she's founded a couple of our most impactful programs. The Article I venture focused on re-educating Congress on the separation of powers, and the Separation of Powers Clinic aimed at educating judges on the separation of powers. Before that, she clerked for Justice Thomas and Judge Brett Kavanaugh. I meant to add one more thing about Paul Ray, by the way. We're lucky to have him participate in so many of our programs. Just 2 weeks ago, he spoke at a conference on financial regulation, and I can safely say if we invite him to any more events, we're going to have to rename the Gray Center the Ray Center. So please join me in welcoming Paul Ray.
Adam, thank you for that kind introduction. Really a joy to be here with you guys among such distinguished company. I want to start today by sketching some lessons for the deference debates from the regulatory process as viewed from the inside. And my main goal is really just to convince you that the regulatory process has important insights to offer to the deference debates. Now, it's a point that's been overlooked sometimes, especially by the courts. Some of you may know Justice Kagan and Professor Barron's article back in 2001 on Mead, in which they said that the court's approach to deference treats agencies as unitary actors, each an undifferentiated black box from which decisions issue impersonally. Only the courts, they said, among those concerned with administration, routinely neglect internal agency structure. And they argued that this omission distorted the court's deference jurisprudence. So today, I want to build on and really broaden Kagan and Barron's insight in their article from 2001. The court's deference jurisprudence views the agencies as monads, each one a simple and solid whole unto itself. But in fact, agencies are not at all monads. Rather, they are made of many parts, and they are themselves parts of the broader executive machine. The court's view of the agencies as monads means that in the deference cases, it has not been asking all the right questions about both agency expertise and political accountability, the two primary bases for the presumption that Congress intends agencies to resolve ambiguity in statutes and regulations they administer. My goal here is not to argue for any particular position on deference, but really just to sketch some important questions that should, but at present do not, feature in the court's considerations in light of the realities of the executive regulatory process. So let's take up the expertise rationale first. That rationale goes something like this. Courts should defer to agencies when agencies have and use expert knowledge that enables a better interpretation of an ambiguous provision. In Chevron, the court described the expertise that warrants deference as, quote, more than ordinary knowledge respecting the matters subjected to agency regulations. The point is one of institutional competence. Agencies with expertise are better situated to interpret ambiguous text than inexpert courts. As the court put it in Kaiser, when the agency has no comparative expertise in resolving a regulatory ambiguity, Congress would presumably not grant it that authority. Now, deference may be appropriate only when the interpreting agency cannot reasonably transfer its expertise to the reviewing court. After all, if the agency could transfer its expertise by educating the court, then the court wouldn't have any reason to defer. It would simply evaluate the agency's interpretation with the benefit of the expertise the agency helps it to acquire. Doing so would avoid deference's indisputable costs, in particular the cost of making the government, at least in some measure, the judge in its own cause. Now, perhaps that's a cost we're willing to bear for the sake of the goods expert interpretation offers, but we shouldn't bear it if we don't have to. And we don't have to bear it if agencies can impart their expertise to courts. So courts should defer only when agencies cannot reasonably transfer their expertise to the reviewing courts. Curiously, the court's cases do not focus on this condition. Rather, they assume incommunicability. Agencies know something that judges don't, and between the two, a great gulf is fixed. We see this assumption, for instance, in the plurality opinion in Kaiser. The plurality uses an example in which they say that TSA is in a better position than a court to know why TSA bans liquids and gels and what makes them dangerous, which is undoubtedly true. But TSA could surely educate a reviewing court in those matters. The plurality simply assumes that because the special knowledge about liquids and gels and their dangers originates in TSA, that it has to stay there. So let's reflect for a moment on why courts might assume that agencies cannot share their expertise. It can't really be because agency expertise is incommunicable in principle, as is, say, knowledge of what it's like to see the color red. Try explaining to someone what it means to see the color red. If they haven't seen the color, they just can't know what you mean. On the contrary, Max Weber wrote, quote, in principle, a system of rationally debatable reasons stands behind every act of bureaucratic administration. So perhaps it is instead because the cost of agencies to express and judges to understand agency expertise is just too high, higher than the cost of deference. And this has a kind of surface plausibility to it. After all, often in daily life we rely on others, say doctors, engineers, and lawyers, whose judgments are based on special knowledge that is shareable in principle, but that neither we nor they wish to spend the time and effort and other expense to acquire. Here, I think, is where the monadic error that I referred to earlier creeps in. For an expert agency is very little like a doctor, engineer, lawyer, or any other expert person. A person with specialized knowledge can form a plan of action or recommendation without sharing his special knowledge with anyone. That's because the expertise resides in the same self as the will that makes a decision or renders a recommendation. But of course, agencies are not like that. Their expertise is distributed across the minds of their staff, and the decisions that the agency makes are also made in the minds of the staff. But unlike in a person, those minds, the holders of the expertise, the makers of the decisions, may not be the same. EPA has deep knowledge about the Clean Air Act, and it also makes decisions about implementing the Clean Air Act. But the minds that have the expertise may well be different than the minds that make the decisions. Indeed, that is very, very often the case. The main decision makers within EPA, the administrator, for instance, the various assistant administrators and other leadership, often, of course, have backgrounds in environmental policy and law, but very rarely do they have deep expertise in the subject matter of a given regulation. That expertise usually belongs to staff, to subject matter experts, or SMEs in executive parlance, who specialize in particular programs. For the SME's expertise to influence regulations, it must make the journey from the SME's minds to the decision makers within EPA. But it can't really stop there either. Their expertise has to also make the journey to the rest of the agency team working on the regulation and to all the other executive officials at OIRA and DOJ, at EPA sister agencies in the West Wing, whose agreement or at least non-opposition is needed for the regulation to go forward. Many of these officials will have significant environmental experience and education, but again, few will have the kind of expertise that the specialist SMEs do. What all this means is that the subject matter experts have to explain their expertise to others, including many non-specialists within the executive branch. As Professors Anya Bernstein and Christina Rodriguez wrote earlier this year, the regulatory process is permeated with norms of justification, explanation, and persuasion, and agency experts must comply with these norms if they are to shape the content of regulations. To be sure, sometimes these norms must give way to executive exigencies. As you might imagine, busy officials cannot afford to plumb every interpretation and every rulemaking down to its roots. But for an important interpretation, a critical mass of officials have strong incentives to understand why they should support and how they can defend it. And this means they have strong reasons to demand, and the subject matter experts have strong reasons to provide, explanations of the subject matter experts' expertise on which the interpretation rests. Agencies, then, are not monadic individuals who make interpretive decisions on the basis of expertise lodged deep in their own selves. They are instead groups of people who deliberate and who must therefore share their expertise with each other. The lesson for Chevron deference, and for our deference too, while we're at it, is this. Even if it is plausible that the cost for an individual expert to share his expertise with a reviewing court would be unduly high, that fact tells us very little about whether it would be unduly costly for an expert agency to do so. For the expertise that shapes important regulations is already being shared in the executive process. That agency experts already successfully communicate their expertise to non-experts within the executive branch is a reason to believe the additional cost for them to communicate it to non-expert judges would be modest. And that executive non-experts already acquire the expertise they need to evaluate arguments about interpretations within the executive branch is a reason to suspect that non-expert judges could often do the same. At the very least, it should be clear that the costs of disclosing the expertise that's the subject of deliberations within the agency are different than the costs of disclosing expertise hidden within a single mind. Perhaps those costs are still higher than the costs of deference. My point, though, is just that the courts have not asked that question. But it's a question they need to ask and to answer if Chevron's expertise rationale is to be complete and persuasive. Now let's turn to Chevron's accountability rationale. The Chevron court placed great weight on the fact that the agencies are supervised by the president, who is, in the court's words, directly accountable to the people. Federal judges, the court explained, have a duty to respect the legitimate policy choices of those who are responsible to the people. So courts must not second-guess the executive branch's interpretation so long as it doesn't contravene the unambiguous statutory text. Even if it is not the interpretation that, quote, the court would have reached if the question initially had arisen in a judicial proceeding. Now, it's not immediately obvious why Chevron deference promotes accountability. After all, Congress too has a democratic mandate and a superior one, and that's for two reasons at least. First, the Constitution the people made vests legislative authority in Congress rather than the executive. And second, Congress, but not the executive, labors under a set of protections designed to prevent factionalism. Those protections increase Congress's accountability to popular reason, even as, indeed because, they decrease accountability to popular passion and private interest. But the executive lacks the benefit of these protections from faction. The upshot is that the best way to promote accountability is to give effect to Congress's policy decisions. I don't take the Chevron court to disagree. Rather, I think its reasoning goes something like this. Congress may have the strongest democratic pedigree, but the president's is both real and greater than the court's. So courts should not stand athwart the presidential will unless they are relatively certain that by doing so, they are promoting the achievement of Congress's will, Congress's objectives. And this means courts should be confident that Congress has indeed spoken to a question before interfering with an interpretation adopted under the president's auspices. Implicit in this line of reasoning is the assumption that the agencies acting under the president's supervision are not significantly more likely than courts to depart from congressional intent. After all, if they are, then deference to the president's democratic mandate comes only at the expense of Congress's superior one. What basis do we have to believe that agencies under presidential supervision are not significantly more likely than courts to depart from congressional intent in the zone of freedom that Chevron opens up to them? That's the question we have to ask. Of course, courts no less than executive officials can make mistakes, and courts no less than executive officials can willfully pursue their own priorities. Part of Chevron's great attraction for Justice Scalia, it seems to me, was its recognition that judges do not differ from executive officials in either of these respects. But executive officials do differ in other important ways from judges. Perhaps the most important is that while judges are immersed in particularity, they are called upon to interpret this particular provision in this statute governing this program. Agencies are parts of a greater whole headed by the president. And presidents, because they sit atop a machine composed of dozens of agencies administering thousands of statutes, confront possibilities and pressures different than those that judges face. Agencies' incentives and chances to depart from congressional intent therefore differ from the incentives and chances of judges to do so. We can begin to see the difference this distinction makes by looking back to Chevron itself. There, the court understood that Congress meant to accommodate certain interests, but did not clearly balance them with respect to the bubble concept. Rather than balance those interests itself, the court chose to let EPA do so since it is accountable to the people through the president. But of course, to the extent the president influences a rulemaking, he does not simply step into the shoes of the EPA administrator with a focus narrowly restricted to the Clean Air Act or even to environmental issues more broadly. He is tasked with the pursuit of many, many interests that are irrelevant to those Congress sought to accommodate in the program at issue in Chevron. And we may well wonder whether the president might use the program at issue there to pursue these other interests. A number of the major questions cases in recent years seem to arise from agency action under a statute repurposed by the president to pursue interests far from those Congress meant to accommodate in those statutes. Consider, for instance, West Virginia versus EPA. There, the Clean Power Plan pursued a presidential goal of national energy resource management that was far beyond Congress's horizon when it enacted the Clean Air Act amendments. I think we find the same thing repeating in the student loan cases, the eviction moratorium case, and others. The concern I've raised becomes even more plausible, I think, if we reflect for a moment on the situation in which today's presidents find themselves. Neither the president nor his constituents can have any clear or firm idea of the limits on agency and thus presidential power. This is because those limits are spelled out in hundreds of statutes enacted over the decades, and whose outer reaches are discovered on an as-needed basis. More and more, presidents seem to their followers and to themselves to be all-purpose problem solvers, within the scope of whose ample powers all the day's most pressing crises fall. For presidents, the means by which one of these crises is solved is a matter of relative indifference. The important thing is to solve it. Presidents and their teams are therefore tempted to formulate policy first and then seek out any authority that might be remotely useful to accomplish their goals without regard to Congress's objectives in enacting the authority in the first place. They thus have strong incentives to strain interpretations to the breaking point, and these are incentives that judges seem to lack. The president differs from judges in another relevant way. A judge's ability to alter policy through a judgment about a regulation is restricted by the reach of the regulatory program itself. But presidents, because they coordinate regulatory policy across many agencies, are not so limited. They can set a general objective to be pursued by agencies across the federal government. The recent climate EOs are examples. By doing so, presidents can shape domestic policy in a much more far-reaching way than can a single judicial decision on a single regulation. And this means they can far more comprehensively displace congressional decisions. It also means that presidents can assume the prime policy-setting initiative, pursuing the kinds of across-the-board solutions that Congress can enact but that courts can almost never effectuate. Further, the public can see that the president possesses the initiative. And the president thus may come to displace Congress in the minds of many as the main origin and arbiter of domestic policy. The state of affairs would undermine Congress's democratic mandate in a wholly different way than any judge can. These concerns all flow from the status of agencies as parts of a regulatory machine helmed by the president. To be sure, nothing I've said establishes that these concerns are so powerful as to justify overturning Chevron. Perhaps the accountability benefits that Chevron generates more than make up for the risk of accountability that it creates. I'm skeptical, but nothing that I've said excludes that possibility. My point is just that once we see that the president does not make decisions as if he were a monadic agency pursuing a limited mission, but rather in light of the many agencies he directs and the manifold priorities he pursues, we must recognize that presidents and the agencies they direct are situated differently from courts with respect to giving effect to congressional intent. And if that's so, then it's far from clear that Chevron promotes accountability. It may in fact create space in which presidents can, and have incentives to, thwart Congress's own democratic mandate. And it therefore becomes incumbent on courts to ask whether deference in fact promotes or hinders accountability. The courts have not asked that question so far. So Kagan and Barron were right. The way the federal regulatory process actually works matters for the deference debates. The intra-executive habit of demanding and giving explanations raises questions about the expertise rationale. After all, if experts must explain their expertise to executive non-experts, how hard would it be to explain it also to judicial non-experts? And the realities of political direction by presidents with their universal perspective and authority should make us question the assumption that courts and the executive branch are equally likely to pursue congressional purposes. I expect the regulatory process offers many other lessons for the deference debates, but perhaps these are enough to get us started. Thank you.
Thank you so much for those in-depth and insightful remarks. We're really grateful to have you with your varied expertise here today. And your predecessor, for example, at the Office of Information and Regulatory Affairs was, as Adam noted, our founder here, Naomi Rao. And so here at the Gray Center, we have a special spot in our heart for that particular role. But before we talk about your expertise in looking on the ground at a lot of regulations within the executive branch coming up through many different agencies, I wanted to go back and hit on one of your earlier experiences of law clerk for Justice Alito, because obviously with the court's reconsideration this term of Chevron, some folks might be thinking, what are the various justices' views and how realistic is it actually that they might revisit Chevron? I think the first panel in particular harkened back to Kaiser, and in that case, everybody, the chattering class in the scholarly world was talking about whether the court would overrule our deference, and Justice Kagan managed to keep it intact in some form. So will the court do the same thing here? So just to think through some of those issues, my former boss, Justice Thomas, for a number of years has been talking about the Chevron deference perhaps needing to go by the wayside as early as 2015, which is somewhat, that's notable in and of itself because just a few years before that, he had drafted the Brand X decision, which was referenced here in passing earlier today. But that decision essentially holds that Chevron deference is so paramount that if an agency had reached an earlier interpretation, a court couldn't then undo it. So really cementing it and then looking at the constitutional questions later and reconsidering it. Justice Gorsuch, when he came on the bench, has really clearly taken up the call to re-examine Chevron deference. And John Duffy mentioned earlier that that's intriguing because his mom issued the order that was at review in that case, although I don't know if we got so far as to make the point that actually overruling Chevron, as some folks are talking about today, wouldn't actually involve necessarily undoing the decision in that case, and the order is issued by Justice Gorsuch's mother, but just the methodology at issue in the case. And then there was the question of Justice Kavanaugh and what do his earlier writings suggest. And I, in looking back at his Kaiser concurrence, which was referenced earlier, he has an intriguing line at the end that says he, like the Chief Justice, really wants to make clear or doesn't interpret the Kaiser decision as in its treatment of our as being precedent for the future treatment of Chevron. And so depending on one's perspective, that might either be ominous or intriguing. Maybe he's saying, well, there's still room to overrule that, even if we wouldn't overrule our deference. And then actually in his confirmation process listed our deference as one of the key decisions he thinks the court should or would revisit. And so, just an interesting question whether with this doctrine that talks about courts deferring to agency interpretations of law, what the justices will do. I don't recall Justice Alito having given quite as many definitive signals on the doctrine over his service as some of the other justices. And I'm curious as to whether you have any just thoughts about, with his general jurisprudential approach, how likely he would be to want to take a close look at the roots of the doctrine itself in this case.
Yeah, no, it's a great question. Of course, disclaiming any insider knowledge on the question. Jen, I think you're right. I think Justice Alito has not taken as firm and frequent positions as some of the other justices, especially I think of Justice Gorsuch in recent years on some of these administrative law questions. I think the way he'll think about the question is really in terms of separation of powers. I think you see the attraction to the Chevron doctrine has waned over the years as it's become apparent that the possibility of as presidential control over the agencies has grown. I think you've seen a number of justices realize the real separation of powers concerns raised by the agencies, and that those concerns may predominate over the possibilities of judicial aggrandizement that the Chevron is meant to cut back on. So I think you see in Justice Alito's opinions a recognition of that same danger.
Okay, and then hopping to your role for a couple of years at the head of OIRA, I'm wondering if you can talk to us a little bit about on the ground, and for those who don't know, I assume most of our audience today does know, the Office of Information and Regulatory Affairs has to review regulations coming up for many of the agencies, not all. There are a number of independent agencies whose regulations don't cross your desk, but essentially you are an office within the White House that's charged with reviewing the regulations for efficiencies, lawfulness to an extent, and then presumably also making sure that they are consistent with whatever the overall mission is of the elected administration in a sense. On the ground, as a practical matter, was the Chevron Deference doctrine a reality for you and your team in reviewing regulations? Did people talk about it, think about it? Did it impact whether you were likely to give a check to a reg?
Yeah, no, very good question. Well, first of all, I'll say I do expect that this room has the highest percentage of people who've heard about OIRA of any room in the world right now, actually. I'm from Chattanooga, Tennessee. You should try asking who knows about OIRA in Chattanooga, Tennessee. The results are not overwhelming. So I absolutely encountered ways that Chevron shaped the regulatory process. I guess I'll start by going back not to my OIRA experience, but to my DOL experience. I was at the Department of Labor, as Adam mentioned, as counselor to the secretary for about a year before joining OIRA. And I remember I was working on a particular regulation, and I advocated for taking a particular position because it was the best reading of the statute. And a career official said that was not a good enough reason to adopt that interpretation in the regulation because of Chevron. We had to seeking to be the most faithful agent of Congress was not a good enough reason. We had to have additional reasons because Chevron allowed us to not seek to be the most faithful agent of Congress. I was rather flabbergasted by that. It seems like if anything is a good reason to adopt an interpretation, it's because we think that it's what Congress would have wanted, even if it's not what Congress demands of the agency. So I do think that the baseline against which, or the concerns that are relevant for agencies in adopting interpretations are profoundly shaped by Chevron. That's true in the initial drafting process and also in the interagency review process, right? So the OIRA process provides an opportunity for OIRA itself to shape regulations to be consistent with the president's priorities and with norms of good regulatory practice and cost-benefit analysis. But it also provides an opportunity for other agencies to weigh in on the regulation under review. So certainly, one great benefit of that interagency process is channeling legal views from the Department of Justice and White House counsel and potentially other agency general counsel's offices into the regulation under review. And I absolutely found that all of the legal input provided in the interagency process was shaped by an understanding of Chevron in the background. So the question really was, is this a thing that the agency can do, rather than is this what Congress would have most wanted the agency to do?
And so as a practical matter, I guess I'm curious into drilling down a little bit more on how that played itself out. So without, interrupting any confidentiality interests, maybe in generalities, going back to your Department of Labor example, what did you perceive to be motivating the desire to stick with Chevron deference? Was there going to be a significant constraint on what the Labor Department could have done if it had followed your idea of looking closely at that the Congress said versus what the original draft or the proposal had been?
Yeah, so the outcome of the regulation was going to be the same in this particular instance that I'm thinking of. What was interesting to me was two things. One, it was quite clear that the agency staff were glad to have the benefit of Chevron deference. They thought it created more liberty of action. What was most interesting to me, though, was that the very idea of trying to seek out the best reading of the statute had been taken off the table as something that was relevant for agencies to do. Agencies were not, as far as as the staff in this rulemaking were concerned, the agency was not really in the business of seeking to discern and pass along or act upon congressional intent. Rather, Congress had, in light of Chevron, had carved out a certain set of bounds within which the agency was free to act, and within those bounds, there wasn't really a congressional intent if it existed wasn't really relevant.
One of the things we've been talking about a lot today is, what happens if the court does revisit the way in which Chevron's been operating and its lawfulness or constitutionality as a doctrine. Do you think, given, though, the fact that currently it's been on the books, and so therefore it would have been a relevant doctrine to executive branch lawyers. I worked at the Department of Justice the same time that Paul was at OIRA, and so we would probably kick over a fair amount of regulations to you. And one question that always comes up, at least for me as a scholar coming into government service, is how different, if at all, is my role supposed to be in figuring out how to look at the legality of an action if you're an executive branch lawyer under the president with a certain set of doctrines that remain in place versus the scholarly approach. And I'm curious as to whether you have thoughts on whether if the court leaves Chevron in place, does that impact the executive branch lawyers' just duty or need to look at tools in the toolkit if they're serving a president who says, let's use every tool in the toolkit, including Chevron deference?
Right. Yes, so certainly, the main role of a lawyer in the executive branch seems to be to provide disinterested advice to his or her client. So if the client, in this case, says, Chevron's on the books, and I understand maybe there are some policy concerns with its invocation, but it's on the books, and so I direct that you find a way for me to pursue X policy in light of Chevron's existence. I think, the executive branch lawyers would be obligated to do that.
And then your piece for the conference today, which really appreciate you submitting that, in addition to doing the keynote address here, talks a lot about the rationale of expertise as being a practical justification for Chevron. And so it might be that as the court's thinking through Chevron deference, some of the justices themselves will wonder if getting rid of the scheme harms the agency's expert ability to be able to influence how courts see statutes. And you suggest that, it's no more challenging for an agency expert to communicate that information to a court than it is to communicate it to their higher ups. And so first I just wondered, as a practical matter, how did you see the folks on the ground forming the statute or forming the regulation, communicating up their expertise and their understanding, and how did that help you understand the regulation better?
Yeah. So, well, thanks for the excellent summary of the paper. I was really struck, especially in my time at OIRA, but also at DOL, at the amount of explaining of expertise that goes on. A few scholars have noted this, but at least in my experience, that it's a simply pervasive flow of expertise from the subject matter experts to those who are entrusted with making the ultimate decisions. So I'll speak from my own experience. OIRA, when I was there, had about 50 career staff. They were immensely knowledgeable people in a vast domain of areas that I had never studied in my life. But I had to begin to understand things, to sign off on regulations or provide feedback to the agencies or participate in higher level meetings about the regulations. And so there wasn't really anything for it but to try to learn what these experts with decades and decades of experience knew. Not all of it, that would have been impossible and would have been silly to try. But the key thing is no expert needs to use all of his or her expertise in any regulatory interpretation, right? I mean, I use this example in my paper. Think about a doctor. A doctor needs a lot of knowledge. But they need a lot of knowledge because they don't know what cases are going to be presented to them on any given patient, right? A doctor deploys only a tiny bit of his or her expertise in treating a particular patient, right? And so if the patient wants to become well-informed, informed enough to make a decision about treatment, it's not an impossible thing to ask the doctor to provide some serious education to the patient. Right, and so I found that in the executive branch, senior officials could ask the career experts to provide not all of their expertise by any means, but enough of their expertise that the executive official could come to understand what he was asked to decide on. I found that a number of my colleagues who were more generalists were engaged in the same kinds of back and forth. Trying to understand the expertise of the subject matter experts. So that's what gives me some measure of confidence that courts could do the same. Courts, judges in executive officials are not precisely the same, but some of the same dynamics do obtain.
So I appreciate your reference to similarities. If we were to think about the differences, do you have thoughts, though? It strikes me that two things off the bat. Number one, as many of us in the room know who have worked on regulations, sometimes it takes years and years to develop them. So the judicial review process often happens on a shorter time horizon. So does that interrupt the ability to be able to get the expertise, that shorter time horizon? And then also, is it relevant that within the executive branch, at least to the extent that one believes in some version of even a soft unitary executive approach, in theory, it's all the same entity. So your ability to be able to just sort of command or ask for information or share the same interests might enable you to be able to easily get the agency expertise. And if we see the judiciary as a separate branch that's supposed to be taking a new look from the outside, perhaps with even more skepticism, does that inherently mean their process is going to be more challenging and they can't as readily just incorporate all the agency expertise the way you as a supervisor would?
So it's certainly the case that the time horizons between, in the rulemaking process often differ radically from judicial review. I'm thinking in particular of one rulemaking that started in the 1990s and tried to move to conclusion in 2019. We actually ended up sending that regulation back to the agency on the instruction that no rulemaking from the last millennium could proceed without going out for another round of notice and comment. But it's certainly the case that rulemakings can take a very long time, to your point, Jen. Of course, so can judicial review. No doubt about that. But I don't think the time horizon materially impacts our question. Usually an interpretation that an agency adopts, in my experience, is not hashed out over decades and decades of discussion. It's usually the product of a few meetings. Those few meetings could happen at different times over the years with different officials, but it would be unusual in the extreme for a high-level official to spend years and years brooding over a particular interpretation and have all that time to get up to speed on a subject matter expert's expertise. So I don't think judges differ from executive officials in that respect. As to your second point, one benefit of OIRA review is that OIRA provides a second set of eyes within the executive branch. Right? That's a frequent source of criticism of OIRA, that OIRA is not expert enough. And the response that I always give to that is it's actually helpful to have compared to the agency, a relatively more generalist review within the executive branch. And I think you find a number of the reviewers who participate in interagency review certainly are adhere to the president's priorities, but also have incentives to poke holes in the agency's analysis, and so therefore have incentives to demand explanations, and that in turn gives the subject matter experts incentives to provide explanations. And so in that way, I think it's not dissimilar to the judicial process, right, where judges to perform their office have reason to demand explanation, and the subject matter experts to get the regulation across the finish line have incentives to provide them.
Well, that behind-the-scenes view is very helpful, and we're really grateful to you for sharing that with us, because you obviously had to look at a number of varied regulations, often under really short time horizons, and with a lot of just political pressure inside of an elected branch of government. One final question before we get to our break and then our delightful afternoon panels. I think even the folks here today who have suggested that under the APA, perhaps there would be purely de novo review of legal questions, have suggested that and acknowledged that statutory terms are so broad, often giving agencies power, that even if you thought that there should be purely no deference given to an agency on the law, that there would still be a fair amount of policy deference under the arbitrary and capricious standard of the APA. So if there's a broad term, then the legal answer is that the agency has a range of options. And do you think that expertise is a way in which an agency and that value can still have a meaningful impact, even if the court, as a practical matter, said, totally de novo review, I'm sure, questions of law moving forward.
Yes, absolutely. I don't think we would actually lose very many, perhaps we would lose none of the benefits of expertise if Chevron were overruled. The reason that you just gave, Jen, is one of those reasons. Other reasons include what I just talked about agencies being able to explain their expertise, right? I don't think that we would stand to lose the benefits of expertise should Chevron be overruled.
All right, well, thank you for sharing your time with us. Feel free to pull Paul aside and ask him questions afterwards. And then please hurry back to your seats for our third panel to start at 1:20 with a lot more experts to come this afternoon. All right, so we're going to get back to business here after that short break. We're going to start off with another wonderful panel, Who Interprets Statutes? So fairly open-ended question that's going to be moderated, I'm sure, in excellent fashion by our next moderator, the Honorable Chad Radler of the U.S. Court of Appeals for the Sixth Circuit, who also has a Scalia tie, serves on the advisory board for our Law and Econ Center, and is a former Justice Department attorney in his prior life. So we'll be able to handle a great discussion here among our scholars on the discussion. Oh, and I have to point out, I will let Judge Radler introduce everybody, but a special shout out to Elie Nachmani, who formerly was a research fellow at the Gray Center, and we had a lot of fun adventures working on Chevron in 2022, co-author, actually reviewing for the Wall Street Journal Tom Merrill's excellent book, and then writing on the major questions doctrine in the Washington Post. So I don't mean to take anybody's thunder, but we're very grateful to your service formerly at the Gray Center, and welcome you and everybody else here in your new capacity today.
Thank you, Professor Mascott. It's great to be here. Thank you to the Gray Center for inviting me. I will say that the center is a real wonderful legacy and tribute to Ambassador Gray, who we all miss and who there are many very nice things to say about. The very short story I have is as a second or third year lawyer, Ambassador Gray came to Columbus to give a talk, and I managed to track him down and chat with him for a few minutes, and he could not have been kinder to a brand new lawyer who knew nothing about the presidency or counsel to the president, but had lots of questions. And I always looked so fondly on that interaction with him. So we all miss him, and it's a privilege to be a part of the center's programming today. So Professor Mady, or Judge Mady this morning had a really wonderful opening referring back to 1984, the year of Chevron, and sort of looking forward to today. As a young boy growing up in a small town in Michigan in 1984, I thought the only thing that year could be known for is the Detroit Tigers winning the World Series. So if Chevron is overturned next year, I also hope that's a return for the Tigers to the World Series in 2024. But it has been almost 40 years. It's a long-standing precedent, and I think we're all quite eager to see what the court does with the cases next year. And I'm just so fortunate to have four experts, and I really mean that experts, in the area of administrative law and the separation of powers, and so we're really in store for a wonderful discussion. I'm going to introduce them all now, and then we'll start with some opening remarks and then some questions. I'll introduce them in alphabetical order, which is also going to be our speaking order. Aditya Bomzai is a professor of law at the University of Virginia. His work on the development of American administrative law has been published in the Yale Law Journal, the Harvard Law Review, and various other journals. He's a co-author of the forthcoming 9th edition of the casebook, Administrative Law, the American Public Law System, Cases and Materials. From 2019 to 2021, he served as a member of the Privacy and Civil Liberties Oversight Board. Before entering academia, Aditya was an attorney advisor in the Office of Legal Counsel at the U.S. Department of Justice. He was a law clerk to Justice Antonin Scalia of the U.S. Supreme Court, and I have to selfishly say, most importantly, a law clerk on the Sixth Circuit Court of Appeals to my colleague, now Chief Judge Jeffrey Sutton, and he's a graduate of Yale University and of the University of Chicago Law School. Jonathan Masur is the John P. Wilson Professor of Law at the University of Chicago. He's a graduate of Stanford University and Harvard Law School. He clerked for Chief Judge Marilyn Hall Patel of the United States District Court for the Northern District of California, and for Judge Richard Posner of the United States Court of Appeals for the Seventh Circuit. He joined the law school faculty in 2007 and served as deputy dean from 2012 to 2014. Professor Masur is the author of Patent Law, Cases, Problems, and Materials, an open source patent law casebook, and also the author of Happiness in the Law, which I hope is nonfiction. And he's served as a director of the Wachtell-Lipton Program in Behavioral Law, Finance, and Economics since its founding. Elie Nachmani is a law clerk at Covington and Burling in Washington, D.C. He recently completed a clerkship with Judge Stephen Menashe of the United States Court of Appeals for the Second Circuit. Between graduating from law school and starting his clerkship, Elie was a senior research fellow, as mentioned, here at the Gray Center. He graduated magna cum laude from Harvard Law School, where he served as editor-in-chief of the Harvard Journal of Law and Public Policy. Prior to law school, he served as a speechwriter to the U.S. Secretary of the Interior and as a domestic policy aide in the White House Office of American Innovation. Victoria Norris is the Ralph V. Whitworth Professor of Law at Georgetown University. Her most recent book is The Impeachments of Donald Trump, An Introduction to Constitutional Argument. She's also published widely on the power of the president and the separation of powers, including Reclaiming the Constitutional Text from Originalism, The Case of Executive Power. She's a co-author with William Eskridge and Abby Gluck from Yale of the most up-to-date casebook on legislation, statutes, regulations, and interpretation, legislation, and administration in the Republic of Statutes. In 2015 to 2016, she served as chief counsel to the Vice President of the United States. He's gone on to do other things since then, as have you. Prior to that, she served as an appellate lawyer in the Justice Department and special counsel to the Senate Judiciary Committee. She's a graduate of Berkeley Law School and a former law clerk to Judge Edward Weinfield of the Southern District of New York. So as I mentioned, it's a terrific panel. I'm going to give them all a few minutes at the beginning to give us some sort of organizing thoughts, and then we'll do some Q&A. So Dietrich, you want to start us off?
Thanks so much, Judge Radler, and thanks to the organizers for inviting me. I'm honored to be here with you and with such great co-panelists. I'm going to start at the beginning, which for me as a failed philosophy undergraduate means Aristotle. There's a claim, it's often attributed to Aristotle, that nature abhors a vacuum. And here's a legal analog to the principle, which is that legal doctrine abhors a lack of adequate justification, or what might be thought of as a vacuum of justification. Let me explain. When Chevron was decided, the opinion contained a justification for the seemingly simple, straightforward two-step process that the court announced. The court said that federal judges have no constituency and have a duty to respect legitimate policy choices made by those who do. And there's similar language in the opinion along these lines. But not everyone believed that Chevron ever announced a simple two-part test. Consider Justice Breyer's 2013 concurrence in City of Arlington versus FCC, which explained that, quote, the existence of statutory ambiguity is sometimes not enough to warrant the conclusion that Congress has left a deference-warranting gap for the agency to fill, because our cases make clear that other, sometimes context-specific factors will on occasion prove relevant. Instead, according to Justice Breyer, the court looks to several factors other than simple ambiguity to help determine whether Congress left a statutory gap. And to the extent that the two-step process of Chevron ever had purchase, it certainly didn't after the court's 2001 opinion in Meade, which added a somewhat hard to pin down so-called step zero of Chevron to the framework. There are other developments and complications, which I'm sure many in the room are familiar with, but in the interest of time, I'll just note that with respect to the stare decisis discussion that we've been having throughout the day, I certainly agree with my colleague John Duffy's formal point about when stare decisis applies, but I also want to add the following, which is that when folks say that we must give the approach described in Chevron stare decisis weight, what do they mean exactly? Do they mean the simple two-step Chevron, or the Chevron as amended by Meade, or Justice Breyer's multi-factor approach? The difficulty is that there's no one Chevron to give stare decisis weights to. Now, some might look at the current case law, just where it stands today, and the reasoning in Chevron and say, it's good enough, and we will muddle through. And I don't necessarily mean that in a pejorative way, because sometimes that's the best that institutions can do. They just muddle through. But I guess I'm just not one of those people. I look at the mismatch between the reasoning in Chevron and the varying approaches to the case and think this calls for some clarification. And you'll remember that I started off this talk with a postulate from Aristotle about nature abhorring a vacuum. So I did, in fact, in true nerdy fashion, look at book 8 of the physics, and here's how he puts the point. He says, this is a quote, "In a void, no one could say why a thing once set in motion should stop anywhere. For why should it stop here rather than here?" And the same is true of the application of deference without an underlying justification or theory. Who can say why it should stop, quote, here rather than there? What are the boundaries for applying deference, and in what cases? That is what the court in Loper-Bright should, in my view, confront. So on this issue, I'll bracket constitutional questions, but I'll just say that I'm in basic agreement with the public-private rights framework that was discussed earlier in the day during the first panel, and I think it was by Professor Walker. Happy to talk more about that if that's of interest. I'm in basic agreement with my colleague John Duffy on the Administrative Procedure Act and its import, which is that the statute calls for a form of de novo review by its terms. And there are various reasons for this. One can look at the language of the statute. Courts shall decide all relevant questions of law, interpret constitutional and statutory provisions, hold unlawful agency action not in accordance with law. Some of these provisions were in fact borrowed from prior statutes where the court had construed them and said basically they imply a form of de novo review. One can look at the legislative and drafting history of the statute, statements by the Act's authors, one of which Professor Duffy quoted. One can look at many contemporaneous court decisions. The complication is that at the same time, Congress enacted the APA, which was in 1946, right after World War II. The courts were innovating on this question in a series of cases that called for heightened deference to legal questions by blurring the line between legal questions, which would have been addressed de novo, and factual questions which were presumptively deferentially reviewed. And that makes one wonder, what's the relationship between these 1940s cases and the APA? So here, one can look at scholarship from the time of the APA's adoption to see that this tension between the 1940s cases and the APA was widely appreciated. For example, with your indulgence, here's a direct quotation from a 1951 article by Louis Jaffe, an eminent mid-20th century administrative law professor. This is a quote. "It is thought to be open for decision whether the so-called doctrine of Gray versus Powell," this is one of the 1940s deference cases, "has been repealed by the Administrative Procedure Act. Section 10 provides that the court shall decide, quote, all relevant questions of law. In the view of some distinguished authorities, this provision was intended to overcome the doctrine of Gray versus Powell," and I'm going to skip like a sentence just in the interest of time, but it points to some legislative history. "This question must ultimately be faced. It cannot be avoided by labeling those questions as questions of fact. I would argue that insofar as these opinions suggest what I've called heresy," he's referring to an earlier part of the article in which I've pulled this quote, "and one quite unnecessary to the decisions in those cases, they should be regarded as disapproved." And then he goes on. Jaffe's position, to be sure, it's complex. I'm definitely skipping over important nuances, but he was not alone in wondering how the Administrative Procedure Act interacted with the courts of then contemporaneous 1940s cases. I'll have a more fully fleshed out version of this argument in my article for the symposium, because the whole question gets quite in the weeds of legislative history and various scholars making different types of arguments. I do think it's interesting that Jaffe spotted the very APA question in 1951 that we're discussing today and said, quote, "This question must ultimately be faced." Well, here we are 70 years later, and we are ultimately facing it. And it is interesting to think, what could possibly explain the passage of time? I'm very much open to the views of everyone on this topic, and I think part of the story might be the administrative common law points that were made by my colleague, Professor Duffy, earlier today. I'll also point out that in the pre-Chevron world, as Professor Merrill suggested, the court was notoriously inconsistent in applying deference principles, including in the 1940s, by the way, and this was flagged by many commentators during that era. And post-Chevron, as I previously discussed, the court is not struck to one particular consistent method. So, just to sum up, in my view, a consistent method would be a good thing. And that is hopefully what the court will aim for in the currently pending litigations. That would, in my view, draw the de novo standard from the APA, but it would temper the standard with certain canons of construction that I think to be a part of de novo review, which defers to contemporaneous and customary agency interpretations. That's part and parcel of de novo review for reasons I'm happy to talk about if people are interested in that topic. And it would also allow for Congress to tinker with the defaults of the APA through provisions in organic statutes in some of the ways previously suggested by my colleague, Professor Duffy. This approach would make sense of the overall APA framework and of background law. I'm happy to discuss circumstances where I do think this approach might, in my view, lead to results that are different from those we've seen in recent cases. But I've already gone on long enough, and I'll look forward to what my co-panelists have to say.
Thank you. Jonathan? Thank you. I'm delighted to be here and really appreciative of the organizers for putting together this terrific symposium. I'm going to try to be quite brief by design. I have sort of one central point to make, but I want to offer a little bit of background before it. So before I came to the symposium, I sort of imagined that there was widespread agreement as to how one would formulate the expertise rationale for Chevron. But one thing I've learned is that a lot of different people have different conceptions of what that expertise rationale actually means. So I'm going to start with what I think is the most coherent articulation of the expertise rationale. Not mine, of course, but what's in the literature. And it goes something like this. Everyone agrees that if the statute unambiguously has one meaning, that the courts are to give effect to that meaning, and that no deference is afforded. But if the statute is ambiguous and there are multiple possible meanings, that opens up a series of options, all of which are consistent with the statute. That series of options provides the agency with some sort of policy space. It can choose among a varied set of potential policies that it wants to pursue consistent with the statute. If the court were to use the traditional mechanisms of statutory interpretation to select one of those various interpretations, that would eliminate the agency's policy space. That would rob the agency of the opportunity to select among a variety of different policies. And it's the selection of those different policies that is the exercise of the agency's expertise. And so it's the creation of the policy space that is the rationale for giving, it's the creation of the policy space that is animated by the existence of agency expertise. I'm not trying to endorse this view, I'm just trying to describe it. I think it's because of that view of the expertise rationale that for essentially the past 40 years, the canonical understanding of Chevron is that Chevron is a pro-regulatory doctrine, that it leads to more regulation, broader regulation, more sweeping regulation. That, I think, was true for many years. The theory here, of course, is that it opens up options for agencies. It gives agencies greater power to exercise choice within those options, and that as a result, we're going to get more regulation. Chevron itself was decided in the middle of the Ronald Reagan presidency, and that was a point of relatively low levels of regulatory stringency across the United States. And so at that point, operating against a baseline of relatively little regulation in a lot of different spheres, it made sense that providing agencies with more options was quite likely going to lead to more regulation. And that's how Chevron operated also for basically the 28 years between 1988 and 2016 across 7 presidential terms. All of those 7 presidential terms, including the Bush 1 and Bush 2 presidencies, were predominantly sort of pro-regulatory terms. Even both Bushes, in addition to, of course, Clinton and Obama, engaged in quite a lot of regulation across quite a lot of spheres of activity. And the result was that the regulatory landscape in 2016 looked very different than the regulatory landscape in 1984. There was a great deal more regulation and more stringent regulation just about anywhere you looked across the economy. This pattern of Chevron as sort of one-way ratchet, always giving agencies more and more options to regulate more and more, came to a halt in 2017. President Trump, as a candidate, campaigned on repealing a lot of the Obama-era regulatory agenda, and that's exactly what he set out to do when he became president. And he used as a principal mechanism for those repeals Chevron deference. In a whole slew of regulations, many of them the most significant regulations, but also smaller ones as well, Trump and Trump's administration used the possibility of reinterpreting statutes more narrowly through Chevron as a mechanism for repealing those statutes, repealing those the existing Obama regulations, and or in some cases replacing them with something that was less stringent. This happened with regard to the salient Obama fuel economy standards. It happened with regard to the mercury and coal-fired power plant regulations that were the subject of Michigan versus EPA. It happened with regard to the climate change regulation, eventually sort of obviated by West Virginia versus EPA. It happened across a number of other domains as well. But under Trump, Chevron was a deregulatory tool. So that's really the central point that I want to make, is that in a world in which we're operating against a baseline of relatively little regulation, Chevron is almost necessarily going to be a pro-regulatory tool. It will give agencies more authority and more power by virtue of giving them more policy space and lead to greater regulation. But in the existing world, in which there is a substantial body of extant regulation, Chevron is really symmetric. In the hands of a pro-regulatory executive, it can be a pro-regulatory tool. In the hands of an anti-regulatory executive, it can be a deregulatory tool. And that is a point I think that has escaped the canonical wisdom as understood by practitioners, academics, members of government, advocacy groups, and the like. So the bottom line conclusion that I want to try to leave you with is that I think that the political valence of a lot of the debates about Chevron is misplaced. I think that there has been to this point a sort of backdrop in which sort of pro-regulatory liberals are in favor of Chevron and deregulatory conservatives are against it. I think that that is an oversimplification that no longer makes sense in the regulatory landscape in which we are operating. And I guess the other thing I want to say is that I think that the consequences of a repeal of Chevron, and this is maybe to echo some other panelists, the consequences of a repeal of Chevron will not be as dramatic, and especially not as dramatically deregulatory as a lot of people believe that they will. They will probably be destabilizing in the short term, but perhaps stabilizing in the long term as agencies become locked into particular interpretations of statutes, and this ability of subsequent presidents to oscillate between greater regulatory stringency and lower regulatory stringency is curtailed.
Thank you. Ellie?
Thank you, Judge, and thanks both to the Gray Center and to the George Mason Law Review for including me in this symposium. I want to talk a little bit about justifications, and we've heard about justifications for Chevron a little bit on this panel. Aditya is right. Chevron does embrace, as part of why to have its rule of deference, this idea of democratic accountability. That said, at the same time, Chevron does not disavow and seems still to be sympathetic to, at least in the initial opinion, the idea of agency expertise playing a role in why courts should defer to agencies when they interpret statutes. Now, Chevron offers several answers to the why deference question. One of those, of course, being the democratic accountability, another being the agency is charged with the responsibility for administering a given statute, and then this third one that Chevron uses the phrase, the agency, or really the administrator, has, quote, great expertise. Now, the question is what exactly expertise means, and you might think, well, it's expertise, as Jonathan just talks about, and picking a policy among a number of different options. So Chevron creates policy space, and we're just going to pick one of those policies. But actually, if you look at the case law, in particular in the circuit courts, you'll find that expertise has a variety of meanings, and all of these animate different kinds of cases in different kinds of statutory contexts. So I've identified 3 in my paper, and I think these 3 are really the main buckets into which you might put the expertise cases when courts applying Chevron say, well, the agency has expertise, thus we defer. One of them is scientific expertise. Now, agencies do science all the time, and we might say, I think quite rightly, that agencies have comparative expertise to judges when it comes to particularized application of scientific methods. So one example might be, determining the environmental impact of operating a light water nuclear power plant. Another might be using a computer submodel to predict injury to natural resources from certain activities in the context of maybe CERCLA liability. That's one kind of expertise to which courts have said, well, the agency is more expert at least than we are, and thus we're going to defer to the agency's interpretation of the statute. There's another kind of expertise, and this is what Jonathan, I think, was talking a little bit about, was political or policy expertise. This is we have these policy options and we're going to choose among them whether massaging different interest groups or thinking what just makes the best sense as a matter of policy. So, you might have the classic policy debate whether to stifle innovation to protect consumers. And that's the sort of thing that judges say, well, the agency, maybe for democratic accountability reasons, maybe for communication with the interest groups reasons, right? You would think agencies are communicating a lot more and receiving a lot more input from interest groups than federal courts are. Well, they have a policy expertise or a political expertise, and thus we would defer to the agency's interpretation of the statute when it's picking among policy choices. Then there's a third kind of expertise, and this kind of expertise is the one that I think is the most relevant to statutory interpretation and thus should guide how courts, whatever happens to Chevron this term at the court, think about agency expertise in the context of deference when the task before the court is statutory interpretation. This is interpretive expertise, and I think Paul Ray talked a little bit about it in the keynote as well. Interpretive expertise can fall along a few lines, but the two best examples of it are, number one, the agency was involved in drafting the statute, or maybe the agency actually drafted the statute and Congress basically passed what the agency wrote. That means the agency was there at the drafting. The agency can say, this is why this particular choice of words was made. Adichie has done excellent work on contemporaneous interpretations of statutes. You would think that the agency, having been involved in the drafting, right after that statute is passed, may issue some interpretation close in time to the passage of the statute. So that's one way for the agency to obtain interpretive expertise, you might say, with respect to a particular statute. The other is the agency, as an expert member of a given industry group or a particular industry, is expert in certain terms of art that you or I might read and say, well, I don't know exactly what that means, or I might have an intuition about what that means, but the agency, let's say it's the FCC, they say, well, no, in the telecoms industry, this particular term means X. And you can put that in a brief, or you can simply interpret the statute to mean that and put it in the notice of proposed rulemaking or something, but say, this is a term of art, it is interpreted by experts or industry members to mean this thing, and thus that's what it means, even if your generalist intuition is going to be different. The point I make in my paper is that the only one of those types of expertise that is the most relevant to statutory interpretation is the interpretive expertise. And so when courts are conducting judicial review of agency interpretations, it may well be the case that once the agency gets around to implementing the statute, whatever it means, that let's say the scientific expertise helps it make the right scientific determination, or the policy or political expertise helps it make the right interpretation that's going to make all the interest groups or the citizenry happy. But when it comes to actually determining, what does this word, what does this term, what does this phrase mean, the court should look to interpretive expertise. That doesn't mean you defer, right? And I think Justice Breyer, there's an article I cite in my essay where he says, if the secretary has a special expertise about the statute, well, put it in the brief. And Paul talks a little bit about this as well in the keynote. But, the interpretive expertise is relevant, and thus the court should, and maybe this sounds a little bit like Skidmore deference, but the court should accord respect to the agency's interpretation when that agency can justify on a particularized basis to the particular statute, well, there's some reason that we would know a little bit better than a generalist, not how to implement the statute, but what the statute means.
Great, thank you. Victoria?
Thank you very much. You're going to have to indulge me a bit. I am the vice chair of the United States Civil Rights Commission, and this morning I was talking about algorithmic bias in AI, so I'm going to have to shift registers here a bit. But I'll take any questions on that if you have them. No, I am delighted to be here. I'm a huge fan of Jen Mascott. I got the honor of meeting Boyden Gray when I was a very young lawyer, and he was unfailingly kind and generous. So thank you for inviting me, George Mason, Jay Slyton, Adam White, Tyler Carter. You did a great job. I run things over at Georgetown. You're doing a lot better when I do my conferences.
an admission against interest.
It is an admission. Well, my husband teaches nuclear security at George Mason to graduate students. So my contribution here is a little bit different than the experts on this panel, who many of their comments I agree with, frankly. But I study interpretation. And so I'm going to take the conversation up to a different level. I fully believe that the court will, in fact, make major changes in Chevron. And why do I believe that? Because I have spent the last few years reading everything the Supreme Court has ever written for something that I call the Supreme Court Interpretation Lab, that includes Kevin Tobia, Neil Sukhatme, who's an economist, patent lawyer, Jonathan, and some other folks. And we're building big data and a lot of new tools to look at text, because that is what you do if you teach about interpretation, whether it's about the Constitution or about statutes. So what I want to talk to you about is thinking about Chevron in a broader interpretive landscape. I don't believe that if Chevron goes, the administrative state will suffer. And I'm sorry to say that Tom Merrill's over there. I'm a huge fan. I think that it will reverse precedent in a fairly disruptive way. There will be a lot of memos written in general counsel's offices. I joke that it's a full employment bill for lawyers, but I do think that, because the administrative is sort of resilient, you can think about it with this metaphor, because my husband works in political military. It's like, taking an AK-47, which is a powerful weapon. So Chevron's powerful, but it's shooting at the Pentagon. It's not going to get rid of the Pentagon. The FDA will operate. No one will operate. We'll know about the weather. We'll know about hurricanes. The Defense Department will be there. So will the Federal Reserve. If you really want to talk about the danger there, I think you have to move into the questions of removal and appointment and separation of powers, which also I'm happy to discuss, but it's a different topic. So to my paper, my fear is that we're moving beyond the Scalia age. And I have both admired and criticized Justice Scalia. I admired him for the zeal and the strength of his vision for text. I spend most of my life talking about textualism. When I left the White House, they gave me a little mug. It's all about textualism, because I got some people to actually read some statutes. But I fear that we are moving beyond the Scalia era, and that Chevron and the campaign against Chevron, or the arguments against Chevron, which, the rule of law arguments are pretty good, is leading us into an era that Justice Scalia would not approve of, what he called strict construction, which is a degraded form of textualism. So let me explain that a little bit. I believe that Justice Barrett, who I have had the pleasure of discussing some things about this with, believes that a judicial thumb on the scale one way or the other, she's talked about this in Biden versus Nebraska in her concurrence, is not textualism. And so I agree as well. So I'm doing some empirical work. It's not complete. It's not even complete in my symposium proposal. But I do worry about the following thing, that to try to explain the major questions doctrine, Chevron, and what I see in all the interpretive cases, constitutional and statutory, is a shift toward a thumb on the scale to narrow statutory interpretations. And what I mean by that is, if you put one interpretation against the other, which one will accept the reach of law more or less? And it's a little bit difficult to define that. But what I find is there's a statistically significant connection between these narrowing interpretations. And that is consistent with a notion of viewing Chevron as a way to push back on the administrative state. It's also consistent with the major questions doctrine as pushing back on the administrative state. Now, as I said, I don't think any of these things are actually going to get rid of the administrative state, because the courts have a relatively small role to play, in my opinion. Nevertheless, I am worried about this, because this really is something that you need to pay attention to. It opens up a whole, for those of you who are textualists, it opens up a whole set of arguments by those who would say, they're not looking at the best meaning of the statute, in which we have to define what is best, and I'll talk about that in a little minute, but what is the narrowest? And so here's an example. Healthcare statute says you can regulate for health or sanitation, and the judge picks sanitation. And I'm sure Judge Radler would not accept that interpretation. That is not textualism. And no one who studies it thinks that is. But we have seen some of that happen. And so that is my cautionary tale. I also think it's a cautionary tale because you're asking every agency lawyer in Washington, it is a vast apparatus, to do something called the best interpretation of the law. And that entails two prior questions. I too wanted to be a philosopher, but I didn't get that far. And I won't quote Aristotle, but I'll just ask you to think carefully about what the term best means. Best to whom? Justice Barrett and I disagree. She thinks I'm a congressional insider because I work for Congress as a lawyer. She wants to talk to ordinary people. That's fine, but you have to specify that because technical meaning is often, particularly in agencies, the real core of what they're doing, not ordinary meaning. You also have to decide what's your metric, what's your norm about what is the best meaning. You could have a case that said, for example, ruling for defendants is always best meaning, right? No one thinks that's correct, but I ask you to do that because I think we're at an inflection point where those who are the adherents of Justice Scalia must consider questions about whether the current court, is in fact honoring his legacy. Thank you very much.
So let me maybe pose a question to each of you that the question to whom the answer to the person to whom the question is posed can answer, and then maybe the rest of you can contribute a little bit. Aditya, I'll start with you. In your amicus brief that you filed with the court in the Loper case, you talked a lot about the interaction between the APA and Chevron. Do you want to expand on that a little bit?
Sure. I suppose I should have actually mentioned that in my opening remarks to the extent that anyone might think that I'm biased. Because
well, I'm here for you.
I filed the brief, but in my defense, it was in support of neither party. So I'm completely unbiased here on this topic. Yes, so what's the relationship between the APA and Chevron? This is a topic that we've heard about from previous panels. I mentioned some of the text that is in the statute that has, I think, for a long period of time, people have tended to think that it calls for some form of de novo review, just the text itself. And I flagged a subclause within the statute about not in accordance with law, and this is going to be a portion of my symposium submission, that portion of the statute was added along with some other portions at sort of a later drafting stage. And that language is actually copied from prior statutes, including, for example, the Longshoremen Harbor Workers' Compensation Act, which is interpreted in famous cases like Kroll versus Benson. And the language is actually discussed in both Chief Justice Hughes' majority opinion and Justice Brandeis' dissent. And so, we're never going to find in the legislative history a remark by somebody or a committee prince saying, when the court 38 years from now decides the Chevron case, we disagree with that case. But look, all of the, to my mind, contemporaneous understanding in Congress tends to suggest some form of de novo review. But there is this complication, which is that cases are being decided at exactly the same time. And the complication increases because the APA had a date on which it was supposed to take effect, and there were disagreements about which parts of the statute would take effect on which dates. So there was a little bit of a lag period during which the APA would not have applied to some of the court's cases. So these cases from the 1940s, you might think of them as proto-Chevrons, like antecedents to Chevron. And that, I think, is the question that confronts the court. How do the cases interact with the statute? And I'll just add one final data point on this topic, because I mentioned the contemporaneous and customary interpretation canons. To be sure, they're not discussed in the legislative history just because you don't expect that type of in-the-weeds detail from members of Congress or committee prints. But, for example, in 1942, Erwin Griswold, who later becomes the dean of Harvard Law School and at the time is a professor at Harvard, writes an article on this topic, and the topic is addressing when do agencies, specifically the Treasury Department in the case of the article, get deference. And this is how he explains the area of law circa 1942. He says if they're long continued or contemporaneous style interpretations. I want to say that the article is called A Summary of the Regulations Problem, so you could look it up if you're interested in this topic. So there you go. I mean, I might have reiterated some of the same themes that I'd earlier touched upon, but gone into a little bit more detail. I think that basically the question is, the statute's enacted in 1946, and there's an interaction between the statute and what is happening in the court at that time.
Anyone else have a thought to share? Okay, Ellie, let me ask you, so we're talking about who interprets statutes. Obviously, we can start with the Constitution. Is there anything you see in the original understanding of Article 3 or Article 1 that speaks directly to the issue? Or any other sort of constitutional points you want to raise? Because we haven't really touched on that too much.
Yeah, and I think for those interested in the constitutional issue, I would point you to page 15 of Aditya's brief, where I think you take the position, maybe the APA says no deference, but we don't find that in Article 3. So I think for Article 3 purposes, when we talk about interpretation of statutes, it's generally thought to be a judicial duty. Yes and no. The executive interprets statutes all the time, and it is, I think, an adjunct to the executive power to interpret statutes to carry out the business of the executive branch. So there really is no constitutional problem with the president interpreting a statute. In fact, when the president interprets a statute, that statutory interpretation is going to have controlling weight among those in the executive branch who are interpreting, who are going and doing the things pursuant to that interpretation of the statute that you would normally expect the executive branch to do. The question comes when there is a particular case in a particular court that concerns that interpretation of the statute. So you might say, well, okay, now we're in the realm of the judicial power. We've moved out of, Article 2, and whether you're a unitary executive theorist and you say, well, there's the president and that those interpretations are binding, or maybe you take a different view, but we've now moved out of Article 2. It's not just the executive branch is doing stuff pursuant to the president's or an administrator's directions. We're now before a court. That starts to get a little closer, I think, to the line of Article 3 has something to say about this. And my view is Article 3 can't permit it to be that once you go into court as to a particular case, the executive's determination of what a statute means is controlling. Whatever the text of the APA says, right, it's against this constitutional backdrop. But that's difficult for a few reasons. So, number one, and Aditya, please, if I'm misinterpreting your argument in the amicus brief, let me know. But my understanding is that if you have a greater power, and it includes the lesser power argument, that if Congress can strip jurisdiction of federal courts as to particular cases, it can prescribe a rule as to the deference to which a court is to give the executive branch as to a particular interpretation. I'm a little skeptical of that because, at least in my view, it seems to me more like an on and off switch, right? You can strip the jurisdiction, but once you have granted jurisdiction, there are limitations in Article 3 on, prescribing the particular rule of decision. And there's federal courts doctrines on this as well. Other problems, I think maybe a little more practical, there's the issue of, say, nationwide injunctions and disuniformity among the circuits, right? At least with Chevron, we say, well, there's going to be one interpretation of the statute. That's the executive's. And, the unfortunate thing I think about Article 3 is there's all these circuits, and the circuits sometimes disagree. And that presents complications, particularly for regulated parties, where you might have a different rule, depending whether you're in California or Texas, as to what law am I supposed to follow. You might have issues with agency non-acquiescence in particular regulatory proceedings, because, well, when we're in the Ninth Circuit, the regulation means this, but when we're in the Fifth Circuit, the regulation means something else. We'll at least continue to apply it in the Ninth Circuit. I think the best response is that scheme is basically contemplated by Article 3 anyway, and you still have the Supreme Court to mediate among the disputes and statutory language that the circuits have. Circuit splits happen all the time, but I think there is a legitimate constitutional case, aside from, there's a delegation issue too, right? Do we say Congress has delegated the interpretive authority to the executive, and is that a delegation of a particular kind of, we might call it judicial power. But I think the best way to think about even that issue is this idea of there's a difference between interpreting statutes in the abstract and then what do we do with that interpretation as to a particular case once you get the judicial power involved.
Someone else?
Do you mind if I say something,
Sure,
Joe?
go ahead.
Go ahead. The two of you. Here's the way that I think about this set of issues which overlap, the Article 3 issue and the due process issue. So first of all, it is interesting to me that the general point that Article 3 or the Due Process Clause requires de novo review of legal questions is in fact a long-standing argument that had been made, for example, by Justice Brandeis in, I want to say his concurring opinion in St. Joseph Stockyards. This might be like 1936, 37, sometime around that period. So like 6-7 years before the passage of the APA, there's still an argument floating out there that the judicial power and the Due Process Clause requires de novo review of all legal questions. Having said that, I'm skeptical of the argument applying in all instances of litigation. And I think Professor Walker made some of the points earlier in the day, and Ellie touched upon some of the points right now. The gist of it is that it was widely acknowledged and understood that some determinations by agencies could be cut off from further judicial review. That basically, there would be preclusion of further judicial review for a long period of time during the 19th century. And later on, some of the judicial review occurred through what's known as the writ of mandamus, along which was a deferential standard of review. So this may reflect some of my methodological priors because I'm looking at the practice of that type of preclusion or that type of mandamus review and saying, well, where were the arguments that this violated the judicial power or due process? Those are terms that don't define themselves. We just have to understand them against the backdrop of practice. And then if you take the view that there are circumstances in which Congress can provide for a deferential standard or for preclusion, you might ask the question, well, what's the line? Is there some line where de novo review is required? And here I have a reductio that I mentioned and will mention in my class, and this is the reductio, which is that what if Congress were to say Department of Justice determinations were binding in criminal cases, in capital cases? That would be something that I think would be jarring for most everybody in the room, although I'm happy to hear arguments to the contrary if you find that to be perfectly acceptable. If you think that that is problematic, then you want to know what the dividing line is. And here, the way that I think about it is through the lens of the public-private rights doctrine, which is a doctrine that is before the court in another case this term. Conceivably, we'll have more elaboration on the line there. I understand there are line drawing problems, but in the context of those cases, the court has said that there are certain there's a certain constitutional minimum of judicial review that is required in private rights cases, however defined. And I would think that the same would be applicable here in this context, which addresses legal issues. The public-private rights cases tend to arise with respect to factual issues. Okay, all that is to say that I don't have a firm position on this public-private rights line with respect to Loper and Relentless, but rather I think that before addressing the Article 3 and due process questions, the court would have to confront this line and this question, the line drawing, and that's what I think would be required before there was a constitutional holding.
Jonathan?
Yeah, sorry about that.
No, that's great stuff. I guess I want to say about both the due process and the Article 3 arguments. I think that these arguments have very, very sweeping implications, and I would like to know from proponents of those arguments, maybe some of whom are in the room, if they're willing to bite the bullet on all of those implications, or if they think that there is some distinguishing characteristic. On the due process argument, there are a lot of canons of construction, just to name a small part of the world of law, and Chevron is probably plausibly thought of as a type of canon of construction. A lot of canons of construction that put a figure on the scale on behalf of one party or the other. Just to take the flip side of Aditya's example, the rule of lenity is one of them in criminal law. The rule in contract interpretation that contracts are to be construed against the drafter is another one of them. And so I guess I want to know whether the claim is that the Due Process Clause takes all of those canons of construction and many, many others and lots of other things that have the same effect and makes them all unconstitutional, despite the sort of very obvious and well-enumerated reasons for having those types of canons in the first place. And on the Article 3 point, there are a lot of statutes that confer sort of deferential authority of a variety of types to executive branch actors. So, for instance, there's a statute about national emergencies, which describes the characteristics of a national emergency and then gives the president the power to declare something to be or not be a national emergency with legal consequences. And I think it would be quite peculiar if we said that Article 3 demands that the president's determination of whether something does or does not constitute a national emergency must be reviewed by the courts de novo. And that despite the fact that the statute quite plainly tries to give that decision to the president, that the courts cannot be cut out of the equation in that way. Sort of more broadly, whatever we might think of the judicial power, the sort of plainest conception of it in this world of statutory interpretation, including by Chevron opponents, has been that the courts are just trying to give effect to the law as Congress has written it, and that Chevron deference takes the ball out of Congress's court. Well, if Congress has written the law, we could disagree about what are the circumstances or how clear Congress has to be handing some grant of deference to the executive branch. But if Congress has written the law so as to give deference to the executive, maybe it seemed to further some notion of Article 3 of a judicial role that cannot be usurped to reject that type of deference, but it would seem very much in tension with an even more core notion of Article 3 in the world of statutes, in which the courts are meant to give effect to the law that Congress has actually written down, to say that Congress cannot afford the executive deference.
Yeah, I just want to follow up a little bit on that with a few facts that you might not know. Congress passes canons of interpretation all the time, but you never see them in the U.S. Code because the revisers put them in the notes. There are thousands of them. And there's a law review article by a librarian at Yale, I think, who's actually discovered these. Congress clearly believes that it is doing that, and there are many rule of law justifications for using canons. And what are the rule of law justifications? And this is a big problem for textualists. Justice Barrett goes back and forth on this. She's the most sophisticated on this. But I see it a slightly different way when Congress does this. It's actually giving the courts some help. Because life, this is not policy space. I mean, I know political scientists talk about policy spaces, and I appreciate that with Professor Mercer talking about that. But, let's get down to brass tacks. Life is complex. Even in something very simple, you will have a core of a statute and a penumbra, no vehicles in the park. Everyone believes that it covers cars, right? But do we believe it covers wheelbarrows, bikes, mopeds, electric bicycles? All the kinds of little, new machines that are zipping across the mall. So there's always a penumbra, and it's not simply because the agency wants to do a Democratic or a Republican thing. It's also not because interest groups are telling them what to do, because, by the way, most of us in Washington who get things done know that interest groups kill deals. They don't enact them. But it's because life gives them choices, and I'm sure the judge knows this. Every judge knows the difficulties of applying things in new circumstances. The internet and AI, new technology. This is a persistent factor that causes a set of options that are all reasonable. And in that case, the question is how you're going to make a judgment. And canons actually help judges and agencies actually call the doubts in one way or another. And so I think they should get actually special deference. Of course, I am a departmentalist. I think you're never going to get agencies not to interpret statutes. They do it every day. How many lawyers probably interpret statutes? I don't know, probably thousands, tens of thousands. Congress has to interpret statutes because they have to decide where a statute fits. The question is how you coordinate them and how you liquidate the meaning in a consistent way. And so, in my view, canons actually that Congress enumerates is something that you should be deferential to. And that's not inconsistent with the judicial power.
Victoria, I can go back to you. So you made the point that you didn't think you're not sure that whatever happens in the follow-on cases of Chevron will necessarily impact have much change. And I don't know if is your point that the agencies will tend to just do what they were doing, or is this a reflection also on the courts? Is there any thought that judges currently, even though step 2 requires them to defer to agencies, that they're doing a lot of work in step 1 to reach a result they want to reach? Or if we change the law and make it more of de novo review, that judges will still sort of say this is complicated, and I'm just going to defer to the in effect going to defer to an agency conclusion. Is that part of your calculation? Or?
Yeah, I mean, part of it is judicial capacity. So I was very much influenced by a mentor from my first law school, University of Wisconsin. I'm an economist named Neil Commissar. And he believes that all constitutional cases and all statutory cases are institutional choices. You're ultimately trying to decide who decides, right? Unfortunately, because it describes almost every case, it doesn't help you decide any particular case. So the judge is faced with the question is when am I going to dig into that 1,000-page record or not? And Chevron has been easy for judges in that respect, and it's easy, and I heard some sort of interesting examples of how the agency lawyer said, oh, well, I can choose to our lunchtime speaker, and I was like, I don't know if that's so good. Because that's not how I see Chevron. I thought of it as a tool for judges to be deferential to the accountability of the executive branch. And I understand we've moved from accountability to, oh, let's not pawn off that to a political branch. But I do think the judicial capacity to control, judges, you're a small, hardy, brilliant band of brothers and sisters, but the administrative apparatus is huge. And it affects a vast set of activities that we all engage in every day. And so I worry that the judges are imagining that they're going to have more of a view than they do. If you really want to control the administrative state, it seems to me that you have to elect someone who will control the administrative state. As Professor Mazur said, Chevron itself can be quite neutral depending upon whether your president is pro-regulatory or anti-regulatory. And in my view, most presidents are both pro and anti. They have different policy preferences. So I think, I know that some people, sort of in the liberal camp say, oh, why shouldn't you support Chevron? Well, I am a statutory interpretation person. I do believe trying to get the best answer. I am just less confident that most cases that actually get into court and then are not settled are actually the cases where you can find a best interpretation. And I don't mind telling agency lawyers. Agency law is ossified, it's old. There's not enough throughput, in agency law. And so I don't have any problem with telling them to read the statute, read the statute. But I don't think that this alone, and that's why it's not alone, and that was the point of my talk, which is to say I don't think you should look at Chevron alone. I think if you really want to get a sense of what's going on, it's not Chevron, it's the major questions doctrine, it's pushback politically against the administrative state, as well as relatively more narrowing interpretations of statutes.
Anyone else want to jump in on that?
Yeah, somebody want to push back?
You're looking at me. I'm happy to. I think the point about what are judges exactly going to do if Chevron is overruled, if they have to go and sift through, maybe it's not an 1,000-page record of an agency proceeding, but they have to sift through all these materials of how exactly do we interpret this particular term, which may include reference to legislative history actually can be used sometimes by textualists to understand if there's a particular term, how is it used in context. There are other, of course, contextual clues that judges might have to use. I think Victoria's point is an excellent one, that there are resource constraint issues. If we say to judges, you have to interpret the wide panoply of statutes that ordinarily you might say, well, we're just going to defer. I'd point folks to a great essay that Judge Kethledge did in the Vanderbilt Law Review en banc, where he likens the process of statutory interpretation for judges in agency cases to hunting grouse or partridge. And he says, it's actually quite easy to just go down one path where all the undergrowth is cleared, as opposed to sifting through the undergrowth yourself. Nevertheless, it's important to sift through undergrowth. The countervailing, practical point about, well, that's a lot for judges to do, and perhaps judges don't want to do that. is probably bolstered by the fact that today the major questions doctrine, operating as King v. Burwell understands it, as a carve-out for the Chevron cases, actually takes a good number of the cases off the Chevron docket in which the judges might be the most excited about going through that statute and digging through to try to figure out exactly what the meaning is, the sort of cases that you might think, if judges are thinking practically about, well, what's the best rule, those are the cases they probably would want to do all the work on the most. I think part of this is we don't know how far the major questions doctrine expands. It may be that economically and politically significant rules or regulations is actually a smaller subset or a truly extraordinary number of cases or not. But the resource constraint point is one that I think is going to deserve significant attention, both in thinking about, well, what is the consequence of departing from Chevron's rule, and also, are there things that the bar and maybe Congress needs to do to better equip judges with the resources to undertake, or maybe we would say the judiciary generally, with the resources to undertake rigorous, you might call it relentless, based on the eponymous case name coming up this term, review of statutes that the agencies have interpreted. But it's a difficult question. It's one that I think judges are going to be faced with if Chevron is departed from.
Jonathan?
You go ahead, please.
Are you sure?
Yes, I am. So this is actually the case that I was thinking of, where potentially, if the court were to move, in a direction closer to my view in Loper Bright, there might be a different outcome. And as I was speaking, I was thinking of this case, even though, potentially people in the room will know the particulars of the statutory scheme more and say it doesn't actually turn out differently. In the case of Brand X, that's the case that I was thinking of, so many in the room will know it. But if I start by zooming out, I think that those cases where everybody agrees under the Chevron framework, Congress has directly spoken to an issue, what we might call Chevron Step 1 cases, they're coming out the same way, right? Whatever the court does in this universe. And then we had previous panel discussions on Justice Kavanaugh's concurrence in Kaiser versus Wilkie that said, well, if the term that's used in the statute is so general that it really is not subject to interpretation, terms like reasonable, permissible, things of that nature, then presumptively that's subject to arbitrary and capricious review. Those cases are also not coming out differently, and that does pose the line drawing problem then between statutory interpretation and arbitrary and capricious review that Professor Bressman talked about earlier today. But setting that to one side, the cases that are affected are those cases where one might say there's a best answer, potentially a best answer, but there are permissible alternatives. And Brand X is sort of the exemplar case to me of that universe, and that's a case in which there was a prior Court of Appeals, Ninth Circuit opinion, that had held that cable companies selling broadband internet service, that they provide telecommunication services, hence they're subject to mandatory common carrier regulation under the Communications Act. And the agency had flipped back and forth, and those of you who are following the agency know that it's flipped again on this question. And the court in Brand X said, well, even though there was a prior Article 3 holding that this was the best interpretation, now granted, in that case there's the complication that it was a Ninth Circuit holding that maybe was not correct, and we could debate that, but that would be a debate about telecommunications law and what the Communications Act means. But even though there was that type of holding, a holding on the best interpretation doesn't preclude an agency from adopting a permissible alternative. So if we were to agree with the Ninth Circuit, the telecommunications service provision was best interpreted as the Ninth Circuit did, then I think Brand X comes out differently, and that's a case that concretely, potentially comes out in a different way.
I just want to say something quickly about sort of this original question of what the world will look like if Chevron is repealed, what will courts be doing? I do not think that as a matter of their statutory interpretation exercises, courts will be scouring multi-thousand-page administrative records regarding agencies. I think that they'll be using the ordinary tools of statutory interpretation, which is what
Chevron tells them to do at step one in the first place. If there are judges who are especially pragmatic or especially consequentialist, they might sort of take a little peek ahead to exactly what that agency record looks like. But for the most part, they'll be looking at text and context and structure, maybe at legislative history, depending on the judge, maybe trying to define the purposes behind the statute, depending on the judge. But by and large, the sort of typical practice of statutory interpretation. But that's not to say that judges aren't looking at those materials anyway. They are. It's just they're doing it as a matter of arbitrary and capricious review, hard look review. That's where that is taking place. And sometimes in some courts, in some places, it takes place with particular stringency. Courts give a really hard look at what the agency has done. Other times, it takes place with a much more sort of lenient and deferential eye. And I would sort of shout out the work of future panelist Caroline Seacoat on this point. I think has done a really nice job of sort of illustrating when and where the courts are more and less stringent with regard to the rationales for agency action, whether those rationales make sense. I think the right way to think about Chevron, though, is if we had a regulation that was otherwise going to pass arbitrary and capricious review, it's going to pass hard look review, because what the agency did was sensible, made sense as a policy, was based on sound reasoning and so forth. And it was one of many or several permissible constructions of the statute. Should the courts nonetheless be striking that policy down if it doesn't fit the best interpretation of the statute? That, I think, is those are the stakes presented most clearly by Roper.
I just want to take two quick questions. One, 2 quick points on this. One, I think what judges are going to do is they are going to use the same tools. Justice Scalia loved Chevron. He expanded Chevron. And that's why I'm saying something new might be going on with this pushback. So I think you can use all the tools you have for statutory interpretation. And I don't think they're going to be looking in records, as Professor Mazur said, to find that meaning. Now, I do think what's going to happen, and this is suggested by Professor Bamzai's remarks, which is you're going to see shifts from the meaning of the statute to a field of statutory application, from law to fact if it's hard. Because these do, in practice, if you ask, I'd ask Judge Riedler here, you ask judges about this, and they say, well, I think of that as a problem not of the meaning of vehicle, but of its application in this certain circumstance. And so when judges are uncertain about the bubble concept, whatever, they'll recharacterize it to some extent as not a question of the statutory interpretation, but as a question of fact when there is uncertainty in that area. And that is in of itself an interesting will be an interesting phenomenon. It'll make judges in the lower courts' lives, I think, a lot more difficult, in the district courts' lives more difficult, but there you go.
Jonathan, can I go back to you? Do you see a larger trend here with, say, Kaiser, with the development of the major questions doctrine and what that portends maybe for the future of administrative law and regulation? And I was just going to reemphasize a point you made earlier, which maybe you want to expand on, which is that doing away with Chevron might also make it more difficult to deregulate. So for administrations that want to deregulate, that this would in some ways be a barrier to doing so?
Yeah, I mean, I think, right, I think that it's not, it doesn't take an administrative law expert, self-proclaimed or otherwise, to notice that the court has issued a lot of decisions across a lot of different policy areas that at least look on their face as if they are cutting back on the authority of federal administrative agencies in one way or another. The major questions doctrine is probably the most famous of these. The spending clause line of cases involving the CFPB case that was argued 2 weeks ago, I think, is another extremely sort of important potential line of cases, though it looks like the court may uphold the constitutionality of the CFPB there. Victoria mentioned earlier the appointments and removal clause cases. Those are especially important as well. And I think that all of these things and Chevron get sort of lumped together as court goes after administrative state. And I guess part of the point that I want to make is that I think that the rest of those doctrines are much more sort of unidirectional in the sense of having the net effect of curbing agencies' authority to regulate and the sort of expansiveness or stringency of the territory that they can take up with their regulation, whereas Chevron is much more equivocal, much more symmetric along those lines.
Any follow-up thoughts? Or?
So I mean, it's obviously a debate for another moment, but I do think, for example...
We have a minute, so give it your best shot.
What other moment? What are we waiting for?
The removal cases, for example, did allow President Biden to appoint a new head of the Consumer Financial Protection Bureau, as well as a new head of the Social Security Administration. So, in some ways, they also could cut in different directions.
I agree with that, actually, just because, although potentially they're operating on what I think is not a formal separation of powers, but a functional separation of powers model that's embedded in their formal categories. And that's why I find it very uncertain to me about what they're going to do. That uncertainty causes a certain amount of disruption. It's difficult for the White House counsel's office to decide who can you remove and who you can't. Because now SELA law has been amended by Collins and Arthrex, and one's a patent case. No one wants to read the patent case.
How dare you?
It's quite uncertain.
You're a textbook author, so...
Yeah, I know, he does.
Yes, he does.
But I also think that they don't...
Put it in the book, yeah.
There is a faction on the court, including the Chief Justice, who goes with the principle but did not do the most extreme remedy. Let's just put it that way. So I don't see them as being extremely disruptive, but they are uncertain.
Yeah, last comment.
Okay, so just to very quickly about a point Aditya made about the appointment of the new CFPB head. I think that's unquestionably correct in a static sense. Like at any given moment, given the structure we have currently, if a president can all of a sudden remove a head and replace it with their own head, that might have any sorts of consequences depending on who the president is and what their regulatory agenda is. I think it's really in a dynamic sense in which decisions like that have a sort of anti-agency effect overall, because there are probably a lot of agencies that would not exist and do not make sense if they can't be politically insulated. The Federal Elections Commission, I would submit, is one of those agencies. The Federal Reserve is plausibly one of those agencies as well. And so if moving forward, I don't know what the world of future agencies might bring, and maybe we will have no more agencies at all. There's no need for any further agencies going forward. But if we were to look backwards, if those cases had been decided 200 years ago, before these agencies were created, and Congress understood that every time they made an agency, they had to place that agency fully under presidential control, and they could not insulate the head of that agency or heads of that agency with removal protections, probably our agency landscape would look a lot different and in many cases a lot smaller.
Great. Please join me in thanking our panelists. This was terrific.
Good job.
Thanks, that was great. Just take a short break. We'll be back here at 2:45 for panel 4, The Future of Deference in Environmental Law, with a set of great professors and moderated by Doug Ginsburg of Scalia Law School. With panel 4, the future of deference in environmental law, and I'm so pleased to be able to introduce the Honorable Doug Ginsburg, who wears many hats. He is a senior judge, formerly the chief judge of the U.S. Court of Appeals for the District of Columbia Circuit, and in fact, I first worked in close proximity with Judge Ginsburg when I was a lowly law clerk the first term that Judge Kavanaugh was on that court, and so I know you all were great colleagues and so well respected on the court, and he is Judge Ginsburg is also a professor of law at Scalia Law School and affiliated with our Law and Econ Center, and he will introduce the panelists, but I have to shout out Caroline Seacott from Scalia Law School and Law Review Advisors, so she's had a lot of influence today in many ways. And then finally, it's been so heartening as a professor to see so many law review students, but also other students, con law students, administrative law students from Scalia Law venture out here downtown to the Mayflower on a Friday afternoon when there are a lot of cases to read and papers to write, and so it's just a great sign of the intellectual engagement here in DC and at Scalia Law School in particular. And without further ado, I'll hand it over to Judge Ginsburg.
Thank you, Jen. Can it be heard in the back? Well, you all have been here, I hope, all day. I just came from court, so I don't know what has been said, and therefore you should not refrain from repeating things that other people have said. All right, we're going to hear first this afternoon from Caroline Seacott. Her credentials are in your program. We're going to then move to Professor Emily Hammond, and then finally to Don Elliott of both the Yale and Scalia Law faculties. And after we've heard from each of them, relatively briefly, there'll be some crosstalk, and we're going to open it up for questions, so note your questions as we go along. Caroline.
Perfect. Okay, so thank you for having me here. It's been such a great conference. Surprisingly, I'm not tired. I'm very energized at this moment with all this great conversation that happened before. So I was talking about this with Emily before about whether this expands what I want to say and contracts. So because of everything that's been said before, I'm going to try to focus my remarks on the things that I either haven't been said to not be repetitive, or things that maybe I disagree with some of the panelists, but please don't leave with the feeling as if I'm mostly disagreeing with everyone. I agree with tons of what's been said before. It's terrific panels. So 3 comments that I want to draw out in my opening remarks. One is I want to say something against the carve-out, which is part of the issue that the court took cert on. So this might be thought of as a compromise position, so it might be attractive to the court, and there's been lots of scholars, some that are here in the room, who have written really wonderful commentary about different kinds of carve-outs that occur. But this one in particular, I think would be worse than getting rid of Chevron entirely, or at least that's how I view it, and I'll make some arguments there. The second point, I want to bring in the environmental context. So a lot of what we've talked about or heard about today was about Chevron in the abstract and sort of divorced from the Loper-Bright specific context. I think that context is really rich. I think also illuminating itself, so I'll bring it in. But also, in general, the environmental context, and I know some of my co-panelists will also talk about this, is an area where a lot of this could really matter. We have lots of trade-offs. We have need for flexibility, quick changing facts on the ground, and the context itself, just expertise about the history of these different sectors could also resolve a lot of perceived silences or ambiguities. And then third, I want to talk about a little bit the actual question in this case, which is the question of the funding. I'm going to actually give a shot at arguing that maybe the agency should win at Chevron step 1. And so I already heard someone crying, so I know this is not going to be popular. I mean, controversially, I'll also use historical context, but also legislative history. So all this to say, you might not be persuaded by anything that I say, but that it's unambiguous, that's step one, but maybe you're persuaded that it is ambiguous. Or at least you might be persuaded that it doesn't raise an inference that the agency does not have the authority to do what it did in this case, that it doesn't raise that inference of lack of authority. And I'll consider that being somewhat successful at that stage. Okay, so we've heard a lot about the original Chevron decision. We even had some quotes up there. So unanimous Supreme Court acknowledged, specifically mentioned that it wants to accommodate competing interests. Congress might not specifically resolve every relevant question. Congress might leave a silence, and it might be intentional. The silence was actually left to the agency due to the agency's relative expertise, or its lack of constituency pressure, or the silence might be there inadvertently. But in any event, and this is a quote from the opinion, for judicial purposes, it matters not which of these things occurred, according to the court. So already now, this is not true at this stage. This is before any decision in Loper-Bright. So now, as we've heard from other panels, if the question is major, the court recently declared that congressional silence will not suffice to authorize an agency to decide how to accommodate recognized competing interests. After West Virginia v. EPA, Congress must either explicitly allow the agency to make this call or decide the matter on its own. And in the absence of that kind of explicit authority to make that decision, the agency cannot decide these kinds of major questions. Now, in Loper-Bright, the court is taking up a question about whether one to overrule Chevron, which has been the focus, which would end judicial deference outright, or to further narrow the application of Chevron, but this time to statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute. That does it does not constitute an ambiguity requiring deference to the agency. So this option builds on a history of narrowing or clarifying Chevron and other deference doctrines, again viewed as a compromise position. Lots of interesting proposals in this space, so including, as mentioned before, carving out adjudications, immigration, criminal context, and others. But my contribution to Symposium argues that this particular form of narrowing Chevron's applicability is not a compromise, and in fact, depending on the details, could be worse than overturning Chevron. I argue that it's essentially unprincipled, that any ambiguity could be reframed as silence about some question that you can introduce. And again, this is in the context of a non-major one, so really any minor question. And some silence is frankly inevitable due to Congress's relative lack of technical expertise, and the context of Loper-Bright is a perfect example of this. And then this particular silence, which is based on an express but narrow authorization elsewhere in the statute, the issue is presented as whether Chevron should apply, but if you read the petitioner's brief, it shows that there's more to this. The petitioner suggests that such silence regarding a power expressly and narrowly granted elsewhere should, in essence, give rise to an inference that the agency is not allowed to do this at all, not just an argument that Chevron doesn't apply. That is, the argument for not applying Chevron is the same as the argument for the also not agreeing with the agency doing this or having this power. And that move, subtle, is makes this more like West Virginia v. EPA, but for everything. And its impact would be greater than denying Chevron deference altogether and doing more work, and I'll talk a little bit about the other kinds of solutions. And because it would apply for any non-major issue that could be invented, it would also mean less likelihood, because it's a non-major issue, that Congress will step in and clarify than is the case for major questions, which means that mistakes would be less likely to be corrected, and then the consequences could actually be greater despite it being more minor questions. And the context of Loper-Bright, fisheries management, is again a perfect illustration of this. Because now it matters why Congress might have been silent. So, like I mentioned, I took a deep dive into the legislative history of the Magnuson-Stevens Act. especially the hearings surrounding its reauthorization in 1989. That's because the 1990 amendments created this silence in this case that the case is focused on. So the original version of MSA required observers on board foreign vessels and required the vessels to pay for these observers. For domestic vessels, regional councils had the authority to make fisheries management plans and then to amend them as necessary to protect the fish stocks. Now, the problem of common pool resources, such as fish stocks, according to economic perspective, is that participants acting in their own self-interest will overfish, destroy the stock. So regulation can come in, can prevent this by setting quotas or something like that. But here's the key part. To do this effectively, the regulators need lots of information and accurate data. So the data has to be accurate, has to be comprehensive, has to be current, has to be on the ground, responsive to any stressors in the fisheries that can come from both environmental factors and overfishing forces. There's a story about the cod fishery that I probably need to sort of skip, but basically the council, the relevant council, delayed implementing the quotas that it thought were recommended because of concern to the effects on communities, fisheries communities, and guess what? The fishery collapsed the next year. And scientists going back to this point have found that if they had implemented the original quotas, the fishery would likely have not collapsed. So in the late 70s, 80s, the fisheries were at risk were dominated by foreign vessels. So the observer requirement on foreign vessels did a lot of the work on gathering the data that the regulators needed to set these quotas. But over time, the industry became more domestic and information plummeted, and then fish stocks were seriously at risk. This problem was especially acute in the North Pacific Fisheries Management Council area. In January 1989, the council, in fact, reported to the Secretary of Commerce that it simply did not have enough information to do its job under the statute. That June, this is again 1989, while hearings were already taking place in front of Congress for the reauthorization, the council made a bold move. It required domestic observers, and it told the industry they had to pay for them. 100% coverage on vessels over 125 feet, 30% coverage on smaller vessels. The vessels would be chosen by lottery, and then whoever got chosen pays all of it, okay? If they didn't like this, and here I took the minutes, I just printed them. And if they don't like this, they need to go to Congress. So this is what they said in the minutes. Some council members expressed concern over funding for the program. Don Collinsworth suggested that the industry should go to Congress asking for a special appropriation of 100% funding for the first year in order to get the program underway, and a declining appropriation for the next 2 years with the goal of having the program totally industry funded by maybe the 4th year. So that's from the minutes of what was going on. In August, so just shortly, a few months after this, hearings were taking place in the area of the North Pacific, and the industry did come before Congress, and they lobbied hard for a change. A big reason why they didn't like what happened before the council was because they thought it was not fair, that who got chosen among the small fisheries to have that observer now had a competitive disadvantage, and there should be some fairer way, and Congress should step in. So in August 1989, Congress had these hearings. Now for me, a notable silence was the silence related to the council's actions. And council members, again, and industry were all before the Congress. Nowhere did I see anyone argue that the council was not empowered to do this. What was expressly discussed was the ambiguity in the statute about whether, if the council wanted to make this more fair and spread the costs around, if they could do something like a user fee in this case. And maybe there was some language. Industry also argued that it'd be great if taxpayers would chip in because, you know what, they benefit somewhat too. But that was met with equal arguments saying that industry should bear this as a cost of business. So I'm about to get really pulled off the stage here. So I guess I'll just end with, I'll just end there. And anything else I'll have to say, I'll say later. But thank you.
Emily?
Well, thanks so much. My mind is swimming with all of the discussion already today. I thought I would make a few points. One is I just have a thing I want to flag as a practical matter from the standpoint of energy and environmental law, but then I'll go into sort of more traditional points where I'd like to really focus on expertise and what it is, what we mean by deference to expertise, and what we might look forward to in the future, and what we might push for as scholars, advocates, and judges. So just the practical point I'd like to make. We have heard a lot today about the destabilizing impact of this uncertainty around Chevron, not to mention how the major questions doctrine will be applied in the future. And I just want to point out for the climate change imperative, for the kinds of investments we need at the intersection of energy and environmental law, we need some stability. And the thing that I'm worried about is we don't have a lot of time to wait on that stability. And although I think we might be able to predict more stability in the future once we kind of get through this phase that we're in and we know how things look, investors are looking to make decisions that require stability now. So my co-author Jim Rossi and I have written about stranded costs and grid decarbonization, for example. So I just wanted to say we're in a time frame where timing matters for the substantive area that we're talking about. Okay, so moving on to expertise. I will say a little bit first about what it is. We've heard a number of conceptualizations of it today, and I do have quite a bit of agreement with some of the concepts. It's used very loosely in administrative law. It's under-theorized in the judicial opinions that we see, and we certainly see a wide variety of ways that courts treat it in the case law. It might mean general familiarity with administering a statute. It might mean unique expertise because of being present for the statute's original implementation. It might be the kind of policy-laden expertise that was at issue in Chevron itself. It might also be the sort of comparative institutional competence expertise that we see regarding scientific and technical matters, particularly emblematic in the Baltimore gas decision from the Supreme Court. We also see kind of a mishmash of these things all put together, and a great example of that is Justice Kagan's plurality decision in Kaiser versus Wilkie, where she has a huge paragraph that goes through these kinds of expertise, but doesn't really say anything about how we're supposed to use them or what they mean. And I submit that expertise is really a combination of all of these things. What agencies do so well is bring those subject matter experts to bear on very complicated, especially scientific and technical decisions, especially in environmental and energy law. But those are not just scientists and engineers, of course. They're economists, they're political scientists, they're the lawyers. They're all of the people who look at what the statute means, but also provide a lot of information about how to actually carry out Congress's purposes in implementing the statute. I want to say Liz Fisher and Sid Shapiro have written an excellent book really detailing and building up this robust account of what expertise means. And I think it's consistent with what we heard from Paul Ray earlier today, this idea that it's very rich. It's not a thin idea of somebody just counting beans or taking water samples. There's a lot more that goes into an agency bringing its expertise to bear on something. So I make this point for a few reasons. The first one is internal to the agencies are legitimizing norms for how that expertise is brought to bear in making ultimate decisions. Some of those are professional norms. Some of those are the kinds of norms we heard about from Paul Ray earlier, the idea that various subject matter experts have various points at which they have to justify and explain what it is they're bringing to the particular problem at issue. So we also have, of course, the expertise of synthesizing all of this, this material. And those processes internal to agencies help support transparency, accountability, the kinds of things that we look to for legitimacy in the administrative state. And then that moves me to my second point, which is, well, what do we mean by deference to expertise? And here I will depart a bit from the Chevron framework because this idea of expertise being something to consider in the level of deference that a court gives pervades administrative law generally. As you all know, it's not limited to Chevron. And this is also true if we think about step 2 of Chevron being somehow merged with arbitrary and capricious review. I think it's also true if we take Professor Bressman's conception, which I agree very much with, that hard look review, the sort of classic arbitrary and capricious approach, is a place where we might see a lot of these battles shift. So I'll start with just a few words about that Baltimore gas decision. This is the super deference idea that courts should be at their very most deferential when agencies are making decisions in light of scientific or technical uncertainty. I have a prior paper where I have done a huge review of that case and its history, and bottom line is the court actually never relied on it again for that principle. And in the lower courts, although you see quite a lot of citation of Baltimore gas, overall, and there's lots of fluctuation, a lot of the decisions that cite Baltimore gas for super deference actually engage in an analysis that looks a lot like traditional hard look review. And I think this is beneficial. So we heard earlier this idea that, well, if agencies are able to communicate their expertise internally, they ought to do it for the courts. Well, they do. That's the record. This is something that's required as a matter of administrative law already. So I think what we can be asking is for that to translate into the briefing that the parties bring to bear and what the court will do. And I think we should be looking for courts to really engage how the agency exercised its expertise. Now, I want to be clear, I still advocate for deference in the sense of State Farm, not substituting the judgment for that of the agency. In any particular decision, we could disagree or agree about whether that has happened, but as a principle, I think that's right, with this idea that there should be some judicial engagement. And there's a few reasons for that as well. One is it reinforces those internal norms of legitimizing practices that we already have within the agencies. Second, it promotes accountability both for the agency by providing a generalist description of the kinds of things that the agency considered, and for all of the other individuals and institutions that are interested in what the agency is doing. It also helps legitimize the courts. And I think Tom Merrill made a point earlier about judicial legitimacy. It helps us show what the courts are doing. I think it undermines judicial legitimacy to either be too deferential or to be so deferential that they're not even engaging. So let me just say one more word coming back to Caroline's point about the carve-out. So I'll bring it back to Chevron in general. And here, at great risk perhaps, I want to bring up a recent DC Circuit case that Judge Ginsburg, you actually authored, Maine Lobstermen's Association versus National Marine Fisheries Service. So this involved the service's biological opinion regarding the endangered species of the right whale, and essentially a plan that would impose a number of restrictions on lobster fisheries. Very, very detailed procedural chicanery before it got to that substantive question. But here the service was missing some data about the impacts of survival on the right whale. And it made some assumptions that were precautionary. It essentially said, we're going to fill those gaps, those data gaps, with the idea that we're going to be as careful as we can with respect to putting in presumptions that would favor the species survival. And they said this is something that the legislative history of the Endangered Species Act suggests we do. The court's analysis, I think, did engage quite well with the agency science, But it also hinted at sort of a backdooring of this idea that if the statute is silent, maybe we'll construe it against agency authority, citing sort of this idea that the agency was asking for an aggressive reading of Chevron, one that would allow it to fill that gap, citing the DC Circuit decision of Loper-Bright, and ultimately concluding that the statute was silent as to whether the agency could adopt a precautionary principle. And so in this example, it couldn't. And I think there's a lot of nuance there that I'm probably not capturing. But what I'm worried about is the many environmental and energy law statutory schemes where agencies are asked to make decisions, and they very frequently find it as best aligned with the policy of the statute to make a precautionary assumption. And we see this, of course, all of the time in EPA decision-making. Whitman versus American Trucking Association was just such a case. If we start construing those kinds of decisions as statutory silence, and we start also saying that those need to be construed against the agency operating in this particular way, then I think we're going to see significant upsetting of a lot of expectations that we have about how energy and environmental law operate. And so I'm going to add on to Caroline's caution that carve-out in Chevron, in the Loper-Bright cert question is hopefully not a direction that we'll go. So I'll stop there. I know Don has more to say about some of these things too.
Yes, so I'll certainly wait to hear what Don has to say before venturing even so much as a thank you.
Thank you very much. It's a great pleasure to be here, and I think pretty much everything that can be said has been said throughout the day, so I won't go on for too long. Samuel Taylor Coleridge wrote in 1819 that every reform will be carried to extremes and will become the instance for further reform in the next generation. And that seems to me to be what's going on in Chevron. I side with the people on the first panel, including Tom Merrill, who said we should amend, not end Chevron. But I think if we were to end Chevron, part of my point would be it really wouldn't change things that much. I think there'd still be deference to administrative constructions of statutes for some of the reasons that I'll talk about. I think some of the abuses of Chevron have been the use by agencies to try to expand their authority, and therefore I think decisions like the Major Questions Doctrine and West Virginia versus CPA are useful correctives to misuses or carrying Chevron too far. On the other hand, what I perhaps uniquely can bring to the conversation is the experience of having been inside an agency. I was general counsel of EPA in the late 80s and early 90s when the agency was really just first adapting itself to Chevron. And at that time, typically we had this, I think, legal fiction that a statute was a sort of magical code of instructions by Congress as to how to answer every question that came up with regard. And in fact, I think Chevron fundamentally reconceptualized the notion of a statute, and it I think took a more realistic view that Congress didn't have an intention, certainly not a majority that was enacted on most of the questions that come up in the implementation stage. And so I think the important issue with regard to Chevron is how to handle these implied delegations. And what Chevron does, I think, is it, as Jonathan Mazur said in the prior panel, creates a kind of policy space that's defined by the limits of the language. And the question is, if there are multiple potential interpretations within that policy space that are all consistent with the language of the statute, Which is a better way to decide? Is it better to have the agency make that decision and then have that be reviewed by a court? Or is it better for courts to make that decision for themselves based on the statutory canons of construction and other techniques? I've had a many-year-long conversation and disagreement with my colleague at Yale, Bill Eskridge, who's one of Virginia Norse's colleagues. He's in favor of having judges make those decisions rather than agencies. I think agencies should make them in the first instance, but I agree completely with Paul Ray that the decision makers within agencies should convey their expertise to the courts so the courts can review them. That's what I thought the step 2 process of determining whether or not the agency's interpretation was reasonable was supposed to be about, is the agency conveying to the court its reasons for adopting one permissive interpretation as opposed to another. And I think what's been overlooked in a lot of the dialogue about Chevron is it talks a lot about the relationship between the courts and administrative agencies. What's been overlooked is the dynamic within agencies. And when I came to EPA in the late 80s, the lawyers in the Office of General Counsel were running the agency. They were basically telling all the program offices of the so-called subject matter experts what they could and couldn't do by way of interpreting the statute. And Chevron changed that in a way that I think was fundamentally very healthy and I hope isn't lost. Well, what if Chevron were to be overruled? I don't think it would be an earth-shaking change. There's a case that hasn't been mentioned that I learned about in administrative law in law school. It's called Hearst versus NLRB, decided by the Supreme Court in 1960. And the question there was whether or not newspaper salespeople on the street were employees or independent contractors. And the Supreme Court upheld the notion that the NLRB could designate them as employees under Democrat administrations and exempt them from NLRB protection in Republican administrations. In other words, that Congress had, by not defining the term, had delegated that question to the agency, and as long as it had a reasonable basis, its decisions could be upheld in either direction. Congress always has the opportunity of defining some of these vague terms, and I think the idea in Chevron that it's an applied delegation if Congress has chosen not to define a term and has given the agency rulemaking authority. The correct reading of Chevron, and I admit that on the same page there are two different phrases, but I think we've spent too much time talking about ambiguity. The other language in Chevron, which I think is more useful, is did Congress make a conscious policy decision on this issue? And everyone agrees if Congress made a conscious policy decision on this issue, that's binding on the agency. Tom Merrill mentioned earlier in the Chevron case itself, there was a definition of stationary source, but it only applied to one program. It only applied under one section of the statute. Nobody ever thought that in the section to which it applied, that the agency was free to adopt the bubble policy as opposed to the statutory definition, which was very specific that a stationary source was a release point. Well, what would happen if Congress did overrule the Chevron decision? I think the Maine Lobsterman case by Judge Ginsburg is a very good example. He was dealing with the Endangered Species Act. I don't agree with Emily that it was a case of statutory silence. There was pretty specific statutory language there that said the agency had to make a determination that the elimination of the species was likely. And I believe that that language was really crucial and distinguishes that case from many of the EPA statutes. A former head of science at EPA, Paul Gilman, once said the purpose of risk assessment at EPA is to make sure that the agency never underestimates a risk to public health. That makes a certain sense from an EPA perspective, given its mission. But I think that if we overrule Chevron, what will happen is there will be a lot of case-by-case litigation in front of judges, focusing particularly on the extent to which agencies, particularly the EPA, is permitted under its statutory language to adopt precautionary approaches. And I, for one, think that courts will not do as good a job of answering that question as agencies do, but subject to judicial review. And I think the real problem with Chevron has been that the stage 2 reasonableness review has not been searching enough. Agencies should be required to state clearly, as Paul Ray said, the grounds for their policy interpretations, and judges should review them under arbitrary and capricious and hard look review. Thank you. That's it. I finished early, though.
Yes, you did. You have 1 minute left. Well, thank you, John. Before we go on, I'll just say about the lobsterman's case, and I've seen quite a number of cases since then and been deeply involved in records, so I don't have a complete command of it, but my recollection is that a turning point, or a crucial point in the case, as to some of it at least, well, as to the precautionary part, was that the agency itself had repudiated that in a prior instance. So first they were relying on legislative history to that effect, and then later on repudiating it and then coming back to it. And that created a bit of a hurdle for them, for their claim of expertise. And I think that's quite different than the labor board situation, with which I agree with Don. The labor board was created. When the labor board was created, the River Rouge plant was being occupied by the nascent UAW adherents. There was violence in the streets, and the board's charge was to make all of that into a legal proceeding in which the lawyers would speak instead of the people on the street or in the occupied. And it did it. And Julius Getman's book, The Myth of Labor Board Expertise, in 1972, I think it was, documents the way in which, with regard to electoral campaigns, what Don described happens with regularity every 4 or 5 years when the board changes, and they make a different presumption about the likely reaction of workers as to whether something is or is not coercive. I think that's their job, to manage conflicts. And we've got these irreconcilable positions. The quadrennial election governs it. Not a terrible thing. Caroline, you want to have a crack at one of your colleagues?
I'm good on that front. I do want to actually, yes, I'll say something. Because I spent a lot of time talking about Chevron, but Chevron's a doctrine that I like it for the reasons that, I guess I'd be a judicial conservative by how it was outlined. I like it for the reasons of leaving policy decisions elsewhere. I like it for the reasons of consistency. But one thing that always bothered me about Chevron, at least how it's been applied, is exactly that point, Judge, that you make, the step, and Don and Emily too, the step 2 analysis that has not been historically rigorous. And so it leads to a potential oscillating feature that doesn't seem tied to expertise, and that's when a lot of folks start to get uncomfortable because the other rationales for Chevron deference seem to have some other problems associated with. So I just want to paint the picture of a world where, which is something I agree with, I've argued for this in other cases, where just talking a little more about arbitrary and capricious review. So if that happens so to the extent that a court does not think that an agency applied the expertise that it has to potentially bear on this question, that's what arbitrary capricious review is. And that could be very easily combined in that, or explicitly made to be combined in that second analysis. And already the court has made some steps towards it by announcing in various ways that there shouldn't be deference to a reasoning that's a result of an interpretation that's a result of arbitrary and capricious reasoning. But what's What's important about doing it this way, though, is that this isn't wrapped in, this is distinct from de novo because it doesn't enshrine any particular point of view on what is a policy question that needs to be informed by expertise. It means that the agency is not foreclosed from coming back to it and actually looking at the evidence that it has on this issue or changing it if facts change on the ground. So I think it is a vehicle that better expresses some of these concerns about expertise and flexibility. And if courts force agencies to apply expertise, you don't have that policy oscillation issue. I think it would result, and I've argued this, in stability, except when we wouldn't want stability, which is when, again, facts on the ground have changed and there's a reason to reject the prior approach because of new scientific findings or anything else that would be a reasonable reason to change an interpretation or its application. So thank you.
Yeah, are you responding to Caroline?
Well, actually, I had further responses.
Oh, go ahead.
Yeah. I just wanted to thank you for pointing out that aspect of the lobsterman's case. What was interesting to me, and I'll respond as well to Don's point here too, is that I think that the agency's oscillation without explaining itself alone was grounds for remanding the decision, and that's why I was so intrigued by this language that talked about the version of Chevron where silence gives an agency-wide latitude has fallen into desuetude is the language here. And so, at least in this part of the opinion, just reading it on the surface, it looks as though in response to the agency's argument that it's operating within scientific uncertainty and it's appropriately making a presumptive choice, that is characterized as an argument about statutory silence. And here's where, Don, yes, of course, there's the not likely to jeopardize language in the Endangered Species Act, and we have different language in a number of the other environmental statutes. But I don't know, this goes back to Victoria's point, what's the best interpretation? Does not likely to jeopardize mean that being precautionary is the best interpretation or not? And so, or silence, right? People could disagree about that. So I just wanted to, maybe one other thing. I also have served in an agency just recently. I was an appointee in the Biden administration at the Department of Energy. And I just want to maybe respond to some earlier comments today. The conversation was constantly, what is the best interpretation of the statute? Obviously, that is going to be influenced by the various viewpoints of all of the people considering that question, some of whom perhaps preferred interpretations from the prior administration. That actually made a really great area for experimenting and playing off ideas and really making the rationales that we did put forth, I think, a lot stronger. But that certainly was always the question that we were asking.
Yeah, but John, please.
Yeah, I'd like to pick up on this. I think that one of the lessons here is that all of these cases are really context-specific. And they are very much influenced by the language of the particular statute, but also the interpretation history. That's the State Farm decision. Right. Certainly, if an agency changes its interpretation without adequate justification. I guess what I would say is that the Chevron framework can be applied by a diligent judge in a way to ask the right questions. But it's also very tempting to judges who are somewhat lazy to simply rubber stamp at Chevron Step 2.
Yeah.
And I think that if there's going to be an amending or a clarification of Chevron, I would hope it would be more in the direction of what Chevron Step 2 should look like to make it real review of the agency's justification for adopting the interpretation that it adopts. I think we all agree that if if we are able to determine from standard materials that Congress made a conscious policy decision on this issue, that's binding on both the agency and the courts. There's really no debate about that. The difficulty becomes, what do we do in situations where Congress either didn't think of the problem, or if it did think of the problem, it wasn't able to reach a majority consensus on how to solve it, but it delegated it to the agency. And where agencies are dealing with delegated ambiguities in the statute, I think the idea of letting the agency make the decision in the first instance, state the grounds that justify its policy decision to adopt one interpretation as opposed to another, I think that's, but have it be subject to rigorous judicial review in the same way that other discretionary actions by agencies are subject to judicial review. I think that's a fine template. I think the real problem with Chevron is it tempts judges to sometimes make that second stage a rubber stamping, just as I think Baltimore Gas and Electric does, even worse. I have a little article for the Gray Center about abolishing what I call no-look judicial review as opposed to super deference. I think the idea of super deference is kind of incoherent, because deference is basically the idea that I sometimes say to my administrative law classes, deference is the right to be wrong, as long as far as the court sees it, it's the right to be wrong as long as you're wrong reasonably.
Well, do you disagree then with the proposition that often cited, but in fact it looks just like ordinary hard look review?
Yeah, I do.
Is that your point?
I have spent some time trying to find a case since Baltimore Gas and Electric where EPA or other agencies in the environmental area have been reversed for lack of factual support in a rulemaking. And I've been unable to find them, and I've consulted with several other people, and they're unable to find them. So I do think that Baltimore Gas and Electric has tempted many judges who find themselves uncomfortable dealing with scientific questions to simply say, well, that's a scientific question, I don't need to go there, I don't need to review it. So I don't have any statistical evidence of that. I did do a statistical study earlier before the one that was referred to earlier, and was able to see a statistically significant effect from Chevron. I haven't done that with regard to Baltimore Gas and Electric, but just impressionistically, I don't think that, and I just was at a conference earlier this week among a number of scientists who were talking about some of the PFAS regulations, which are 100,000 times more stringent in the United States than they are in other countries around the world. I don't think judges are doing a very good job of really looking at scientific records and making informed decisions as to whether or not agencies have abused their authority. I think it's sufficient to simply clothe an agency conclusion in scientific terminology, which is what I call pseudoscience, and that will typically get you an affirmance. That's my perspective.
That's what happened in Whitman.
Yeah.
Well, I'm glad I finally fomented a disagreement, even of a limited nature.
You're good at that, Judge.
But I think, Don, your perspective is very much informed by your having worked in one of the agencies, the EPA, a scientific agency, probably the most sophisticated scientific agency we have, apart from the pure science agencies like NIH or something like that. And that gives you a window into the process that judges just don't have. And unfortunately, as you said, briefs don't bring it out. The one thing that ever really gives us insight into the internal process is if it's a collegial decision-making body and there's a dissent. That is very revealing. Not always successful by any means, usually not, but it gives a much better perspective on the internal workings of the agency.
Just if I could pick up on that, I think one of the differences, and you may have missed the keynote speech by Paul Ray.
I did, unfortunately.
But I think one of the differences between the review of discretionary decisions that takes place in the executive branch, and I was EPA's liaison to the Office of Information and Regulatory Affairs, or IRA, and participated in those discussions for the agency. The difference between that and arguing a case in the D.C. Circuit, which I've also done, I was a law clerk on the D.C. Circuit, is typically in these technical and highly controversial rulemaking cases, the court requires a lead brief and then allocates an hour for oral argument. Now, sometimes it expands it to 2 hours or 3 hours, but that results in a rulemaking case where there may be hundreds of issues that counsel have to prioritize the issues that they're going to highlight. And I think that issues of scientific review often get excluded from getting proper emphasis in oral argument or in the briefs, precisely because of this, I think, ill-conceived language from Baltimore Gas and Electric.
Interesting. Well, we have some time that we've tried to reserve and succeeded for questions from the audience. So despite the fact that there are bright lights in my eyes, Michael Griever shines even more bright.
I think that violates the Americans with Disabilities Act.
Yeah. Oh, whoa. Sorry about that. Mike Griever. This is not just to the 3 or 4 of you, but throughout the day I've been struck by this consensus that, you know, the remedy and to Chevron, whatever may be wrong with it, is let's have really, really hard look review, and maybe even State Farm is not enough. Maybe we should sort of park a flatbed truck outside the courthouse and say, Judge, you want to sort of look at the record and see whether we got this right. To what extent, I mean, throughout his career, in case after case after case, Steve Breyer always said, this strikes me as upside down. We're supposed to defer on questions of law, and then we're supposed to be really probing and nasty when it comes to questions of policy inferences, policy-making decisions, let alone raw facts, where the agencies have all the comparative advantages. Isn't that upside down? To what extent, that always made intuitive sense to me. What's wrong with that?
Oh, I'd like to respond to my good friend and colleague. I think that the proper realm for Chevron is where the law has run out, where Congress has delegated or hasn't thought about. I think the important part of Chevron is gap filling, interstitial lawmaking, and I think that the most controversial part of that is where there's an implied delegation. But you can call them questions of law, but the difficulty is there isn't any law on the subject. And so somebody's going to have to come in and fill that. And the way you can do that is you can either have judges and agency general counsels apply the canons and say there's only one best answer. Or you can do what we do under Chevron, and that is say to the agency, okay, tell us within the range of things that are permissible under the language of the statute, within the limits that Congress has set, what are the policy reasons for adopting one interpretation as opposed to another? And that can include statutory structure, statements of purposes, history, all sorts of things. But then as long as that's subject to review by the court and you have the input from the agency as well as review by the court, I just think that's a better way of doing it.
I think that's all that Stevens meant.
I think so too.
I think so when he dissents later, was it Cardozo-Fonseca? He says that, right?
Yeah,
it's a hard line, policy versus statutory interpretation, but that's the line we had drawn.
And I remember before he died, Justice Scalia told me that he frequently told Justice Stevens that even though he wrote Chevron, he didn't really understand it.
Well, he certainly expressed regret about it.
Can I
Various
add a comment to this? 'Cause I completely agree with Don's point. I was going to make it just, I don't think there's sometimes law, but sometimes what we say is law involves the policy. And so that's why it's not as simple as that. But I wanted to add another point to the second part. Why are they doing so? Why does everyone agree? First of all, I didn't know that a lot of folks agreed on doing more hard look reviews. So sort of welcome, because I've been thinking about this for a while, and I didn't really think there was a lot of folks on board with this. But so I want to defend it also because I've seen it be portrayed as also a form of judges getting the policy reason and pushing back at the agency when they don't agree. And I don't think that's the right way to look at hard look review or other. And I don't think it does that. And I could talk about this more. But one thing that I do want to just say for just everyone in the room, that arbitrary and capricious review is not about the judges finding certain facts like we think of that, in your question sort of implicit, why is that the thing? It's about whether the agency considered certain views and explained it. Okay, so we can there could be still disagreement about these views, but there's an explanation on the table that the agency has considered these aspects and made some kind of connection between the facts that they found and then what conclusion they drew, and that there is not a gap there. And I think that's important because that serves a transparency role, accountability role, and it also, that's the key thing that ties this potential for stability, because it will only survive to the next administration to the extent that it reflected that well, and others, observers, seeing the transparent reasons that an agency went a certain way, people could speak on that, and that could affect who the next president is, for example.
Another question from the audience. Sir. Oh, it's Tom. Oh, nice.
An issue that's come up in a number of panels, and I think Carolyn sort of alluded to this, is the change over time. We've got a lot of old statutes that are getting older all the time, and issues keep coming up that are not addressed by these statutes. The textualist movement has as one of its principal tenets that the statute should be interpreted in the way in which an ordinary reader would understand it at the time of enactment, okay? So there's some tension between textualism and the needs of society over time as reflected in new events and new issues that arise and so forth. One possible appeal of Chevron, I guess, is the opening line in Justice Stevens' paragraphs about the two-step he puts it in terms of the first question that the court needs to ask is whether Congress has spoken to the precise issue before us. So that suggests a very narrow realm of authority for the court in engaging in statutory interpretation, and a correspondingly large gap or space for the agency to make adjustments over time. And the adjustments over time can be influenced by the president, they can be influenced by the executive branch policies, but also by Congress. Congress interacts with agencies all the time and threatens them in various ways with appropriations, cutoffs, and so forth. So what does the panel think about how in a world in which statutes are increasingly aging and are not frequently amended by Congress, and in which courts are now committed, at least in principle, to interpreting the statutes in their original meaning, how does all that relate to the question before us about the proper role of Chevron deference and/or hard look review?
Tom?
Well, I think that it makes sense, it makes a certain degree of sense to say with regard to a constitutional provision that it has the meaning that the ratifiers would have understood it at the time, because as Justice Scalia pointed out, the ratification was really the act that created and made constitutional provisions, operationalized them. I don't agree that that necessarily should be carried over to statutes, particularly statutes in which Congress has set up a regulatory agency and delegated rulemaking powers to it. So I think it's really a category mistake to apply that version of textualism from constitutional situations to statutes and say, for example, that the Toxic Substance Control Act, which was enacted at a time when we all believed in the linear no threshold hypothesis. And now there's mechanistic evidence that scientifically it's incorrect because there's redundancy in your DNA, and I mean, I could go into all of this. So I think that when Congress, and whether or not this is actually what Congress intended, I think there should be a presumption that where Congress has set up an administrative agency and given it interpretive rights, including rulemaking, that it's perfectly legitimate for the agency to use them within the bounds, and where I'm kind of conservative is I think it has to be within the bounds of a plausible interpretation of the wording of the statute. I don't think agencies can go outside a plausible meaning of the statute, but within the plausible meanings of the statute, I don't think that the best meaning applying the standards of law that applied at the time the statute was enacted, or the dictionary that was in place in 1970 when the Clean Air Act was enacted, that were necessarily frozen to that.
Just then Judge Kavanaugh and I had a disagreement about this with regard to the longstanding regulatory prohibition of smoking on airplanes, commercial aircraft, which seemed to me to bear no relationship to vaping on airlines, which don't involve the smell, that don't involve a fire, and so on, and didn't exist when the prohibition was laid on smoking. It seemed to me appropriate for the agency to look at vaping and make a decision, but not to rely on a regulation that dealt with a phenomenon then not in existence.
Yeah, I would agree that the agency should be able to either include or exclude vaping, provided that it had reasons, policy reasons for doing so that passed judicial scrutiny.
Right. No, I agree. It didn't. It just looked at the point. We already prevented smoking. This is smoking. On the presumption of a linear relationship between dose and response below the threshold where we have any empirical data from the lives and deaths of mice or rats, I don't think there's anything in the statute that would preclude the agency from changing its view on that, is there? I mean, I think they could. They've got reason to believe now, of the sort you just alluded to, that would be a false assumption.
I agree.
Yeah, I mean, they need to have the flexibility to update their own rules based on this relevance.
Yeah, and I was, maybe that's not the best example. It was the first one that came to mind, but I was referring to that to essentially argue that I think that where Congress leaves these statutes in place over a long period of time, administered by agencies with rulemaking, they expect that the agency will use their rulemaking power to update the conclusions in the light of evolving science and other factors.
And subject to the verbal constraint that you just mentioned.
Right, and subject to the notion it's got to be within the permissible interpretation of the statute. But going back to Michael Greva's point, I think law is the ultra vires decision. You know, whether or not this is within the limits that have been delegated to the agency, and if it is, then I think that within those limits that have been delegated to the agency, including by statutory vagueness, I think that's really the issue, is statutory vagueness a delegation to the agency, and I think there's a good reason to say that it is, and if there is an implied delegation to the agency, it ought to be reviewed under an arbitrary and capricious standard, but the agency ought to have to explain and justify its exercise of policy discretion.
And I just wanted to add on to that, because I agree with everything that Jen Tiesbury and Don was saying, but you know, many statutes, it's not difficult to see that they build in some kind of dynamicism. Mm-hmm. And I don't know if we even need to just make an assumption that it does. It's very clear that Congress intended some kind of emerging threats to be also handled. Second is that if Congress did make the policy decision, then that is off the table. And so there could be narrow circumstances where maybe we think wrongly, but I would say we would have to be constrained by that. And then even if we don't think it's the right thing in light of today's, that might require a congressional change. And then I just want to bring in Justice Scalia's point that there's a scope to every ambiguity, there's a scope to a silence, and I don't think, I think Jonathan Mazur framed it really nicely about, options on the table, and that the amount of those options that are on the table might certainly change.
We have time for at least one, maybe more questions.
So I was given the mic. Hi, Susan Bodine. I actually do work with Don right now. So in the last panel, I think it was Eli Nachmani who suggested that we have deference to agency expertise, particularly with how to interpret a word, a word that has a particular meaning in a technical context, that may not be the dictionary meaning, but it had meaning in a technical context. And it was interesting because I was also at the PFAS risk seminar that Don was attending and spoke at. The scientists asked the legal panel, would it be helpful if the scientists created a lexicon of saying, well, when we see the word likely, this is what it means to us. When we see the word adverse, this is what it means to us. Yeah, when we see, so something that could have a totally different meaning in a risk assessment context, in a scientific context, than us generalists may think of. And I was curious as to what the panel would think of that. Again, if rather than in a textualist approach, go to the dictionary, instead go to, well, wait a minute, what does this mean to the people who actually use these words and implement them?
I'll answer that if no one else.
Just go ahead.
The problem you're identifying is just looking at the wrong dictionary. And you don't need to construct a dictionary for the purposes of a particular case involving a technical field, because the documents it's a common lingo for people on both sides of the issue. Those are the terms they use. I think it was a commercial boiler case I had a year or so ago, which was full of terms that were explained in the briefs and were not controversial between the parties. I mean, that's their job. They don't need to do more than that, I think, in order to make the record intelligible to a reviewing court. Same with the economists. I mean, the economists that disagree as expert witnesses use the same terms on both sides of the debate, and they understand each other, and their burden is to make it clear to the district judge what those terms mean, and there's not a problem, I don't think. 2 minutes, 2.5 minutes. Another question?
Or we get to drinks early.
Or a yes/no question. How's that? Okay, well, please join me in thanking our panel. It was a great discussion. Thank you.
So thank you so much. And just a few notes to end the day. First, in addition to all of the written work being done by these great panelists, Professor Adrian Vermeule from Harvard Law School and Professor Hamburger from Columbia will also be submitting essays in the symposium issue. So be on the lookout for that, to read it in full in a few months when it's published by our esteemed law review. And now head to the left down the hall to the Chinese room for a reception of drinks and hors d'oeuvres. We're so thankful that you chose to spend your Friday afternoon and morning with us, and have a great weekend.